Courtmaster, sir? Courtmaster, sir? I need to know what list will be taken first. List 1 or list 2?
List number 2.
All right, sir. Thank you.
Submission of day. Good morning. Yes, Gayatri.
Suspension matter, suspension matter, consideration of interim prayer.
Yavat suspend agide.
Suspension not issue the day before. It to be implemented. I find the tribunal has not granted interim.
Suspension agile inno.
Agile, but it has not been given effect. I am working on the basis of the interim order of status quo granted by the court in the writ petition.
Sorry, Monday happen. ಅದು ಯಾವ್ದು WP
ಫೈಲ್ ಅಲ್ಲಿ ಇದೆ
ಇದು ಅದು ಅದರ ಜೊತೆ ಕರಿಬೇಕು ಮತ್ತೆ ಹಾಕೊಡಿ ಕಾಲ್ ಅಲಂಗೇಟ್ ಮಾಡಿಕೊಳ್ರಿ ಅದು ಆ ಅದರ್ಶನ್ ಸುಳ್ಳಿದ್ರೆ ಮತ್ತೆ ನಾವು ಆಮೇಲೆ ಏನು ರಿಲೀಫ್ ಕೊಡೋದಷ್ಟಲ್ಲ ವಿ ಮೇ ಆಡ್ ಸಮಥಿಂಗ್ ಬ್ಯಾಡ್ ಆಲ್ಸೋ
ಇದೆ ಈ ಸ್ಟೇಟಸ್ ಕೋ ಇದೆ
ಅಲ್ಲಿ ಕೊಡಿ ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಹಾಕೊಡ್ರಿ ನೋಡಿ ಹಾ ಸರಿ
Suspension order not in the application not add then it is interim order.
Interim order itta?
Yeah, interim order is
Good.
Monday.
My lords, item 5, my lords.
5.
Yes, my lords. Can I request for 2nd of April, my lords, because there's a council appearing outside Bangalore.
Outside Bangalore, okay. 2nd of April. Ah,
Great.
We are allowing in terms of Justice Pratibha Singh's order in Delhi judgment. We have considered all points which you have argued. Okay? Okay. Because we drew some wisdom from section 64 capital A of Sale of Goods Act. Sale of Goods Act says, where taxes are varied, if it is increased, then the seller is entitled to add the tax to the value of the goods. If it is decreased, you are entitled to ask him to reduce the sale price. But there is no law relating to sale of goods ideyala. Ariti sale of services illa.
Services.
Namalli, except in one Tanzania, African country, where sale of services law is there. We are not referred to that in any way. In that way, in the above circumstances, this appeal succeeds and impugned order of the learned single judge is set aside. Appellants WP number so and so are allowed. A writ of mandamus issues directing the respondents of Western Railways to reimburse to the appellant all that amount which it has paid by way of service tax with 9% interest per annum from the date the amount became payable within 8 weeks. Delay, if proved, would carry additional interest at the rate of 1% per mensem, and the same may be recovered from the hearing officials.
My lords have considered Roman clause 16.
Yes, yes. Great. Well, not only 16. We have one more clause also. Because 16 you heavily banked upon, therefore we have reproduced that 16 itself. That in addition to that, we have reproduced another clause which you had not banked upon. That appeared little in your favor. That also we have considered.
Great.
Yes. We are referred to two judgments of Supreme Court also as to nature of service tax, who should pay, whose liability it is. We have referred to the 1944 Act also.
Hope my lords have reported it now.
We did not feel that is that of that quality.
Great.
Therefore, anyway, I'll just consider it.
Obligement.
Respondent, madam.
Your respondent, Elli Surana.
Respondent has filed the SLP before Supreme Court, madam, that is
Ah.
pending. madam. In SLP number 21514 of.
ನೀವು ಮಾತಾಡೋದು ನಮಗ್ ಕೇಳ್ಬೇಕು, ಹಿನ್ನೂರಿಗೆ ಕೇಳ್ಬೇಕು.
Yeah, respondent has challenged this honorable court before the Supreme Court. My lord,
The order to be complied with and a compliance report should be filed in the official respondents with the Registrar General of this court within an outer limit of 3 months, failing which stringent action may follow against the ring officials. Who are the officials? ಮತ್ತೆ ಇದ್ರ ಮೇಲೆ ಕಂಟೆಂಪ್ಟು, ಇದ್ರ ಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಷನ್, 20 ವರ್ಷ ಅದನ್ನೆಲ್ಲ ಮಾಡಲ್ಲ ನಾವು. ನಮ್ಮ ಆರ್ಡರ್ ಆಟೋಮೆಟಿಕ್ಲಿ ತಮ್ಮಷ್ಟಕ್ಕೆ ತಾವೇ ಕಂಪ್ಲೈ ಆಗ್ಬೇಕು.
matter is seized before Supreme Court.
ಸೀಸ್ಡ್ ಅಂದ್ರೆ ಅರ್ಥ ಏನು? ಸ್ಟೇ ಇದೆಯಾ?
Notice for.
ಸೀಸ್ಡ್ ಅಂದ್ರೆ ನಾವು ತಗೊಂಡು ಏನ್ ಮಾಡೋಣ? ಸೀಸ್ ಅಪ್ ಆಗ ನಿಮ್ ಸ್ಟೇ ಇದ್ರೆ ತೋರಿಸಿ ನಮ್ಗೆ. Who are your officials who should comply with?
Tahsildars and the
Tahsildars?
Tahsildar.
Ask them to be present before the court on Monday.
They have complained, my lord, RTCs were transferred in the name of State Forest. My lord. Chamundi.
Eh?
Chamundi Davis State Forest is shown in the RTC. They have not filed the complaints report.
Why is say, brother? Why have you? RFA. This is a Chamundi
Yes,
forest.
yes, yes.
Chamundi forest which we
Yes,
held.
yes, yes.
It's a government land. It's a forest land.
Yes.
ಯಾಕೆ ಇನ್ನೂ ಮಾಡಿಲ್ಲ?
They have already complained. my lord.
They have complained.
Officially, they have complained.
Compliance report ಹಾಕಿಲ್ಲ ಅಂತಾರೆ. So next, kindly after next week, my lord, will file compliance report.
Call
Tuesday, my lord.
call Tuesday
I saw.
for not reporting compliance by the forest and revenue officials. First off, the concerned Tahsildar and assistant commissioners of the jurisdictional area shall be personally present before the court. First off, some action may follow on the next date of hearing against them. After hearing, of course, after giving an opportunity of hearing. Okay. ಅದನ್ನ ಕಂಪ್ಲೈನ್ಸ್ ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ಮಾಡೋ ಅಗತ್ಯಿಲ್ಲ.
Also,
ಕೆಳಗಡೆ
if not.
personal presence shall not be may be dispensed with if complete compliance is vouched by documents. All right. ಎಲ್ಲ ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು ಬೇರೆಯವರಿಗೆಲ್ಲ ಕೊಟ್ಟು ಮೈಸೂರು ಫಾರೆಸ್ಟ್ ಇದು. Yes.
My lord, I feel for the,
Memo did say appellant not pressing of IA so and so.
it's a copy of the IA. What is the IA? I don't know.
Yeah, anyway, he's not pressing about that. Don't worry.
You do not push.
Argue the matter on merits. ಆಗಿದೆ.
Dispose of.
Dispose.
IA is disposed of as having not been pressed. ಏನಂತ ಲೆಟರ್ ಬಂದಿದೆ? ಚೆಕ್ ಕಳಿಸಿದಾರ?
My lord,
We are ready to accept the check.
in obedience to the direction of this honorable court,
Yes.
we have sent the check to the address as shown in the cast title.
But there was change in the address, my lord. So anyway, as of now, the director is present in the director of the
No.
company is present, my lord.
Very
Let them hand over the check here.
ಚೆಕ್ ವಾಪಸ್ ಬಂದಿದೆಯಾ?
ವಾಪಸ್ ಬಂದಿದೆ ಕವರ್ along with the cover we have produced
All right.
court.
ತೆಗಿರಿ, ಓಪನ್ ಮಾಡಿ ನೋಡೋಣ ಚೆಕ್ ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ ತಗೊಳ್ಳಿ. ಎಷ್ಟು ದಿವಸ ಚೆಕ್ 6 months ಅಷ್ಟ ವ್ಯಾಲಿಡಿಟಿ ಏನೋ
ಹೌದು ಅದಕ್ಕಾಗಿ
ಅದಕ್ಕೆ ಈಗ 3 months ಲೋಕಲ್ ಇತ್ತು.
ಅದು ಬರಂಗಿಲ್ಲ.
ಅದನ್ನ ವ್ಯಾಲಿಡೇಟ್ ಮಾಡಿ ಕೊಡಿ ಇವತ್ತು. ವ್ಯಾಲಿಡೇಟ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು. ತೆಗಿರಿ, ಓಪನ್ ಮಾಡಿ.
Because we have no authority to open the cover.
We will open it now.
ಅದಕ್ಕೆ.
ಚೆಕ್ ಹಾಳಾಗದಂಗೆ ನಿಧಾನವಾಗಿ ಅವ್ರು ಹೆಂಗ್ ಬೇಕಂಗೆ ಅಂಟು ಹಚ್ಚಿರ್ತಾರೆ. ಬಹಳ ಮೈಂಡ್ಲೆಸ್ಲಿ ಸರಿಯಾಗಿ ತೆಗಿಬೇಕು. ಇದ್ರ ಮೇಲೆ ಒಂದು ಕಂಟೆಂಪ್ಟು, ಅದು ಒಂದು 5 ವರ್ಷ ರಿಲೀಫ್ ಸಿಗೋದಿಲ್ಲ ಲಿಟಿಗಂಟ್ಗೆ. May 24. 14/8/24 ಚೆಕ್ ನೀವು ವಾಪಸ್ ತೊಗೊಂಬಿಡಿ. ಅವ್ರಿಗೆ ಮಧ್ಯಾಹ್ನಲ್ಲಿ ಮಾಪ್ಸಿಗೆ ಹೋಗ್ತಾರೆ. ಟೆಲ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಟು ಗಿವ್ ಅನದರ್ ಚೆಕ್ ಇನ್ ಲಿeu ಆಫ್ ದಿಸ್.
ಒಂದು ವಾರ. Because ನಾಳೆ ಸೆಕೆಂಡ್ ಸ್ಯಾಟರ್ಡೆ ಪ್ರೊಸೆಸ್ ಎಲ್ಲ ಇದನ್ನ ರಿಟರ್ನ್ ಪ್ರೊಸೆಸ್ ಆಗ್ಬೇಕು. ಅದಕ್ಕಾಗಿ ಒಂದು ವಾರ
ಇನ್ನೊಂದು ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಮುಗಿತು.
ಫ್ರೆಶ್ ಇಶ್ಯೂ ಫ್ರೆಶ್ ಮಾಡ್ಬೇಕು.
ಮಂಡೇ ಮಾಡ್ಬೇಕದ್ನ ಬರ್ಕೊಳ್ಳಿ. The KSFC wide letter dated 14/8/2024 accompanied by a Canara Bank check evenly dated for a sum of rupees 13,05,594 claims to have complied with the direction of this court, in as much as the same were sent to the respondent, to the petitioner, alva?
Respondent
Petitioner.
respondent in the writ appeal. There is
Therefore,
a order.
petitioner, that is the respondent herein. First off. However, the envelope was not served on the said respondent. First, comma, postal shara stating inwards nalli no such person. Now, the managing director of the respondent, Mr. Director of respondent company, Mr. So and so is personally present before the court. First off, the postal envelope having been opened, the letter and the check, which has now time barred, are handed to the respondent, to the KSFC, counsel for the KSFC. Receipt whereof he acknowledges. Third, or kayal kodi. First off, he undertakes that a fresh check duly drawn for the amount in question shall be handed to the director of respondent company, Mr. So and so, on Monday, Tuesday.
It has to be approved by the MD.
We do not know all that. Tuesday. First off, if the same is not handed, comma, the managing director of the KSFC shall be personally present before the court on Wednesday, Wednesday, date Wednesday, to explain why action should not be taken. Full stop. This order has to be complied with by doing all needful action. Yes. Call on Wednesday. Yes. Yeah. 3. ಏನಿದು non-filing of the compliance report. What is this report? What is-
For number 2 and 3, my lord, have forwarded the proposal to the first respondent. And first respondent is sleeping over the file, my lord. January 20th is
Who
the
is first respondent?
The principal secretary.
principal
of the
secretary higher education.
Higher Education Department. I've communicated to the concerned officer, my lord. She said she will get the information to me.
At 1:30, it should happen.
Please,
1:30,
please.
call
Please.
this matter at 1:25 for reporting compliance. Failing which, some stringent order may be passed against the principal secretary, your department,
Higher Education, my lord.
higher education. First stop. The government advocate shall communicate this order to the said secretary immediately, and also apprise him, her, apprise her of likely action. Call this matter at 1:20 PM today. Yes. Why are you not complying with the court orders? Why? What is the reason?
I'll find out, my lord. I
Fine,
received the
direct.
file for
Ask her
I'll
to
find
be
out.
present before the principal secretary shall be present before the court at 1:20.
Joint director and the commissioner have forwarded way back.
Don't play with the courts. Our powers are enormous,
I'll caution the officer.
simply enormous. Okay?
Please,
Tell her,
I will.
tell her. Show this video clip to her. You can't go on playing with the citizen. Successful ಆದ್ಮೇಲೆ ಮತ್ತೆ ಅದು ಕಂಪ್ಲೇಂಟ್, ಅದ್ರ ಮೇಲೆ ಒಂದು ಅಪೀಲ್, ಅದ್ರ ಮೇಲೆ ಒಂದು ನಾನು ಬ್ರೇನ್ ಇದನ್ನ ಮಾಡ್ಕೊತ ಕೊಡ್ಬೇಕೆ ಜನ ಎಲ್ಲ. All second rate. Yes.
My lords, kind leave. My lords, the respondent number 3, my lords, has filed an application for vacating the interim order, my lords. I'm praying for a short accommodation, my lords, to file my objection. The application was served
When it
yesterday.
was served?
It was served yesterday, my lords.
Next week.
ನಾನು ಏನು ಹೇಳೋದಿಲ್ಲ.
ಅಲ್ಲ next week.
ಅಲ್ಲ
Call.
ನಾವು ನಿನ್ನೆ ಕೊಟ್ರೆ ಮತ್ತೆ ಅವರಿಗೆ ಐ ಆಲ್ಸೋ ಕಾಂಟ್ ಒಬ್ಜೆಕ್ಟ್ ಮಾಡೋದು. ಇಟ್ಸ್ ನಾಟ್ ಫೇರ್ ಆನ್ ಮೈ ಪಾರ್ಟ್.
That's what yesterday. Call. Wednesday?
Would it be third?
ಎಲ್ಲಿಂದ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನಂತ ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು ಅಬ್ಜೆಕ್ಷನ್ಸ್?
Party, my lords.
ಎಲ್ಲಿ ಪಾರ್ಟಿಯಲ್ಲಿ?
The party, my lords, is in Bangarpet, my lords. But certain
Bangarpet.
developments have taken place after the stay has been granted, my lords. So the trial has place on record.
ಬುಧವಾರ ದಿವಸ
Please. Very good.
ಕಾಲ್ ಆನ್ Wednesday.
Would it be Thursday, my lords, instead?
Thursday. Thursday ರಜೆ ಅಲ್ಲ?
ಶುಕ್ರವಾರ.
ಸಾರಿ.
ಅದಕ್ಕೆ ನೀವು ಹೋಳಿ ಆಡಲ್ಲನು?
ಇಲ್ಲ. Lord, what has happened is my brother-in-law's son is getting married in US. ನಾನು ವೀಸಾ ಎಲ್ಲಿ ಮಾಡ್ಲಿಲ್ಲ, ಎಲ್ಲಿ ಯಾರು ಹೋಗೋದು ಅಂತ ಹೇಳಿ. ಅದು ಈಗ ಅದೇನೋ ಅಲ್ಲಿ ಹೈದರಾಬಾದ್ ಅಲ್ಲಿ 2 ದಿವಸ ಅದೇನೋ ಅದು ಒಳ್ಳೆ nuisance. ಹಾಗಾಗಿ
ಮೇಲೆ ಹಾಕೊಂಡು
ಅಲ್ಲ
ಈ ಹೋಳಿ ಮೇಲೆ ಒಂದು ಬಹಳ ಒಳ್ಳೆ ಒಂದು ಗಜಲ್ ಇದೆ. ರಂಗ ಮತಡಾಲೋ ಶ್ಯಾಮಜಿ ಅಂತ ಭಾವೇ ಚಂದ ಹೇಳಿದಾರ ಒಂದ್ಸರಿ ನೋಡಿ. ಹೋಳಿ ಇದ್ರ ಮೇಲೆನೆ ರಂಗ ಮತಡಾಲೋ ಶ್ಯಾಮಜಿ. ಎಸ್.
ಇಲ್ಲ, ವೆಡ್ನೆಸ್ಡೇ ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ.
ಇರ್ಬೋದಾ?
ಥರ್ಸ್ಡೇ ಆಯ್ತು, ವೆಡ್ನೆಸ್ಡೇ ಮೀಟಿಂಗ್ ಪರವಾಗಿಲ್ಲ.
ಬೇಕಾ ಫ್ರೈಡೇ ಇಟ್ಕೊಂಡು?
ಇಲ್ಲ, ನಾನು ವೆಡ್ನೆಸ್ಡೇ ಇದ್ದೀನಿ.
ವೆಡ್ನೆಸ್ಡೇ ಇದ್ದೀರಾ?
ವೆಡ್ನೆಸ್ಡೇ.
ಮತ್ತೆ ಅಲ್ಲೇ ಆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಕುತ್ಕೊಂಡ್ಬಿಟ್ರಿ ನೀವು. All right, Wednesday.
Would I request for Friday, my lords, instead of Wednesday?
Friday? ಅಲ್ಲ ಅವ್ರು ಇರಲ್ಲ, ಅವ್ರು ಟ್ರಾವೆಲ್ ಮಾಡ್ಬೇಕು.
Would I request for Monday,
to
the next
prepare.
Monday, my lords?
Huh?
Next Monday after that.
ಬೇಡ, ಫ್ರೈಡೇ ಆದ್ರೆ ಫ್ರೈಡೇ ಆಯ್ತು, ನಾನು ಬರ್ತೀನಿ.
ಫ್ರೈಡೇ ಬರ್ತೀರಾ? ಮತ್ತೆ ನೀವು ಟ್ರಾವೆಲಿಂಗ್ ಮಾಡ್ಬೇಕು ಅಂತಿರಲ್ಲ?
ಏನಿಲ್ಲ.
ಆಲ್ ಫ್ರೈಡೇ.
Interim order may kindly be extended.
Entry order to continue.
Grateful to my lords.
Sorry. Yes. ಹಾ
For the respondent. We have
Yes.
we have become wiser now. But I'll make one submission which is, my lord, which revolves the entire gamut of the issue. Now, this agreement, which we have entered into, some portions of the joint development agreement are incorporated. There is no doubt about it.
Correct.
And under this very same agreement, there is a clause number 7, which says, if there is an award or a judgment against CVPL, I am bound to obey it. And there are other clauses also which specifically say that till the pyramidal finance loan is cleared, immediately thereafter, whatever revenue sharing has to take place under the joint development agreement, I have to. My submission is, this agreement is a complete answer to all their grievances. I need not be made parties. I am bound by this. Yesterday, Your Lordship wanted to know whether I am, but even on the first principle, the agreement specifically says, number one, I am bound by the joint development agreement to a certain extent, about 10% of regarding conversion of the land, building plan, etc., it is for the CVPL. So far as I am concerned, revenue sharing, and also, my lord, my
Question is not only that. It is a doctrine of group of companies, new doctrine, which Apex Court has invented. If your case fits into that doctrine, then this court has no discretion in saying, no, he should not be made a party by banking upon certain clauses of the agreement.
If they say that my participation will enlarge my responsibility under this agreement, beyond this agreement, I have no case. If they say that my entire responsibility flows from this agreement and ends with this agreement, then I need not be party. The reason is this.
No.
The reason is,
Even
if there is a 1 rupee award against me, there will be separate appeal, multiplicity of the proceeding. I am taking the risk. That the reason is, under class 7, I cannot challenge the award because I am bound by the award. Second one is, there will be multiplicity of the process. This document, four corners, it completely fixes my responsibility. If it is the case of the respondents, that my responsibility will be enlarged by my participation in the arbitration proceedings, let them make the submission.
Let us see what they say.
This is a complete answer to all their grievances. Otherwise, my lord, me entering would be like a bull entering the China shop. My lord, all the rights of CVPL I'll take over. I may make the counterclaim. I may even question this document on the ground of fraud, misrepresentation.
So in other words, you undertake to abide by the award to be passed in the said proceedings as if you are a party.
Correct.
Though you want to be outside.
Yes. Otherwise, it is like, as I said, a bull entering the China shop. There will be a full massacre.
But that's not the question before your lordships. The question really is as to who is the party to the contract. That's the question, my lord, which has been addressed by the learned arbitral tribunal. And that's the question that has fairly fallen for consideration in Cox and Keynes. I will address your lordships, my lord, on both the merits of the case and on the principle of Cox and Keynes. But there is one important aspect that I want to point out to your lordships, my lord, on how far should this honorable court interfere with an order that is passed by the arbitral tribunal, considering, my lord, that the principle of arbitration is
to exclude judicial process.
To exclude judicial review. Second, party autonomy. And in fact, my lord, I'll point out to your lordships cases which have been decided by the Honorable Supreme Court, which say that under Article 226, this court should not interfere. Because that's setting a bad precedent, my lord.
We understand that
Yes.
also. Now he is saying, we will consider
Why not?
this. He is saying, I will abide by the award to be passed.
That is the reason why he should be a party, because tomorrow when I want to execute it, I don't want to be told that he is not a party against whom an award has been passed.
We will make an order.
My lord, even then, my lord,
Class 7, I'm sorry, class 7.
even that's, my lord, clause 7 is all right, my lord, I've seen that.
Adjudication of it.
I don't want that situation. He should be present. Let there be an order. Let it be heard. In fact, my lord, I don't understand why they want to shy away. If they say we are willing to abide by the terms of the award, it's good for them to be participant. And I am willing to face not one opponent. I am willing to face two opponents. What is the grievance that is caused which should persuade this honorable court, my lord, to interfere in an extraordinary jurisdiction in Article 226? And that's exactly what the Supreme Court has said, my lord. So please let me place that point for your lordship's consideration. I have 2 points to urge for your lordship's consideration. First, my lord, that once an arbitral tribunal has passed an award of this kind having regard to the provisions of the Arbitration Act and the self-imposed rule that
Court will not interfere.
Court will not interfere.
Next
I am not for a moment saying, my lord, that the petition is not entertainable.
Next point.
That's one point, my lord. The second point is there is a veritable interest. And in terms of the order of the Honorable Supreme Court in Cox and Kings, I will show to your lordships, my lord, passages from Cox and Kings which are squarely against the proposition that has been canvassed by my learned friend. And if therefore that principle is applied, then the order passed by the learned arbitral tribunal is right. So this is going to be my approach. So if your lordships will permit me, my lord, let me just formulate the propositions that I want to place for your lordships, my lord.
Perfect.
The first proposition, my lord, is that an arbitration is a consensual one. The second proposition, my lord, is that an arbitration can commence or be proceeded with against a party who is not a signatory to the arbitration agreement. Proposition number 2. Proposition number 3.
Because of doctrine of group of companies.
No, my lord.
Even other way.
No, my lord. I will develop that, my lord. Merely because there is a doctrine called the doctrine of group of companies that does not entitle a non-signatory to be made a party to the arbitration agreement. That was the law when the Honorable Supreme Court decided chloro control. But chloro control has now been watered down by the Honorable Supreme Court in Cox and Kings. Cox and Kings tells your lordships that it's not enough if it is a group of companies doctrine.
That's a precondition.
It is. I have, my lord, I have one additional submission to make. If there is consent, which, my lord, is the fundamental basis on which arbitration can proceed, because according to me, my lord, arbitration is 100% consensual. Nobody can compel a party to go to arbitration. Therefore, the question really, my lord, is whether a non-signatory has consented to be a part of the arbitration. That's the question.
First, from material on record.
I told you material on record. So can I first put the first proposition? How far should the court interfere? And I want to show you.
May not be. May not be. If you want to argue, argue, but may not be. We humbly believe we are updated on that. We very humbly believe this. But still, if you want to argue, it is open to you to argue.
Your lordships
Many youngsters will be benefited.
Your lordships are disarming me.
Generally, we don't have other business than reading. We have no other business.
That I know.
Really.
That
Very humbly.
The more time of course, I'm conscious that your lordship's time is public time. But the more time I take of your lordship's, I believe that I will be enriched and my colleagues also will be enriched.
Very.
That's all. My lord, for the purpose of brevity, what I have done, my lord, because I owe a duty to the court to save your lordship's time, which is valuable, I understand, my lord. I have prepared a note. So can I
Please
have your permission to pass it on?
But you?
Of course, and we have to read to your lordships the order passed by the learned arbitral tribunal. Every of the 5 factors
they have addressed
mentioned in Cox and Kings has been considered. In fact, their lordships, their learned arbitrators have put it, my lord, point number 1, point number 2, point number 3, and then discuss the material available and record to come to the conclusion that every one of the factors mentioned in Cox and Kings have been satisfied.
So those are notes on submissions. We've also extracted the relevant paragraphs of that.
Share it with Mr. Basuraj.
Yes. But may I take your lordships to the 5th page of the submissions?
Yes.
The arbitral tribunal is the appropriate forum to determine its own jurisdiction under Section 6 of the Arbitration and Conciliation Act, under Section 16 of the Arbitration and Conciliation Act, that the principal, my lord, is competence. Question of parties to an arbitration is a jurisdictional question, personal jurisdiction, that goes to the very root of the arbitral tribunal's power under section 16 of the Arbitration Act. Please look at section 16 of the Arbitration Act for a minute, my lord.
But
Arbitral tribunal, you also have it, my lord.
yes,
Arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement. And
that
for-
purpose.
And for that purpose, an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract, and a decision by the arbitral tribunal that the contract is null and void shall not ipso jure invalid, it shall not entail ipso jure the invalidity of the arbitration clause. So therefore, my lord, the arbitral tribunal on the principle of competence, which was a concept that was introduced into the arbitration law for the first time in the 1996 Act on the basis of the UNCITRAL model law, clearly gave jurisdiction to the arbitral tribunal to decide on the question whether there is in existence an arbitration agreement. Now, my lord, once an objection is taken before the arbitral tribunal that there is no arbitration agreement, which is the contention that is now being advanced by the other side, what is it that the arbitral tribunal can do? The arbitral tribunal can do one of three things. One, my lord, is for the arbitral tribunal to say, well, I think there is no arbitration agreement. That's the end of the arbitration so far as the party is concerned. Second is to say, there is an arbitration agreement. Arbitration will proceed. The third is for the arbitral tribunal to say, I will not decide it now. I will decide it along with the merits of the case when I do the final hearing. Now, in the instant case, the arbitral tribunal has adopted the second course. The arbitral tribunal has found on the facts and a detailed analysis, my lord, that the proposed party is a party to the arbitration agreement. Now, in a situation of that kind, what is the remedy available? Is the petitioner before your lordships remediless? The answer is no. The answer is found in subsection 6 of section 16. This has a material bearing in my humble submission to answer the question as to whether your lordships should entertain a writ petition. I am not on the
So
question of
section
entertain-
34 is available.
Exactly.
Even against such a finding.
Even if there is such a finding, they can always go back if an award is passed against them, assuming, my lord, that on merits I succeed in the arbitration, and the arbitral tribunal comes to the conclusion that they are also liable, they are not remediless. They can go and tell the section 34 court, sorry, I am not a party to the arbitration, and therefore the arbitral tribunal was wrong in either impleading me, making me a party, or imposing a liability upon me. Now, my lord, this very point has come up for consideration in several judgments before the Honorable Supreme Court. So, my lord, as I said, my lord, I'm not on the question of maintainability, my lord, I'm on the question of entertainability, because the point in law, my lord, is that every writ petition is maintainable. Every writ petition is maintainable. Judicial review is unlimited. But the question is, would your lordships interfere? Would your lordships entertain? Is the question. Okay. Now, my lord, please look at my note. And on this, my lord, I want to take your lordship through a few paragraphs of Cox and Kings and also a few other judgments, which directly have a bearing on the point I'm now placing for your lordship's consideration.
But
Is extracted?
so your friends can go for a coffee round now.
Yes, but I think it's a little too early. 11 ಗಂಟೆ ಇನ್ನು ಈಗ ತಾನೇ ಬಂದಿರ್ತಾರೆ ಕಾಫಿ ಕೊಡ್ಕೊಂಡು.
ಅಲ್ಲ ಆದ್ರೂ ಸ್ವಲ್ಪ ಲಾಂಗ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ರೆ ಕಾಫಿ ಬೇಕು ಅನಿಸ್ತಿರ್ತದೆ. ನಮ್ಗೆ ಆ ಲಿಬರ್ಟಿ ಇಲ್ಲ, ಆ ಕಡೆಯವ್ರಿಗಿದೆ. Anyway.
That privilege of going for a coffee, your lordships voluntarily relinquished.
There's a kind of unknowledgeable volunteer.
In tort law, my lord, there is a concept called voluntary non-fit injury. My lord, if your lordship will take, my lord.
Yes.
In fact, these notes that I have given on judgments will give your lordships everything. I don't have to do anything more. I'll just read this and place it for your lordship's consideration. Kindly see SBP Engineering, SBP versus Patel Engineering, it is seen that some high courts,
ನಿಮ್ಮ ನೋಟ್ನಲ್ಲಿ ಎಲ್ಲಿದೆ ಓದ್ಬಿಡಿ.
not page number 1 ತಗೊಂಡು. Oh, your lordships are looking at my submissions or the case law submissions?
ನಿಮ್ಮ ಇದ್ರಲ್ಲಿ ನೋಟ್ಸ್
Yes, my lord. Please be kind enough to turn to page 5.
ಅಲ್ಲ ಕೇಸ್ ಲಾ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಲ್ಲ,
Yes, my lord.
ಪ್ರಪೋಸಿಷನ್ಸ್
First page,
ಹಾಕಿದೆ.
page number 1.
ಎಸ್ SBP.
SBP.
Okay.
It is seen
Seen
that
that
some high courts have proceeded on the basis that any order passed by an arbitral tribunal during arbitration would be capable of being challenged under Article 226 or 227 of the Constitution. We see no warrant for such an approach. Section 37 makes certain orders of the arbitral tribunal appealable. Under Section 34, aggrieved party has an avenue for ventilating its grievances against the award, including any in-between orders that might have been passed by the arbitral tribunal acting under Section 16 of the Act. The party aggrieved by an order of the arbitral tribunal, unless has a right of appeal under Section 37 of the Act, has to wait until the award is passed by the tribunal.
So we disapprove of the stand adopted by some high court.
Exactly.
Last.
Exactly.
Next point.
Your lordship got that, my lord.
Yes.
Then, my lord, kindly turn to next page, para 46. What your lordship just now mentioned. The object of minimizing judicial intervention, while the matter is in the process of being arbitrated upon, will certainly be defeated if the High Court would be approached under Article 227 or under Article 220 of the Constitution against every order made by the arbitral tribunal. Therefore, it is necessary to indicate that once the arbitration has commenced in the arbitral tribunal, parties have to wait until the award is pronounced, unless, of course, a right of appeal is available to them under Section 37 of the Act, even at an earlier stage, which is not so in this case.
Okay.
Then, my lord, kindly see the next judgment in deep industries. This being the case, there is no doubt whatsoever that if petitions were to be filed under Article 226 and 227 of the Constitution against orders passed in appeals under Section 37, the entire arbitral process would be derailed and would not come to fruition for many years. At the same time, we cannot forget that 227 is a constitutional provision which
So
is
extremely circumspect.
extremely circumspect. In these circumstances, what is important to note is that though the petitions can be filed under 227 against judgments allowing or dismissing first appeals under 37, yet the High Court will be extremely circumspect in interfering with the same, taking into account the statutory policy as adumbrated by us herein above, so that interference is restricted to orders that are passed which are patently lacking in inherent jurisdiction. Obviously, this is not inherent jurisdiction because Section 16 gives the power to the arbitral tribunal. And now, my lord, kindly see.
If
Another
16(6) order is made, then they have to wait till award.
Till the award.
Next point.
My lord, kindly see the last sentence at page number 3, if your lordships are kind enough. Even otherwise, entering into the general thickets of disputes between the parties does not behove a court exercising jurisdiction under Article 227, where only jurisdictional errors can be corrected. The Honorable Writ Court ought to be extremely circumspect in exercising its jurisdiction over orders of an arbitral tribunal and should only do so in cases of exceptional rarity. Then, my lord, please be kind enough to turn to Bhavan Construction. My lord,
Page 8.
my lord, I have my learned friend, my
The
lord, rightly
contractor, his directors on holiday.
my lord,
that
my
one?
learned friend rightly requests me
Yeah.
place for your lordship's consideration,
Yeah.
middle of para 22 at page 3. So would your lordships be kind enough to permit me to do that? Kindly turn to line number 4 in para 22 at page 3 of my note. The drill of Section 16 of the Act is that where Section 16 application is dismissed, no appeal is provided. And the challenge to Section 16 application being dismissed must await the final passing of an award at the stage.
But 16(6) provides for appeal.
Exactly. 16(6) doesn't provide for an appeal. It says you can take this as a ground in 34.
That's all.
37 is the appeal.
Okay, it is like order 43, rule 1, capital A.
Absolutely.
On par with that.
Absolutely. Philosophy, my lord, that is why the philosophy of the Arbitration Act is Section 5. Do not permit judicial intervention. I ask myself, what is it that has happened to the petitioner to now knock at your lordship's doors? What is the grave injustice that has been caused? If the award is against them,
All. Understood.
well, then, my lord, please be kind enough to turn to item number 3 at page number 4, Bhavan Construction. In the instant case, respondent number 1 has not been able to show exceptional circumstances or bad faith on the part of the appellant to invoke remedy under Article 227 of the Constitution No doubt the ambit of 227 is broad and pervasive. However, the High Court should not have used its inherent power to interject the arbitral process at this stage. It is brought to our notice that subsequent to the impugned order of the sole arbitrator, a final award was passed, etc., etc. Then, my lord, we don't have to, I don't want to trouble your lordship with the rest of the paragraphs. Please be kind enough to turn to the next one at page, seal number 4, page number 6.
Yes.
In fact, my lord, sorry, my lord, kindly turn to page number 5 at the bottom of that page, para 27 in Bhavan. In view of the above reasoning, we are of the considered opinion that the High Court erred in utilizing the discretionary power available under Article 226 and 227 of the Constitution herein. Thus, the appeal is allowed and the impugned order of the High Court is set aside. There shall be no order, etc., etc.
Yes.
Then kindly see the next last sentence, my lord.
Yeah.
There shall be no order as to cause. Before we part, we make it clear.
They can take up all.
Exactly. That is a complete answer
Yes.
to my learned friend's contention that he should not be implemented in arbitration. Then, my lord, please be kind enough to turn to serial number 4, Punjab State. We are of the view that a foray to writ court from a section 16 application being dismissed by the arbitrator can only be if the order passes so perverse that only possible conclusion is that there is a patent lack of inherent jurisdiction. A patent lack of inherent jurisdiction requires no argument whatsoever. It must be perversity of the order that must stare one in the face.
Yes.
At the moment one sees it, the court's conscience should be shocked. That's how it is, my lord. That's the threshold, the high threshold that is required to be crossed before a writ court can be called upon to interfere.
Yes.
Then, my lord, now, my lord, these are the judgments I want to place for your lordship's consideration to say that this on
Non-interference in writ jurisdiction.
this is.
Ah.
Now, my lord, what about on merits? Now, my lord, kindly look at a few paragraphs in Cox and Kings, the judgment on which my learned friend relied upon, which in fact support the case of the respondent more than it does. General principles of law stated in Cox and Kings are now well entrenched. First, mere group of company doctrine does not mean that all the companies in the group are liable. No, my lord, I'm not saying that at all. Today, the position in law is that
Conclusion, performance, termination. These
All
are the
that-
three
yes,
first essentials.
all that is to determine whether there is consent. So, my lord, the formation, performance, or in a given case, if there is termination, in our case, there is no termination. So, therefore, formation and performance should lead to a conclusion that there is consent
And Apex Court has used the word or
or
is used,
is used.
which yesterday Basuraj read.
Yes, ma'am.
So that guarantee, contract of guarantee goes to performance itself,
It goes to
assured performance.
Yes.
if it
And
is.
then, my lord, in fact, the contract of guarantee, which was read, supports our case. My lord, the whole intent is to make sure that MDPL is bound by the terms of the contract that I have entered into with CVPL. For that purpose, multiple layers of agreements are entered into. All that only in one direction, that the obligations have to be performed by MDPL. They are not contradictory or cutting into each other. In fact, they are complementary to each other. They are not contradictory to each other. So if your lordship use it this way, my lord, then there are multiple agreements. For example, my lord, we have come across cases.
Even contract of guarantee refers to JDA itself.
JDA itself.
Maybe there is curtailment or limitation of liability.
That's a matter of
etc. It's
merits.
Another thing, merits on merits.
In fact, my lord, here, MDPL can be said to be wearing two hats. One is as a party. Now, if I fail as a party, you will be liable as a guarantor. So, MDPL, therefore, is wearing two hats. When you wear your hat as a guarantor, maybe there is a restriction on your liability. But when I'm looking at you as wearing the hat of a party, your liability is coterminous with whatever has been said in the JDA. So, looked at, therefore, my lord, and parties enter into all these commercial transactions, they want to put layers and layers so that, my lord, MDPL does not in any manner escape from liability. For example, my lord, I'll give you lordship an example. We have a number of cases where in a JDA, permission or authorization is given to a developer to enter upon the property for the purpose of development. And it also says, you are the one who is to get the plan sanctioned. You are the one to get all the permissions from various authorities. In addition to it, there is also a power of attorney that is executed, which is a common practice. Then I ask myself, why was a power of attorney executed? Does the creation of a principal agency relationship cutting into your obligation as a party? No, it doesn't cut into the obligation. It in fact supplements the obligations. That is how, my lord, that guarantee document has to be read. Not, my lord, to say, oh, my liability is limited to what is mentioned in the guarantee, and therefore whatever is there, I will be liable later on. You are liable as a party. Now, my lord, therefore, your lordships may look at a few paragraphs, my lord, in Cox and Kings, which will be very relevant for your lordship's kind consideration. But I may trouble your lordship to kindly see paragraph number 70. My lord, in fact, please don't even trouble your lordship to look at the judgment, my lord. We have extracted everything. So that I save your lordship's valuable time. Please see page 8. May I read it, my lord? And wherever your lordships have already seen it, my lord, if your lord tells me, my lord, I'll stop.
Page
8.
ಅಲ್ಲಿ ರೋಮನ್ ಪೇಜ್ ಸ್ವಲ್ಪ ಏನೋ ಬೇರೆ ಬೇರೆ ನಮ್ಗೆ ಇದರಲ್ಲ
ಇಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ ಫಾರ್ ಪರ್ಪಸಸ್ ಆಫ್ ರೆಕಾರ್ಡ್ ಬಟ್
ಗುಡ್
ಈಸ್ ಆಲ್ರೆಡಿ ಗಿವನ್
ಇದು ಕಾಕ್ಸ್
ಕೊಟ್ಟಿದ್ದಾರೆ ಕಾಕ್ಸ್ ಅಂಡ್ ಕಿಂಗ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ
ಇನ್ಫ್ಯಾಕ್ಟ್ ಹಿ ಹೆವಿಲಿ
Yes.
on that judgment.
Parties to the agreement. The general method to figure out the parties to an arbitration agreement is to look to the
ಯಾವ notes ನಲ್ಲಿ ಯಾವ page?
page 8.
Roman page.
Page 8, my lord. Serial number 6.
Page 8.
ಮೇಲೆ 8 ಅಂತ ಮೇಲೆ ಬರ್ತಿದೆ.
The judgment extracts.
In the judgment extracts.
Okay, paragraph 8, huh?
Yeah, no, my lord. Page 8, serial number 6. 5-factor test for determining whether a non-signatory is a party to an arbitration agreement. That's the heading. My lord, got it?
Party to a signatory and arbitration agreement.
Yes, my lord. Parties to arbitration.
So 5-factor test.
Yes.
Our Roman 25 adu.
My lord, may use the extracts that were initially being referred to. It has everything in it.
It's a seriatim.
All of it has been put, my lord, so that your lordships are not even troubled to.
Okay.
My lord, got it, man?
Yes.
May I read that portion? Your lordship got it. The general method to figure out the parties to an arbitration agreement is to look for the entities who are named in the recitals and have signed the agreement. I'm sorry, my lord, your lordship didn't get it.
No, got it. Para 122.
Para 70, my lords may have.
The general position of law is that party will be referred to arbitration.
My lord, para 70, 770. My lord, in this note that I gave to your lordships on the extract from the case law, morning, just now, your lordship gets everything.
In this one, okay.
Yes, my lord. For ease, we have extracted the paragraphs themselves. Page 8.
Page 8.
Para 70.
Therefore, mutual intent.
No, my lord, I'm sorry, my lord. The 5-factor test anta heading hakidivi. Yeah, kindly take it on.
5-factor test ಇದರಲ್ಲೇ ಇದೆ.
Give them the briefing note.
ಇಷ್ಟೊಂದು ನೋಟ್ಸ್ ಕೊಟ್ಟರೆ ನಾವು ಯಾವ್ದು ಹೆಂಗೆ ನಾವು?
ಇಲ್ಲ, ಎರಡೇ ನೋಟ್ಸ್ ಕೊಡೋದು. ಒಂದು with the list of dates and as part of it, and next one, my lord, we have given you
Parties to arbitration. Para 70.
Yes, my lord. Yes,
70.
yes, my lord. That's the one. Your lordship.
Yes.
May I proceed, my lord?
Yes.
The general method to figure out the parties to an arbitration agreement is to look for the entities who are named in the recitals and have signed the agreement. The signature of a party on the agreement is the most profound expression of the consent of a person or entity to submit to the jurisdiction of the arbitral tribunal. However, the corollary that persons or entities who have not signed the agreement are not bound by it may not always be correct. A written contract does not necessarily require that parties put the signature to the document embodying the terms of the agreement. Therefore, my lord, first proposition is that a non-signatory can also be a party to the arbitration agreement. That's the first proposition. Next, therefore, the term non-signatories instead of the traditional third parties seems the most suitable to describe
It
situations.
is an exception to doctrine of privity of contract in a sense.
Respectfully, my lord, I don't think it's that way, because the construction is that you are a party to the contract and therefore there is privity. My lord, if there is no privity, there is no consent.
Okay.
My lord, the distinction, my lord, is that you are not a signatory, but you are a party. Party, no
So it
privity
is
of
falls within the doctrine of privity of contract, not as an exception.
Exactly. Therefore, the terms signatories instead of the traditional third parties seems the most suitable to describe situations where consent to arbitration is expressed through means other than signature. A non-signatory is a person or entity that is implicated in a dispute, which is a subject matter of an arbitration, although it has not formally entered into an arbitration agreement. That's it. Rethinking consent in international commercial arbitration, etc. my lord. Then kindly say next one. There may be arise situations where persons or entities who have not formally signed the arbitration agreement or the underlying contract containing the arbitration agreement may intend to be bound by the terms of the agreement. In other words, the issue of who is a party to an arbitration agreement is
Primarily an
issue of consent. And if there is consent, my lord, privity of contract is there. That's the point. Next, my lord, please see para 74. Section 2H of the Arbitration Act defines a party to mean a party to an arbitration agreement. If before I read this paragraph, yesterday your lordship put to us a very pointed question. What is the extra mile that his lordship, who has given a concurring judgment of the Honorable Supreme Court in Cox and Kings, has taken?
Justice Narsim was.
What is the extra mile that Justice Narsimha has crossed in arriving at the same conclusion which has been arrived at by the Honorable Chief Justice? That, my lord, is having regard to Section 7. Because para 74, which is the judgment of the Honorable Chief Justice, did not take it that far. But his Lordship Justice Narsimha takes it one step further. That is the distinction.
That also becomes part of law?
Of course it is.
It's a
As long as
concurring
it's a concurring opinion, my lord, whatever his Lordship has said is also part of Article 141.
Unless somebody adversely comments upon it.
That's another bench.
No, members other. Suppose we are 5-judge bench and one will say something of them, one will disagree with.
Doesn't matter, my lord. If he agrees with the majority, if he concurs with the majority, it is still 141. According to me, it is still 141. Unless the view taken by...
Yes, the majority itself repels with that.
Of course, then it's a different scenario altogether.
Then it becomes a dissenting.
It becomes a minority judgment.
Yes.
That's it. Section 2H of the Arbitration Act defines a party to mean a party to an arbitration agreement. Section 7 defines an arbitration agreement to mean an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship. Section 7 requires that an arbitration agreement has to be in writing. Section 7 indicates the circumstances in which it is regarded as an agreement in writing. Such an agreement may be embodied in a document, an exchange of communication, including the electronic form, or in a statement of claim which is not traversed in the defense. In inter-alia, this court observed that legal relationship means a relationship which gives rise to a legal obligation and duties and confers a right. Such a right may be contractual or non-contractual. In a case of a non-contractual legal relationship, the cause of action arises in tort, restitution, breach of statutory duty, or some other non-contractual cause of action. Thus, legislative intent underlying Section 7 suggests that any legal relationship, including relationships where there is no contract between the persons or entities, but whose actions or conduct has given rise to relationship, could form a subject matter of an arbitration agreement under Section 7. I pause for a moment here, my lord. This is here where Justice Narsimha, my lord, his lordship, takes it further. He says, no, I am not reading that a non-signatory can be a party to the arbitration agreement, dehors the Arbitration Act.
He brings in Section 7.
7, exactly. Here, my lord, the court stops at saying legislative intent suggests that any legal relationship, including relationships where there is no contract.
Literally quasi-contracts.
His lordship says no question of no contract. I say there is contract. That is the difference, my lord, between the view
Therefore fits into 7 paragraph.
Therefore, we see the section 7. That is the subtle difference between the view taken by
Honorable
his
Chief
Lordship, the Honorable
Justice.
Chief Justice, and the view taken by his Lordship Justice Narasimha. That's the answer to your Lordship's question. What
No,
is
it need not, perhaps here, the intent of the bench was that it did not divorce the provisions of the Act.
exactly?
It should have some semblance of statutory recognition itself. Otherwise, your debates like basic structure theory is outside the Constitution, brought all that. These debates took place in Parliament. Parliamentary
Yes.
debates show that we're still in a very bad language is another thing. We are not on that. Now, it's in a very bad language, the discussion took place. They are available in records.
But all said and
records.
done, my lord, they were patriots.
They are patriots.
That's all.
That's all.
At the bottom of it, my lord, that's all. There can be different views expressed in different ways.
Even Antonio said, Mark Antonio said, Brutus is a patriot.
Brutus is an honorable man.
He said patriot.
Yes.
Julius Caesar. That's that kind. Anyway.
Thus, legislative intent underlying section 7 suggests that any legal relationship, including relationships where there is no contract between the persons or entities, but whose actions or conduct has given rise to a relationship, could form the subject matter of an arbitration agreement under section 7. His Lordship Justice Narasimha says, no, this comes under section 7. There is no question of a relationship divorce the contract.
No, even idea of no contract is also not invocable.
Not-
There is a contract.
There is a contract. That's the point.
Understood.
I'll come to it. This approach is in line with the observation of the Lord Hopman in Philly Shipping Company versus so-and-so, where it was observed.
House of Lords judgment.
House of Lords judgment, my lord, I'm going to skip the para 76. Now kindly see para 76. Section 7(4)(b) provides the second circumstance according to which an arbitration agreement is in writing if it is contained in an exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement. According to this provision, the existence of an arbitration agreement can be inferred from various documents duly approved by the parties. The exact exercise that the honorable arbitrators have undertaken. And they have written, my lord, 40 pages. They have done a
Very
40
long order issue.
long order, full analysis. And of course, my lord, if your lordships permit me, I want to take your lordships through the order passed by the Learned Arbitral Tribunal. According to this provision, the existence of an arbitration agreement can be inferred from various documents duly approved by the parties. Section 7(4)(b) dispenses with the conventional sense of an agreement as a document with signatories. That's the law. Rather, it emphasizes on the manifestation of the consent of persons or entities through their actions of exchanging documents. However, the important aspect of the said provision lies in the fact that the party should be able to record their agreement through a documentary record of evidence. In so-and-so, this court observed that section 7(4)(b) requires the court to ask whether a record of agreement is found in the exchange of letters, telex, telegrams, or other
In
means of-
other words, they have said what Anson on contract said. AG gets work edited by Professor Anson.
Yes, sir.
He says a contract like arrangement can be inferred not necessarily from one particular document, but a series of transactions and intercourses that would evidentially vouch. That is in fact quoted by
In fact, my lord, in the subsequent paragraphs in Cox and Kings, their lordships say circumstances are very important for the purpose of finding out as to whether you are a party to the contract, even though you are not a signatory to the contract. That's how it is. Now, my lord, kindly see para 81. Section 2H, read with section 7, does not expressly require the party to be a signatory to an arbitration agreement or the underlying contract containing the arbitration agreement. In the context of arbitration law, the intention of the parties has to be derived from the words used in the arbitration agreement. While construing the arbitration agreement, it is the duty of the court not to delve deep into intricacies of the human mind, but only consider the expressed intention of the parties. The words used in the contract reflect the commercial understanding between the parties. The intention of the parties, not exactly what your lordship just now mentioned, their lordship, the Honorable Supreme Court also mentioning. The intention of the parties has to be ascertained from the words used in the contract, considered in the light of the surrounding circumstances and the object of such contract. Exactly what your lordships mentioned just now. Modern commercial, the discussion is very
Beautiful.
illuminating, if I may respectfully
Illuminating.
say so, with all the humility at my command. Therefore, my lord, if I'm taking too much of your lordship's time, your lordship may ask me to stop.
No, no, no,
Otherwise,
nothing
I-
like that, nothing like that.
I-
Many, we will be learning law. Every day, when I go home, I feel again, I learned so much today. Many of our judges, including my brother, says this. They say
Correct.
this.
It is-
We learn
It is both-
case to case basis ಮೇಲೆ learn ಮಾಡ್ತೇವೆ ನಾವು.
Yes, very true.
ನಮ್ಮಷ್ಟು learning ನಿಮ್ಗೆ ಆಗಲ್ಲ.
ನಿಜ.
Very brilliant. But amount of experience which we have by sitting as a judge is something marvelous.
Undoubtedly, my lord, your lordships have 100 cases on the board. I have.
And every day,
Every-
judges, lawyers like you, Mr. Halla, or Professor, and many others come and argue. But few others do not do well. That hurts us. That hurts us. They come without preparation and they get perplexed when we put question, or they become angry on us. That should not happen. Whatever is, wherever not. Therefore, Gita says, Nahi jnanena sadrusham pavitramiha vidyate. There is nothing as sacred as knowledge. This knowledge is like that. This is Bharata is knowledge, land of knowledge.
Amrutam to Vidya.
That's what.
Knowledge is nectar.
One small incident I should say.
My lord.
Sir, when Vishweshriya went to US and came back. And thereafter, Mysore, Maharaja of Mysore went to US. Then the Americans asked, they asked him, who are you? I am Maharaja of Mysore. Oh, Mysore means Vishweshriya? Then Maharaja came and reported to Vishweshriya. Vishweshriya, you are ನನ್ನ ರಾಜ್ಯದ ನಾಗರಿಕ ನೀವು, ಆದ್ರೆ ನಾನು ಅಮೆರಿಕಕ್ಕೆ ಹೋದಾಗ ನಿಮ್ಮ ರಾಜ್ಯದ ನಾಗರಿಕ ಆಗಿದ್ದೆ ಅಂತ.
I go down, no doubt. We would not have been where we are, but for those.
ಅಲ್ಲ, ಒಳ್ಳೆ ಡಿಸ್ಕಷನ್ ಆಗ್ಬೇಕು ಬಾರ್ನಲ್ಲಿ. ಬರೀ ಎಲ್ಲ ಕಳಪೆ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಆಗಿ ಶೋ ಮಾಡ್ಕೋತ ಹೊಂಟು ಬಿಟ್ರೆ ಹೆಂಗೆ? ಎಲ್ಲರೂ ನೋಡ್ತಿರ್ತಾರೆ ಜನ, ಇದು ಮಾಡ್ತಿರ್ತಾರೆ, ಏನು ಜಡ್ಜು ಕಳಪೆ, ಲಾಯರ್ಗಳು ಕಳಪೆ, ಕೇಸು ಕಳಪೆ ಅನ್ಕೊಂಡು ಮಾತಾಡಿಬಿಡ್ತಾರೆ. ಒಂದು ಡಿಸ್ಕಷನ್ ಆದ್ರೆ ದೇ ಶುಡ್ ಫೀಲ್ ವಿ ಹ್ಯಾವ್ ಲರ್ನ್ ಸಮಥಿಂಗ್ ಟುಡೇ, ವಿ ಲರ್ನ್ ಸಮಥಿಂಗ್ ಟುಡೇ ಅನ್ನುವಂಥ ಫೀಲ್ ಬರಬೇಕು. ಆ ರೀತಿ ಡಿಸ್ಕಷನ್ ಆಗ್ತಿತ್ತು. ಇದು ಬೇರೆ ಎಲ್ಲೇ ಒಂದು ಬೇರೆ ಲೀಗಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲ. ಯು ಹ್ಯಾವ್ ಟು ಡೆವಲಪ್ ದ ಬಾರ್ ಆಲ್ಸೋ. ವೇರ್ ಫ್ರಮ್ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಬ್ರಿಂಗ್ ದ ಜಡ್ಜಸ್ ಟುಮಾರೋ? ಫ್ರಮ್ ಪ್ಯಾಡಿಫೀಲ್ಡ್. ಮತ್ತೆ ವೇರ್ ಹೌ ಆರ್ ಯು ಗೋಯಿಂಗ್ ಟು ಬ್ರಿಂಗ್ ದ ಗುಡ್ ಜಡ್ಜಸ್ ಹಿಯರ್? ಅದರ್ವೈಸ್ ಬೇರೆ ನಮ್ಮಂತರ ಅಟ್ಲೀಸ್ಟ್ ನಮ್ಮಂತ ಜಡ್ಜಸ್ ಆಗಿಬಿಡ್ತಾರೆ. ಅವಾಗ ನಿಮ್ಗೆ ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ. ಒಳ್ಳೊಳ್ಳೆ ಜಡ್ಜಸ್ ಬೇಕಾಗ್ತಾರೆ. ಹೌದು, ಇದೆಲ್ಲ ಕ್ರಾಪಿಂಗ್ ಇದೆ. ಬಾರನ್ನು ಬೆಳೆಸ್ಕೊಳ್ಬೇಕು. ಅವಾಗ ನಮ್ಗೆ ಒಳ್ಳೊಳ್ಳೆ ಜಡ್ಜಸ್ ಇವರೆಲ್ಲ ಸಿಗ್ತಾರೆ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಅಲ್ಟಿಮೇಟ್ಲಿ ಏನ್ ಜುಡಿಷಿಯರಿ ಬಿಲ್ಡಿಂಗ? ಇಲ್ಲಿ ಕೊಡುವಂಥವ್ರು ಏನಿದ್ದಾರೆ ಮತ್ತು ನೀವು ಎಂಥವ್ರು ಅಂತಂದು ಕೂಡಿಸ್ತೀರಿ, ಅದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತದೆ ಜುಡಿಷಿಯರಿ. ನಾವು ಹಂಗೆ ನಿಮ್ಮ ಮುಖ ನೋಡಿ ಪ್ಲೀಸ್ ಮಾಡಿಕೊಂಡು, ಜಾತಿ ಮುಖ ಇಂಥವೆಲ್ಲ ನೋಡ್ಕೊಂಡು ಪ್ಲೀಸ್ ಮಾಡ್ಕೊಂಡು ಹೊಂಟ್ಬಿಟ್ರೆ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಉಳಿಯೋದೇ ನಾಳೆ. ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಸ್ವಲ್ಪ ಜಡ್ಜಸ್
Lawyers, judges and lawyers.
Lawyers.
Both have to be.
ಲಾಯರ್ಸ್ ನಮಗೆ ಅವ್ರ ಕ್ರಾಪು. ಆ ಜಡ್ಜಸ್ ಇವೇ ಬರ್ತಾರೆ ಹೋಗ್ತಾರೆ ಬೇಕಾದಷ್ಟು ಜನ. ಒಳ್ಳೊಳ್ಳೆ ಲಾಯರ್ಸ್, ಟಾಲ್ ಲಾಯರ್ಸ್ ಎಲ್ಲ ಇದ್ರೆ ಎಷ್ಟು ಉಪಯೋಗ ಬಾರಿಗೆ, ಆಮೇಲೆ ನೇಷನ್ನಿಗೆ ತುಂಬಾ ಉಪಯೋಗ. ಒಬ್ಬ ಪಾಲ್ಕಿವಾಲ ಇದಕ್ಕೆ ಬೇಸಿಕ್ ಸ್ಟ್ರಕ್ಚರ್ ಡಾಕ್ಟ್ರಿನ್ ಬಂತು, ದೇಶ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಉಳಿ, ಒಬ್ಬರೇ ಅದೇನು ಗುಂಪು ಕಟ್ಕೊಂಡೇನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮೇಲೆ ಯುದ್ಧ ಮಾಡ್ಕೊಂಡ್ ಬರಲಿಲ್ಲ. ಒನ್ ಐಡಿಯಾ, ಒನ್ ಸಿಂಗಲ್ ಐಡಿಯಾ, ಒನ್ ವಿಶ್ವೇಶ್ವರಯ್ಯ, lakhs together acres irrigation. ಅದಕ್ಕೆ ಅದು ಬೇಕಾಗ್ತದೆ. How the 9 Scorpios, which he called Supreme Court judges of America, he called as 9 Scorpios. Each bite improved the health condition of the country in the Baritangon Harris. They may call the judges as Scorpios. And bite of each scorpion improved the health condition of the country, constitutional health condition of the country. ಹಾಗಾಗಿ ಸ್ವಲ್ಪ ಬೇರೆ ಹಿಂಗೆ ಅನ್ಕೊಂಡು ವೇಸ್ಟ್ ಅಂತ ಅನ್ಕೊಂಡಲ್ಲ. But still we have to ration our.
That is why, my lord, I'm conscious of that. When I said I don't say waste, my lord, I am very conscious of the fact that your lordship's time is so precious and with so much of work. Therefore,
we are concerned that good bar produces good judges.
Only from bar only.
Bar from
ನಮ್ದು ಜಡ್ಜಸ್ ಎಲ್ಲಿಂದ ಬರ್ತಾರೆ?
At the end of the day, when we
ಹೊರಗಿನಿಂದ
meet in the
ಕರ್ಕೊಂಡು
in the
ಬರ್ತೇವೆ.
evening,
what good work we have done today, what we have learned today. That has to be introspected.
ಅಷ್ಟೇ.
I bow down to it.
ತುಂಬಾ ಲರ್ನಿಂಗ್ ಆಗ್ತದೆ ಜಡ್ಜಸ್ಸಿಗೆ, ತುಂಬಾ ಲರ್ನಿಂಗ್ ಆಗ್ತದೆ, ಬಹಳ ಲರ್ನಿಂಗ್ ಆಗಿರುತ್ತೆ ನಮಗೆ. ನಾವು ಜಾಣರು ಇರ್ಲಿಕ್ಕಿಲ್ಲ, ಆದ್ರೆ ನಮ್ಗೆ ನೀವೆಲ್ಲ ಸೇರ್ಕೊಂಡು ನಮ್ಮನ್ನು ಒಂದು ಮೂರ್ತಿಯಾಗಿ ಪರಿವರ್ತಿಸ್ತೀರಿ. ನಾವು ಅಲ್ಲಿ ತನಕ ಮೊದಲಿಗೆ ಏನು ಲಾಯರ್ ಅನ್ಕೊಂಡೇನು ಅನ್ಕೊಂಡಿದ್ದು ಹಂಗಿರಲ್ಲ. ಇಲ್ಲಿ ಕೂತ್ಕೊಂಡಾಕ್ಷಣ ಇನ್ನೊಂದು ಆಂಗಲ್ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ. ಒಂದು ಬೇರೆ ಇನ್ನೊಂದು ಯಾವುದೋ ಒಂದು ಬೇರೆ ದೇಶದ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್, ಅಯ್ಯೋ ಅಲ್ಲಿ ಹಿಂಗೆ ಟ್ರೀಟ್ ಮಾಡಿದ್ದಾರೆ, ಇಲ್ಲಿ ಯಾಕೆ ಹಿಂಗಾಯ್ತು, ಈ ನಮ್ನಿ ಕಂಪೇರೇಟಿವ್ ಲಾ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ ಹಿಂಗಂತ. ಬಟ್ ಅಷ್ಟೆಲ್ಲ ಪ್ರಿಪರೇಷನ್ ಮಾಡಿಕೊಂಡು ಬಂದು ಆರ್ಗ್ಯೂ ಮಾಡುವಂಥವರಿಗೆ ಈ ಕೋರ್ಟ್ನಲ್ಲಿ ಹೆಚ್ಚು ಬೆಲೆ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ನಾವು ಅಷ್ಟು ಬೆಲೆ ಕೊಡಲ್ಲ.
Great.
ಕೊಡಲ್ಲ.
Grateful, grateful,
Yes.
very great. My lord, para 97 at page 12. Modern commercial reality suggests that there often arise situations where a company which has signed the contract containing the arbitration clause is not always the one to negotiate or perform the underlying contractual obligations. In such situations, emphasis on formal consent will lead to exclusion of such non-signatories from the ambit of arbitration agreement, leading to multiplicity of proceedings and fragmentation of dispute. Like, if the course that is adopted, suggested by my
That
learned
would
friend, is
happen
that
ಅಂತ ನಿಮ್ಮ ವಾದ.
clearly against this. What is this fragmentation?
Yes.
In Ayaswamy, the court observed that it is the duty of the courts to impart to that commercial understanding a sense of business efficacy. My lord, all that I would plead for your lordships, my lord, judges should in fact step into the shoes of the businessman to see what is it that they intended when they entered into this contract. That is the role of a judge. That's why, my lord, to impart to the commercial understanding a sense of business efficacy. The courts must interpret contracts in a manner that would give them a sense of efficacy rather than invalidating the commercial interests of the parties. The meaning of the contract must be gathered by adopting a common sense approach, which should not be allowed to be thwarted by narrow, pedantic, and legalistic interpretation. Therefore, there is a need to adopt a modern approach to consent, which takes into consideration circumstances, apparent conduct, and commercial facets of business transaction. Then, my lord, what is this group of company doctrine? Is it a legal concept or is it a fact-based doctrine? Supreme Court says it is a fact-based doctrine. It can't be decided in a writ petition like this. It has to be decided upon appreciation of the various documents by the fact-finding body, namely the arbitral tribunal, is what Honorable Supreme Court says. The group of companies doctrine is used in the context of companies which are related to each other by virtue of their being a part of the same corporate group. Since every company in a group has a separate legal personality, a contract formally entered into by one member of a group will not be binding on the other members by virtue of the limited liability principle. The group of companies doctrine is used to bind a non-signatory company within a group to an arbitration agreement which has been signed by other members of the group. The underlying basis of the group of company doctrine would rest on maintaining the corporate separateness of the group companies while determining the common intention of the parties to bind the non-signatory party to the arbitration agreement. I pause for a here to explain this concept to your lordships. As your lordships are aware, every company is an independent legal entity. Therefore, my lord, when I want to say that if A company has entered into a contract with B company, you want to make C company part of A company, you should not do violence to the principle that A and C are two independent legal entities.
Entities trading with limited liability.
Exactly. But having said that, one has to marry the principle of consent. If A has entered into a contract with B, you want to make C liable, you don't make C liable because A and C are related in the sense of being a holding company or a subsidiary company.
But they are
consenting. That's the issue. That is the issue. Therefore, the two principles of corporate entity, distinct and separate from the shareholders, and
is not violated.
Is not violated. That is how, my lord, the Honorable Supreme Court is marrying the two principles. The underlying basis of the group of companies doctrine rests on maintaining the corporate separateness of the group companies while determining the common intention of the parties to bind the non-signatory party to the arbitration agreement. In other words, group of companies doctrine is a means of identifying the common intention of the parties to bind a non-signatory to arbitration agreement by emphasizing and analyzing the corporate affiliation of the distinct legal entities. So if the two principles are beautifully reconciled. Then, Manoj, kindly say the next one. The above position was explicitly adopted by ICC tribunal in Dow Chemicals, where it was held that an arbitration agreement signed by certain companies of a corporate group will bind other non-signatory members only where all the parties intended and understood the non-signatories to be, kindly see these words, Manoj, veritable parties. That's the test to the underlying contract containing the arbitration agreement based on their participation in the conclusion, performance, or termination of the contract, what my learned friend emphasized. Thus, the existence of a group of companies is a factual element that the court or tribunal has to consider when analyzing the consent of the parties. Now, Manoj, why do they use the word court here, Manoj? They use the word court because these are also factors that have to be considered while considering an application under Section 11 or in a Section 8 proceedings where stay of proceedings
Or wherever that question arises.
Today, the word therefore here court may not be relevant. The position would be thus the existence of a group of companies is a factual element that the tribunal has to consider when analyzing the consent of the parties. Exactly what has been done. It is inevitably adds an extra layer of criteria to an exercise which at its core is preponderant on determining the consent of the parties in case of complex transactions involving multiple parties and agreements. In Cox and Kings, Suryakant J. questioned whether the principles of alter ego or piercing the corporate veil can alone justify the application of the group of companies doctrine even in the absence of implied consent. This court in Sharon clarified that there is an important distinction between group of companies doctrine and the principle of veil piercing or alter ego. The principle of alter ego disregards the corporate separateness and the intention of the parties in view of the overriding considerations of equity and good faith. In contrast, group of company doctrine facilitates the identification of the intentions of the parties to determine the true parties to the arbitration agreement without disturbing the legal personality of the entity in question. I pause for
one sorry. Whether that another company has consented or not ಅಂತ ನೋಡ್ಬಿಟ್ರೆ piercing the wheel ಎಲ್ಲಿ ಹೋಗೋದೇ ಇಲ್ಲ.
In fact, piercing the corporate veil is doing
violence to the independent
Exact.
personality of the
Exact.
company.
Exactly. That is why, my lord, their lordship say, no, we are not going to adopt
No,
this.
that's how Apex Court said
Apex.
in that Escorts Limited versus
Yes.
LIC.
Yes.
Oh, Chinnapareddy.
Yes. That's right. This is, my lord, a departure from chloro control. And it is here that we don't have to worry about piercing the corporate veil, alter ego concept when we are considering whether a non-signatory to an arbitration agreement is a party to the arbitration agreement. By consent, you are saying that you are a party. Therefore, why lift the corporate veil and destroy the independent existence of a corporate entity? That's how, my lord, this principle of alter ego or lifting the corporate veil has now been done away by introducing predominantly the concept of consent, which, as I indicated earlier, my lord, is the very basis of all arbitration because arbitration is 100% consensual. There can be no imposition of arbitration unless it's a statutory arbitration. That's a different thing. Then, my lord, 111. Group of companies doctrine requires the courts and tribunals to consider the commercial circumstances. My lord, at page 15 on top.
Yes.
The group of companies doctrine requires the courts and tribunals to consider the commercial circumstances and the conduct of the parties to evince the common intention of the parties to arbitrate. Please mark the words, my lord, commercial circumstances and the conduct of the parties. It is important to note that the group of companies doctrine concerns only the parties to the arbitration agreement and not the underlying commercial contract. Consequently, a non-signatory could be held to be a party to the arbitration agreement without becoming a formal party to the underlying contract. The existence of a group of companies is one of the essential factors to determine whether the conduct amounts to consent, but membership of the group is not sufficient in itself. This has been the consistent position of law, starting from Dow Chemicals, where it was observed that common intention of the parties to bind the non-signatory party to the arbitration can be inferred from circumstances that surround the conclusion and characterize the performance and later the termination of the contracts. In other words, it was held that a non-signatory party could be considered as a true party to the arbitration agreement on the basis of their role in the conclusion, performance, or termination of the underlying contract. We are not concerned with termination because in this case, there is no termination.
Small question.
Why not?
Why at all we wanted the doctrine of group of companies? If we could have ascertained whether that company has consented or not, where is the requirement of it being a group?
My lord, I bow down. In fact, your lordship,
Yesterday when he argued,
your lordship asked
I was contemplating.
Your lordship.
And this idea is very much nearby what the Honorable Justice Narasimha observes. If consent is given,
Even if you're not part of the group,
That is
doesn't
what-
matter.
where is the jurisprudential justification
is
for
because-
inventing this new?
But I
doctrine?
tell you, lordship, that is because in this judgment in Cox and Kings, their lordships were answering a reference. There, it was part of a group. And the argument advanced was that because you're part of a group, you're automatically a party to the arbitration agreement. So therefore, their lordships were considering the correctness of that proposition. And then in the context of that proposition, they said merely being part of a group is not enough. You also have to show consent. In fact, I would take now, my lord,
If you are not part of the group,
doesn't matter if there's consent, that's
That's
interfered.
what I'm
Your
saying.
lordships are right. Exactly, my lord. Absolutely.
they simply followed that House of Lords judgment.
Yes.
This is how perhaps it arose. But I could not find any jurisprudential justification to bring that doctrine as if it is applicable to here. It is like taking a pineapple to Siberia and plant it there. The idea is whether it has consented to this or not.
Yes.
Then whether it is part of, assume that if it has consented but it is not part of the group,
Yes.
will you exclude it?
No, don't. If that's why, my lord, they came up with the concept of composite transaction, common intention, serving a common purpose. If all this, and you are acting in the course of performance of a contract, of which you are not a party or a signatory. I must not use the word party. If you're not a signatory, still, even if you're not part of a group, you are still liable. Your lordship's question was, why is it that this entire Cox and Kings talks about group of company? Because these facts arose in that manner.
That matter.
Therefore, my lord, the converse, that if you are not part of the group,
you
even if
will
you
go
have
away.
consented.
That is not the
No,
law.
that's not. That's not. That is the law. The law is that primarily, my lord, consent is the essence.
It is more like pacta sunt servanda. You have agreed to this, you have consented
Yes.
to this, therefore abide by it.
Abide by it.
It like boils down to that.
Exactly. Surrounding circumstances, your conduct.
That's how you should collect the intention of the parties, etc. It is more evidentiary in nature. But in substantive principle is pacta sunt servanda. You have
Suppose,
agreed
my
to
lord-
that, therefore you are bound by it.
Bound by. Suppose, my lord,
Formally you have put signature, whether you are formally or mentioned it there or not. This is, the formality is given a go by.
Go by.
Ascertain all this, whether the totality of the interaction intercourse will lead to consent.
Absolutely.
Then whether you are part of the group or not, you will be bound.
You will be bound by
that.
Precisely, my lord. My lord, we have so many contracts where in a contract entered into between A and B, it is mentioned that the contract will be performed by C, and C has in the performance corresponded with B, corresponded with A,
Can
and there is
assert
a
that.
dispute. C may be a total outsider, but C will be liable.
Total outsider in the sense to one particular document where the arrangement is drawn. If evidentiary material shows that he has effectively participated, therefore, conclusion, performance, or termination. Three,
Or
Cox and King is the theme is that one.
That.
Anyway,
Exactly. Now, my lord, Then, my lord, there's another judgment which is very relevant. It is called Discovery Enterprises versus ONGC. Now, my lord, please see para 115 at page 15 at the bottom.
ONGC versus Discovery.
The Discovery Enterprises, ONGC versus Discovery Enterprises. This court refined and clarified the cumulative factors that the courts and tribunals should consider in deciding whether a company within a group of companies is bound by the arbitration agreement. And Discovery Enterprises, my lord, is held to be good law by the division bench, by the full bench judgment in Cox and Kings. In deciding whether a company within a group of companies which is not a signatory to arbitration agreement would nonetheless be bound by it, the law considers the following factors. 1, mutual intent of the parties. 2, relationship of non-signatory to a party which is a signatory to the agreement. 3, commonality of the subject matter. 4, composite nature of the transaction. 5, performance of the contract. These are the factors. And now, my lord, kindly see this one. The relationship of non-signatory to a party which is a signatory to the contract need not be confined to holding and subsidiary.
At all.
At all. Need not, it's not confined. If it is there, it is a very important factor. If it is not,
Not there, it
doesn't matter. Doesn't matter. If various other factors are satisfied. That is my understanding of the law, and I humbly place it for your lordship's consideration. Para 116. Since the group of companies doctrine is a consent-based theory, here, my lord, the fact of the matter is, and my learned friend very fairly said so yesterday, and your lordships recorded it, that MDPL holds 99% of the shares in this company called CVPL.
R5.
R5. So therefore, my lord, it is a relationship within the same group. There's no doubt about that. Since the group of companies doctrine is a consent-based theory, its application depends upon the consideration of a variety of factual elements to establish the mutual intention of all the parties involved. In other words, group of companies doctrine is a means to infer the be bound by the arbitration agreement. The relationship between and among the legal entities within the corporate group structure and the involvement of the parties in the performance of the underlying contractual obligations are indicators to determine the mutual intention of the parties. Both are satisfied in this case. The other factors, such as commonality of the subject matter, composite nature of the transactions, and the performance of the contract ought to be cumulatively considered and analyzed by the courts and tribunals to identify the intention of the parties to bind the non-signatory party to the arbitration agreement. So it's a cumulative. Put all the factors into the pot and then form a conclusion. That is how, my lord, ultimately, my lord, it's a question of resolving a dispute. It is not resolving a case. The whole object of the arbitration law is that we have to put an end to the dispute as quickly as possible, as efficiently as possible.
And holistically.
And holistically. That's it. The party seeking joinder of a non-signatory bears the burden of satisfying the above factors, so the satisfaction of the court or tribunal, as the case may be, and we have done it. We have discharged that onerous burden of proving that the non-signatory in this case is a party to the arbitration agreement. And the arbitral tribunal has given a finding on that. Section 7 of the Arbitration Act broadly talks about an agreement by the parties in respect of a defined legal relationship, whether contractual or not. Such a legal relationship must give rise to legal obligations and duties. In a corporate group, a company may have various related companies. Legal relationship must be analyzed in the context of the underlying contract between the arbitration, containing the arbitration agreement. The nature of the contractual relationship can either be formally encrusted in the underlying contract, or it can be inferred from the conduct of the signatory and non-signatory parties with respect to such contract. However, we clarify that mere presence of a commercial relationship between signatory and non-signatory parties is not sufficient to infer legal relationship between and among the parties. If this factor is applied solely, any related company or entity may be impleaded even when it does not have any rights or obligations under the underlying contract and did not take part in the performance of the contract. The group of companies doctrine cannot be applied to abrogate party consent and autonomy. That's correct. No doubt. No doubt. The doctrine properly conceptually applies gives effect to mutual intent and autonomy. That's it. Then, my lord, is para 120 required? Not necessarily. Skip to. My lord, I would request your lordships to kindly see paragraph 122 at page 18. That
General position of law.
Yes, my lord. Yes. The general position of law is that parties will be referred to arbitration under the principal agreement if there is a situation where there are disputes and differences in connection with the main agreement and also disputes connected with the subject matter of the principal agreement. In chloro control, this court clarified the principle of composite performance would have to be gathered from the conjoint reading of the principal and supplementary agreements on the one hand.
ಅದೇ repeat ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
It is, the lordships are expounding the concept. Sometimes repeatedly, sometimes not expanding it. And then
Some-
this,
at times little confusing also.
true, true. My lord,
ಅದರಲ್ಲೇ ಸ್ವಲ್ಪ confusion ಇದೆ. Anyway, we will not go to that discussion now.
but my lord, that's how law evolves. If
Yes.
everything is clear, my lord, progress will come to a stop. There should be scope for improvement, and 100%, my lord, everywhere there is scope for improvement. And now kindly see the third line at page 19. This is important, my lord. The common participation in the commercial project by the signatory and non-signatory parties for the purpose of achieving a common purpose.
Which
would-
paragraph?
My lord, I am reading at page 19, third line number 3.
Line number 3.
Common participation.
The common participation in the commercial project by the signatory and non-signatory parties for the purpose of achieving a common purpose could be indicator of the fact that all parties intended the non-signatory party to be bound by the arbitration agreement. Thus, the application of the group of companies doctrine in case of composite transaction ensures accountability of all parties who have materially participated in the negotiation and performance of the transaction, and by doing so have evinced a mutual intent to be bound by the agreement to arbitrate. This is it. Which one? Yeah, when we come to the order, I'll show it.
You come to para 126,
126, my lord, yes, I'll.
evaluating the involvement.
My lord, I
Again,
will.
the-
Grateful. Evaluating the involvement of the non-signatory in the negotiation, performance, or termination of the contract is an important factor for a number of reasons. First, being actively involved in the performance of a contract, a non-signatory contract may create an appearance that it is a veritable party to the contract containing the arbitration agreement. And in this case, my lord, the arbitral tribunal has found abundant material to show that they have been the persons who have been actively participating in the performance of the contract. Second, the conduct of the non-signatory may be in harmony with the conduct of other members of the group, leading the other party to legitimately believe that the non-signatory was a veritable party to the contract. The other party is me. And third, the other party has legitimate reason to rely on the appearance created by the non-signatory party so as to bind it to the arbitration agreement. Absolutely, my lord. I bow down. I'm grateful to your lordship. Pointing. Really? My lord, there were many factors that my learned friend pointed out, your lordships.
171 para 22, page 22.
Yes, my lord. Can I have your lordship's permission to point out one sentence
Please.
in paragraph 123? I shall read 170, my lord. Because emphasis was laid upon performance.
We will revert in a couple of seconds.
One sentence. Yeah, you're right.
And the second last para, 169 before 170, because that's what says the section 16.
That's a far more reliable single economic entity. Trust-based, group of companies. Single economic entity is based on practical reality. I mean, into a contract, but I am into a holding company or a shell company, the execution has to be by somebody else. Because it's a single economic entity.
But it need not necessarily be holding company subsidiary. That's what is also the same.
If you are applying if you are applying the consent based.
Not necessarily. Then you don't have to have holding.
Exactly, where in those cases, when Shankar Sundaram versus amalgamations, etc. Where they apply the single economic entity, they say that the promisor and the performer may be different in terms of corporate clothing, but it is impossible to segregate. Samananur power and Shankar Sundaram is one. Fluoro control is bad law, but now it's gone.
Now even water.
But recently, the result in the principal scheme. Not with the sole basis. Cannot with sole basis, yes, there are ways that you will find that consent is not required because the entities are so intertwined. That performance by one, promise by one results in performance by other. Then how will you segregate them from a? See, in Samanur, what happens is that
Is that what?
there is because the parent agreement and then the separate agreement. The requirement was that let's say there's marketing, there's manufacturing, entity create a subsidiary and perform it to that. So you go to control the subsidiary that is being created under the requirement of the contract itself is actually performance by the parent. Because they form a very tightly held single economic entity. But in the cases that went to contract that, never can be done. Never be. So one thing, one confession. In my life, I have not cited fluoro controls one code. I have not opened such a. I have from the day it came, I have considered it bad.
What to do? They didn't you got lots of games, it was good law.
The day it came out, we cited it first time. Then we told them from the moment this overturned, we'll come and show you the other judgment. Because Justice Thakur was reading and we had a weird contract with the trade company. So wherever they.
I had the same
said-
reaction.
Yes.
When I was doing another before Chief Justice Bombay, for Supreme Court. No.
Kapadia.
No, Kapadia passed away. We did that other man. Huh? No, not being Sri Krishna. No, actually. He told me, sir, he said, I will get fluoro control, but I'm not going to follow what he said.
It's just Thakur said, I will pass the award before the full bench considers the matter. I have not cited fluoro controls in one hour.
Fluoro control makes it impossible for group companies to work across the world.
In fact, in Dow Chemicals, cited as the poster child, Dow Chemicals, group of companies was recognized and rejected. Didn't apply. Correct.
Right. How can it make these big, complex structuring we have of companies all across the world? Because
By to consent.
goodbye consent, exactly. Order.
Order and then.
And then they have referred to all that and then one by one.
Yes. Very.
because we are using cloud. He is always 2 paragraphs. He could have jumped to 170 because he wants to be very impatient. Conclusion, let's go to conclusion. I understood. It may not be necessary that he will be there. He will be looking for it. Conclusion.
We'll take it as a good sign that he is convinced.
I know that. Open forum. Experience doesn't matter. Yeah, or he may convince about the outcome. He will dictate what he does. It's his character. Not my matters. He will say, hello. Yes, 1, 2, 3, 4. Or if he said, wait, I've detailed all the facts. My conclusions and the findings, I will detail in my chambers. So that I know sometimes it dictates the arguments to capture. I didn't know if it happened that way, you know what happened again. Oh my God. I know. Almost. You could probably lift it.
Sorry?
Lift it.
Okay.
Oh, this one.
I just, so and so gets so and so, and all said, in view of the above. Oh.
Yes.
You wanted me to read one paragraph. My lord, in paragraph 123, there is one very important indication that the Honorable Supreme Court has.
Participation of the
Yes,
non-signatory.
participation of the non-signatory in the performance of the underlying contract is the most important factor to be considered. But all this formation, participation, performance, termination. Kindly see what the Supreme Court says. Participation in the performance is the most important fact. So this I think, my lord, clears all the confusion, if at all There is with respect to formation, participation, termination, or.
Yes.
Now, all that is not. Then, my lord, 164, your lordship. My lord, I am reading one paragraph 163 and 164, which also supports the first proposition I place for your lordship's consideration. Section 16 of the Arbitration Act enshrines the principle of competence in Indian international law, in Indian arbitration law. The provision empowers the arbitral tribunal to rule on its own jurisdiction, including any ruling on any objections with respect to the existence or validity of the arbitration agreement. Section 16 is an inclusive provision which comprehends all preliminary issues touching upon the jurisdiction of the arbitral tribunal. The doctrine of competence is intended to minimize judicial intervention at the threshold stage. The issue of determining parties to an arbitration agreement goes to the very root of the jurisdictional competence of the arbitral tribunal. Therefore, my lord, if they have considered it as a jurisdictional issue and decided that I will make you a party, then it is an order under section 16. It's a jurisdictional issue. In Vidyadrolia, N.V. Ramana J, as the learned Chief Justice then was, held that the amendment to section 8 rectified the shortcomings pointed out in chloro control with respect to domestic arbitration. My lord, I'll just skip that, kindly come to para 239 in Vidyadrolia. Jurisdictional issues concerning whether certain parties are bound by a particular arbitration under group company doctrine or good faith, etc., in a multi-party arbitration raises complicated factual questions which are best left to the tribunal to handle. And this principle, my lord, has been endorsed in paragraph 169 at page number 122, the highlighted portion. In view of the complexity of such a determination, the referral court should leave it for the arbitral tribunal to decide whether non-signatory party is indeed a party to the arbitration agreement on the basis of the factual evidence and application of legal doctrine. Here, my lord, when they said the referral court, because they were considering the context of a section 11, in our case, my lord, arbitral tribunal. Leave it to the arbitral tribunal. In view of the complexity of such a determination, I would permit me to say, I would say writ court. Instead of referral court, my lord, I would use the word writ court. The writ court should leave it to the arbitral tribunal to decide whether non-signatory party is indeed a party to the arbitration agreement on the basis of the factual evidence and application of legal doctrine. The tribunal can delve into factual, circumstantial, and legal aspects of the matter to decide whether its jurisdiction extends to the non-signatory party. In the process, tribunal should comply with the requirements of principles of natural justice, such as giving opportunity to the non-signatory to raise objection with regard to the jurisdiction of the arbitral tribunal. And in this case, I can tell you, Lordship, that they were given full opportunity. They were heard for days and days before the arbitral tribunal, and they filed multiple sets of written arguments. This is the position, my lord. And then para 170, the conclusion that your lordship. My lord, the definition of parties under 2(1)H, read by sections.
That Basuraj read yesterday.
Yes, I will not read it. Then, my lord, ONGC versus Discovery is at serial number 7 at page 24. My lord, I have read the same paragraph. I'm just pointing out to you. And now, my lord, there's one recent judgment after Cox and Kings. That is Ajay Madhusudan, which is serial number 8 at page 25. The fact that
a non-signatory did not.
Yes, this is the latest judgment on the point. The fact that a non-signatory did not put pen to paper may be an indicator of its intention to not assume any rights, responsibilities, or obligations under the arbitration agreement. However, the courts and tribunals should not adopt a conservative approach to exclude all persons or entities who intended to be bound by the underlying contract containing the arbitration agreement through their conduct and their relationship with the signatory parties. Mutual intent of the parties, relationship of a non-signatory with the signatory, commonality of the subject matter, composite nature of the transactions, and performance of the contract are all factors that signify the intention of the non-signatory to be bound by the arbitration agreement. This is the latest enunciation of the law by the Honorable Supreme Court after Cox and Keynes.
Yes.
Then, my lord, kindly turn to page 26, paragraph number 80, my lord. My lord, there's one other point, my lord, that's relevant. I'm thankful to my learned friend pointing out. Para 79, kindly see, my lord, do not conduct a mini trial in a section 11 proceeding. In a writ petition, my lord, please do not conduct a mini trial to sit as if I am sitting as an appellate court over the factual findings recorded by the Honorable Tribunal. And then, my lord, please be kind enough to turn to paragraph number 80 at page 26.
Sorry. He is a party to the proceeding anta admele. Will you allow him to lead evidence
Of course,
to rebut that also?
my lord, that he can do in 34.
So that
If the award is against him, he can do under 34. Suppose, my lord, in a section 16, let us leave aside.
No,
my lord,
whether
on-
an issue is framed. Now,
No, no, that
prima
can be done.
facie, now no evidence is yet, trial
No,
has
no.
not begun.
No,
You have formed an opinion that he fits into this and therefore you have brought him within
Yes.
this one.
yes.
Are you going to frame an issue saying that? Because now evidence is not led from either side. It's only by turning the pages of papers, whichever you
No, on
have
the
put
basis of admitted documents.
Huh?
On the basis of admitted documents.
admitted document.
Yes, yes.
Admitted by whom?
No, in a, once,
Admitted by whom?
by all parties, they also didn't dispute it. They were, my lord, they were given ample opportunity to appear before the tribunal. They did not say, sir, there are disputed documents. I want evidence.
In other words, once that issue is decided, it is final only.
It is final. 34 is the only remedy. That is the scheme of section 16.
16.6.
16.6. That 16.6. That's the scheme. Otherwise, my lord, at every stage, the arbitration proceedings will be halted.
ಇಲ್ಲ ಹಾಲ್ತನ ಕೇಳಿಲ್ಲ ನಾನು. ನೀವು ಅದನ್ನ ಇನ್ನೊಂದ್ ಸಾರಿ
No, my lord. No.
ಫ್ರೇಮ್ ಮಾಡಿ
No,
ಅದನ್ನ
that will be,
lead ಮಾಡಿ.
that will be rendering section 16.6 odious. The scheme is totally different. Because, no, my lord, let us look at,
ಯಾಕಂದ್ರೆ ಎವಿಡೆನ್ಷಿಯರಿ ಆಸ್ಪೆಕ್ಟ್ ಇದೆ.
my lord, let us look at this. Let us look at this point that your lordships are putting to me in a slightly different perspective. Let us leave aside a question as to the implement of a non-signatory as a party to the arbitration. Suppose, my lord, the question is as to whether a particular dispute is arbitrable or not. Existence or validity. Now let us assume, my lord, the dispute is in respect of this particular dispute, is there an is this coverable? Is it covered by the arbitration clause? Arbitration looks into the clause, says this is a dispute, and then says, yes, it is. It is something that comes within the purview of the arbitration clause. Therefore, I will proceed with it. Now, again, will you frame another issue later on to say, no, let me consider once again on the basis of the totality of the evidence.
ಬಿಕಾಸ್ ನಾವ್ ಯಾಕೆ ಇದನ್ನ ಕೇಳಿದ್ವಿ ಅಂದ್ರೆ ಫ್ಯಾಕ್ಟ್ ಬೇಸ್ಡ್ ಡಾಕ್ಟ್ರಿನ್ ಅಂತ
Yes.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 3 ಕಡೆ ಹೇಳ್ತಾರೆ.
ಹೌದು.
ಫ್ಯಾಕ್ಟ್ ಬೇಸ್ಡ್ ಅಂದಾಗ ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಅನ್ನ ಅಸರ್ಟನ್ ಮಾಡೋದು ಟ್ರಯಲ್ ನಲ್ಲಿ.
Yes. Yes.
ಆ ಟ್ರಯಲ್ ಆಗಿಲ್ಲ ಇಲ್ಲಿ.
ಅವ್ರು ಕೇಳ್ಬೇಕಾಗಿತ್ತು. They should have come and told the arbitral tribunal, sir, you don't have enough material before you to come to a conclusion that that even though I'm a non-signatory, that I should be made a party. I have a lot more to say. I want to keep this issue open, but I will participate in the proceedings. On the contrary, they came and told the arbitral tribunal, sir, I don't want to be before you. Well, it's one thing to say, I will be before you. I will participate in the proceedings.
Reserving liberty to raise this issue
Please keep this
and
issue
lead evidence on that.
Yes.
That is not his case.
No. Therefore, today they cannot therefore override section 16. If they had done that, the court would have said, I will not pass any order under section 16. Therefore, section 16.6 will not kick in. Having participated before the relevant arbitral tribunal, having taken a chance on a finding that they are not parties to the arbitration agreement, it is not open for them to come and tell your lordship, give me a second innings.
Like estoppel.
That is a stop, my lord. And that is against the scheme of the statute. We will be completely taking away section 16.6 from the statute book. So, my
But
lord,
there are
so-
some judgments of the apex court
Yes. Yes.
where doctrines and principles are fact-based.
Yes,
Obviously, they are facts-based. only.
yes, yes.
And when Supreme Court emphasizes that it's a fact-based doctrine, whether these facts can be ascertained without holding a trial,
It can be. If the other party says, I'm ready to.
our trial Barudela.
Barudela.
If when he disputes trial begins,
Exactly. He didn't dispute. He says,
he said, I am not at all concerned with this.
No, but he came and participated in the proceedings, told the arbitral tribunal, sir, on the basis of the material that you have with you, please decide the question that I am not a party to the arbitration agreement.
Whereby he has to request. He has to request the arbitrator.
He should have requested the arbitration. He should have told the arbitrator, sir, keep this application open. I will come and participate fully in the arbitration before you. I will also lead evidence. Please give me permission so that ultimately you may decide this also a question. My lord, how many times we have not had situations where we file applications under section 16? The arbitral tribunal says, sorry, I will not decide your section 16 now. I will decide it because it's to be
requires evidence.
requires evidence. He could have done it, but he didn't do it. Having taken a chance before the arbitral tribunal to get a finding that they are not parties to the arbitration agreement, even though they are not signatories. Today, because the order has gone against them, they can't come and say, no, please give me, keep this issue open. No, you took a chance. It can't be, my lord, innings in arbitration like this. Otherwise, section 16(6), my lord, I would respectfully submit will be putting it on its head.
Yes.
In fact, I'm given to understand, my lord, that is arbitration. They came and said, give us time, we want to file objections. They took time, participated fully, not once. I'm given to understand, my lord, that multiple hearings were held by the learned arbitral tribunal.
Mr. Basuraj, did you tell the tribunal that this is a fact-based doctrine and therefore I may be permitted to lead evidence on that?
It's not an application under section 16. Nobody invokes section 16. 16(2) arises if somebody questions the jurisdiction. If I am implemented now, I'll certainly go and attack the jurisdiction. There's no doubt about it. If such an issues arise, if it is answered against me, saying that yes, we have jurisdiction, that absolutely doors are closed. If the arbitrator say yes, we do not have a jurisdiction, then section 37 comes. Nobody writes section 16. It is not an appealable order under section 16(6) or under section 37. This is an interlocutory order impleading me based on the new doctrine of the group of companies. But the Honorable Supreme Court in Deep Industries said the inherent lack of jurisdiction, so far as I am not referable to section 16, inherent lack of jurisdiction in bringing a third party to the proceedings will be a ground. And if the order is perverse, I will demonstrate how the order is perverse. Is referring the order of the tribunal order. It is not the order of the majority. 2 judges ruled in their favor and 1 judge solved reason according to me ruled in my favor. The perversity is writ large in the majority judgment, and nobody invoked section 16. There is no interim award. There is no interim award which will be merged with the main award. Held is section 16. I need not even bother about section 16 because section 7 is invoked based on consumers. And if it's not page number 209, the application is under section 218. 7 of the arbitration. This is the application. It is not under section 16. Then it's not section 16, subsection 2. The arbitrator may rule on its own including ruling in any subjection with respect to the existence or validity of the arbitration agreement and further purpose next learn. They believe that arbitration tribunal does not have jurisdiction shall be right not later than the submission of the statement of the defense. However, party shall not be precluded from raising such a thing merely because he has appointed and participated in the appointment of the arbitrator. Then, party agreed by such an arbitral award may make an application for setting aside arbitral award in accordance with section 36 months. Now, sorry, 37. 37 is if the arbitrators declare that they do not have jurisdiction. Subsection 2, my lord, of section 37. An appeal shall lie to the court from an order of arbitral tribunal accepting the plea.
Refusing to refer the parties to
No, that is
arbitration, granting or refusing to grant any measure, setting aside or refusing to set aside an arbitral award.
34. No, it is once it is concluded. Next one, an appeal shall lie to a court from which an order of arbitrary tribunal accepting the plea referred to in subsection 2. Suppose if the arbitrators say that we do not have jurisdiction, or 3 of section 16, or granting or refusing to grant an interim measure under 17, no second appeal shall issue. If the arbitrators had rejected the application, their application, saying that we do not have jurisdiction so far as MDPL is concerned, that they should have approached under section 37. This is not an application under section 16, and there is no order rejecting the application and holding that they do not have jurisdiction. They say they have jurisdiction. Therefore, madam, attacking that they lack inherent jurisdiction so far as I am concerned. But what they are doing is, they are mixing the non-signatory being part of the arbitration proceedings and group of companies together and making some sort of a hybrid khichdi. What they should stick to, whether it is a group of companies which satisfy 3 steps: conclusion of the contract, performance of the contract, or termination of the contract. If your lordship see the majority opinion regarding performance, I will demonstrate how perverse it is. It simply says, okay, we have seen everything. Kindly similar page number.
What do you say about guarantee agreement?
There, my lord. I asked a fundamental question in the beginning. What do they want from me? Kindly see the undertaking given by me. Whether they are going to enlarge the scope of the agreement, they have not answered still. The avalanche of case laws ultimately end up in a fact-based doctrine of group of companies. The entire gamut of my performance is covered in the agreement. Now, can they enlarge the scope of the agreement? No. Can they enlarge my role under the agreement? Absolutely not. I've already surrendered myself. I said I'm bound by the agreement. Now, what happens is this. Suppose if I implemented.
You said even bound by the award passed also.
Yes. Now, 34 remedy may not be available to me. They should be thankful that I'm making this submission, because the moment I go, the first thing I'll do is I'll make an application under section 16 to questioning their jurisdiction, so far as I'm concerned. And I'll be able to satisfy the learned, all the 3 arbitrators, that they do not have jurisdiction so far as I'm concerned. Those doors are not closed because nobody has invoked section 16. I'll invoke them, I'll make the counterclaim, and I'm even question the validity of the agreement on various grounds. Apart from that, I only say that some sort of a wisdom should dawn and say there is an agreement. I am bound by all the terms and conditions incorporated in the JDA so far as revenue sharing is concerned, and I am bound by the arbitration agreement and the award under class 7 of the, and I cannot question it unless the arbitration award goes beyond this class, this agreement. Now, why should I participate? And
No, if you agree,
yes, ma'am.
which you said that you agree.
Yes, ma'am. Kindly say
That
class
you-
7. Class 7, ma'am, that
No.
answers all your lordship's question.
Not that.
I'm sorry.
You say, I shall be bound by the award.
Yes.
Whether I'm a party or not.
Yes.
Is it not sufficient for bringing you within the frame of arbitral proceedings?
No, why should I participate?
Don't participate, but you will be a party.
No, the reason is this. Tomorrow, there will be an ex parte award.
Therefore, you
Not-
should participate.
No, even if there are otherwise, the entire award cannot go beyond this agreement.
If that contention you can take up by your pleadings, because the liability is under the guarantee.
Even otherwise established, I've admitted, I've accepted
Guarantee
everything.
agreement you have accepted.
I have,
Therefore,
yes.
If they proceed and pass an award beyond your scope of responsibility, liability, that should not happen. For that, you have to participate.
No. If there is an award beyond the corporate guarantee, which I have provided, which
Yeah.
we have given, 34 is the remedy. Even if
That's
I'm not a
correct.
party,
Understood.
even if I'm not a
To
party.
decide whether the liability to be fixed under the guarantee agreement,
That is
that
is not
itself be
open
an
for
issue.
debate. That is not open for debate now. Not I'm making a submission against me. That is not open for debate so far as I'm concerned. That is not open for debate. Kindly say section, class 7 at page number 316. This is not open for any debate so far as I'm concerned.
Anyway,
I have surrendered lock, stock and barrel. This is the problem. And what more they want, can they enlarge the scope of the agreement? No. Can they enlarge my role in the arbitration proceeding vis-a-vis this agreement? The answer is no. And am I bound by the terms of the agreement? Yes, I am bound. Whether I am bound to perform certain parts of the contract of the GD agreement? Yes, answer is yes. Am I bound by the ultimate arbitration? The answer is emphatically yes. What more they want? Not,
Then where is the grievance against?
the grievance is, why should I, not, I will not,
Don't go.
I do not want to, why should I participate in the arbitration?
Don't
proceedings?
participate.
No. No, not that, voluntarily staying away from the arbitration.
Basavaraj,
No, it's
you are
voluntarily.
saying that my client will be bound by the award in contemplation. May be in your favor, in their favor, or against them also. If that is so, how you are aggrieved by the order now passed? Where is the grievance?
They make me to undergo the trauma of the
No, you don't
arbitration
go.
proceeding. No, that is a different thing. That if the honorable arbitrator say that you are a necessary party, we impleaded,
No, you
say that
impleaded.
I will not participate, my lord, it will
You will be
be
placed
bit
ex parte.
arrogance on my part. It will be arrogance on my part to say that I will not participate.
No, you will be very wise. It's
No,
not
no.
arrogance, wisdom.
That not be necessary. The reason is, why should I be impleaded?
No, you are saying you will be bound by the award and now
That's what
you,
I'm telling.
how can you
If
take
I
up-
am bound by the award, for example, if I am bound by the award, for example, in a civil suit, is it necessary to implicate all the guarantors as defendant? The answer is absolutely no. Because in the execution procedure, they can always go against the guarantor. How my role in the agreement or my position in the agreement different from the guarantor? The only guarantee which I have given is monetary guarantee. It is not, except I have given the financial guarantee, not the performance guarantee. Of course, here in this case, performance guarantee and financial guarantee is same because they are entitled for
They are
revenue
mixed
sharing,
with
not the built-up area. That is the problem. So even if I am not there, I am bound by the award that's going to be passed. I am bound to honor certain terms and conditions of the joint development agreement. I am saying that why should I be made a party to the proceedings? Not that why should I participate? I use the wrong word. Why should I maybe a party to the proceeding? Just joining me into the boxing ring and smear the dust. That's totally unnecessary. I'm not talking about the cost involved. I'm not talking about the legal expenses. No, I can stay outside and whatever they say, I'll say yes.
But what we feel that one who says I will be bound by the decree, he cannot say I will be bound by the decree and therefore don't implead me as a party.
No, what I'm saying is their grievance is safeguarded. Why they want to invoke group of companies is that an element of performance or there is no termination of contract. There is an element of performance.
All that goes now by your stand. Your stand is
Performance.
I will be bound by the award.
Yes. Why? The reason is
How you will be, we have not understood how you will be aggrieved by your name figuring in the cost title. Nobody is telling you to go and defend. Even otherwise also, you are not going and defending.
the reason is this.
What is
Not
the
even
defamation
saying-
that
I'm
you will
not
suffer?
even saying necessary a party or proper. I'm nobody so far as arbitration.
No, you are a
proceedings
most necessary party because you said, I am bound by the award.
I'm bound by the award once it is passed.
Therefore,
My role will come into picture the moment order arbitration. I will read the terms and conditions specifically says moment the liability arises after payment.
You are
of-
liable.
A moment the payment is made to Pyramid Finance to the extent of about 650 crore, my liability arises until today. Admittedly, there is no default on the part of CVPL. There is no default on the part of MDPL. Nobody has committed default. What they have done is, they have suppressed certain things. What they have done is, they induced me to hypothecate my property along with ISKCON property and there is one BNS Hari property and we all entered into agreement and we borrowed money. Subsequently, they have filed a civil suit questioning the very hypothetical.
ಕಲ್ಲೇಗೌಡ ಮಲ್ಲೇಗೌಡ ಎಲ್ಲಿ ಲ್ಯಾಂಡ್ ನಿಂದ ಬಂದ್ರು ಪಾಪ ಸಾಕಾಗಿದ್ರು ಹೊಲ ಹೊಡೆದು ಸೈನ್ ಮಾಡ್ರಿ ಅಂದ್ರು ಮಾಡಿ. You are a company.
No, I'm not
You
saying
are a
that.
name.
No, what I'm saying
Brand
is
name
they
in
filed,
construction
no,
industry.
they have filed a civil suit now. It is the other way. They signed with all their,
Juristic person.
they signed the hypothecation deed with all their censors intact. Now they have filed a civil suit questioning that, oh, hypothecation deed was vitiated by fraud, misrepresented. I have not questioned. They have filed a civil suit. I have not filed a civil suit.
All right, but at least you make your stand clear by filing a memo that whatever you
No,
said
class
now.
7. Class.
No, let your
No, memo may
record
not
file
be
because
necessary.
you have said it is on record now. It is being relayed to the world at large, where you have repeated, I am bound by the award.
That I will read couple of paragraphs from this corporate guarantee.
Mr.
And
Basavaraj, we are asking you, whatever you have said is already there.
Yes.
On the everything is ಎಲ್ಲ ಜಗತ್ತಿಗೆ ಬಿತ್ತರಿಸಿ ಆಗಿದೆ.
Live stream.
ಹೌದಾ? It's on online. We are seeing whatever you said. Write it in a
I'll
memo.
put it in the
Give
in the
it
form
to
of
us.
written arguments I'll put.
Who will,
In the form of written, absolutely no undertaking from the client. We'll put it in
undertaking
the
ಅಲ್ಲ, ನಿಮ್ submission ಅನ್ನು
Certainly,
ಹೇಳಿ
certainly,
ಅಂತ
yes,
ಹೇಳಿದ್ವಿ
yes,
ನಾವು.
certainly, in the form of written submissions I'll make. Certainly, Vinod.
All right.
What my learned friend said, well, I have said so many times what the arbitral tribunal has held. In fact, he is the petitioner. He ought to point out what the arbitral tribunal has said. He has not done it and I will do it. Because I want to show that the arbitral tribunal has applied the right.
No, I want to, I'm sorry,
One
I
minute,
apologize,
in
I
the-
apologize. I wanted to read that.
Matilwala, you have not shown
I
the.
did
ಅಲ್ಲ, ನಾವು
Ah,
ಸಾಕು ಅಂತ.
And I can show
No, no, I'm not
perversity
finding
right
fault
away,
with
right
you.
away I can show the perversity.
I'm not finding fault with you. I'm saying, ತೋರ್ಸಿಲ್ಲ ಅಂದ ಅಷ್ಟೇ.
Sir, ಈ ಗುರುಗಳು ನಮ್ಗೆ
ನಾನ್ ನಿಮ್ಮನ್ನ
that he has a great regards for me, for the work the academy has done.
No, my lord, just one paragraph in the latest judgment of the Honorable Supreme Court on this. Kindly see page 26, para 80. Therefore, considering the complexity involved in the determination of the question whether SRG Group is a veritable party to the arbitration agreement or not, we are of the view that it would be appropriate for the arbitral tribunal to take a call on the question after taking into consideration the evidence that we have adduced by the parties before it and application of the legal doctrine as elaborated in the decision in Cox and Kings. But the square point, my lord, is they could very well have come and told the arbitral tribunal, sir, I will participate in the proceedings. Don't make me a party. Please decide this question at the ultimately. But they did not do it. Today they cannot come and say, leave it open.
No, ಅವ್ರು ಹೇಳಿಲ್ಲ. ಅವ ನಿಮಗೆ ಕೇಳಿದ್ವಿ. Legal. Say that.
I'm sorry. Then I'm
Wanted to.
then no, but that,
ಏನು ಬೇರೆ prima facie ಹೆಂಗ್ hold
ಇಲ್ಲ, ಇದು prima facie ಅಲ್ಲ. Because they wanted a full-fledged decision of the Honorable Tribunal. They could very well have said that, but it is not open for them even to adopt that course. And I want to answer that one point that my learned friend mentioned, that this is not under section 16. My lord, maybe section 16 has not been mentioned, but kindly see, my lord, the very important aspect that my learned friend has pointed out. Please see section 16. my lord.
16(2).
No, my lord, please see 16(1), important. Completely covered by section 16. Maybe, my lord, in a property we may not invoke a provision, not invoke a provision, invoke a wrong provision. That does not determine the character of the application. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with respect to the existence of the arbitration agreement. And interestingly, my lord, section 16 does not talk about an application being filed at all.
Tribunal itself has to.
Yes. And subsection 6 says a party aggrieved by such arbitral tribunal, arbitral award, may make an application setting aside such an arbitral award in accordance with section 34. And what is an award, my lord? Final determination. Where else did the arbitral tribunal get the jurisdiction to decide on the question as to whether MDPL is a party to the arbitration agreement or not? In other words, existence of an arbitration agreement between the claimant on the one hand.
16(1) is
16(1).
attracted. Read with 7.
Read with 7. Exactly, my lord. And their
All.
objection is under 16(3).
All.
Therefore, to say that 16 is not applicable, my lord, yes, where else does the arbitral tribunal get the power now?
All.
So now, my lord, that I finished on the law. Can I quickly, in a matter of 10 minutes, run through the order passed by the, because I'm prefacing my submission by
Yes.
saying your lordships are not sitting in appeal.
Yes.
Is a writ jurisdiction. So may I just quickly take your lordships, my lord, to the award itself. Please be kind enough to take my note itself, my lord. I don't think I need to trouble your lordships. Kindly turn to page. Okay.
Your note,
Yes, no, no.
the one which hitherto you referred, that one or
No, my lord.
the
Your
small
lordships may kindly take the writ petition for a minute.
writ petition?
Yes, my lord. And the order of the tribunal is at page 22. My lord, as your lordship sees, my lord, the arbitral tribunal comprises of 3 learned arbitrators, and as my learned friend rightly indicated, 2 of them
2:1.
ruled in my favor, 1 held
2:1.
2:1, and by the provisions of the Arbitration Act, the majority
becomes.
prevails. That is, now, my lord, I will straight away take your lordships through the, kindly turn to para 10. At page number 30.
The core issue.
My lord, and I want only to say, my lord, in paragraph number 7, their entire objections are recorded. I will quickly read this, my lord, so your lordship knows what is their dispute. Mr. So-and-so, learned senior counsel appearing for the proposed respondent MDPL, on the contrary, has elaborately made submissions containing that the claimants have filed a misconceived application by wrongly interpreting Cox and Kings in order to include the proposed respondent as a party to the present arbitration dispute, which is outside the scope of the JDA. He has submitted to this tribunal a detailed submission trying to distinguish Cox and King's case, but drawing our attention to various paragraphs of the said judgment to show how the said case is not applicable to the present arbitration proceedings. He states that MDPL's role is limited to the framework agreements and as a guarantor under separate loan agreements, and the same does not warrant its inclusion as the additional respondent to the present arbitration proceedings. He further states that no such intent and conduct has been made out by the claimant as mentioned in Cox and Kings. His main argument was that none of the factors as laid down by the Honorable Supreme Court in the discovery case to invoke the group of companies doctrine were present in the instant case. Firstly, he contends that there is no clear mutual intent between the parties to bind the non-signatory to the arbitration agreement, but on the contrary, there is clear intent of the party to sever from any rights and obligations of the JDA. He further contends that mere extension of secretarial practice of facilitating certain correspondence between the parties, we do not deal with the aspect of the execution of JDA, and securing funding by extending a conditional guarantee does not amount to mutual intent of the parties. I may tell you, lordships, my lord, MDPL went to Piramal and said, please give me a loan because I have this project going. And the money was not taken generally for MDPL purpose. They went and specifically said, I want this money for the purpose of this project. That is the extent of their involvement. And not 1 rupee, 2 rupees, but not 650 crores they borrowed from Piramal. And specifically saying that this is the project for which I want money. I showed your lordship the document, my lord. Firstly, he contends that there is no clear mutual intent between the parties to bind the non-signatory to the arbitration agreement, but on the contrary, there is clear intent of the parties to sever from any rights and obligations of JDA. He further contends that mere extension of secretarial practice of facilitating certain correspondence between the parties, we do not deal with the aspect of execution of JDA, and securing funding by extending conditional guarantee does not amount to mutual intent of the parties. Further, he contends that there is no such commonality of subject matter in the activities of the parties and MDPL, and state that there is no role of MDPL in the said JDA, as the rights and obligations have now been transferred to CVPL under the second supplementary agreement. And I may point out to your lordship, that I will show you a document where they say CVPL is an SPV, a special purpose vehicle which we have created for the purpose of this project. The moving spirit behind the whole thing was MDPL. Not incidental, someone correspondence comes from them. He further contends that all of the 5 tests as laid down by the Honorable Supreme Court in discovery case has to be satisfied in order to invoke the group of companies doctrine to apply the ratio of that case to the case on hand. And since none of the 5 tests have been satisfied by the claimants, MDPL cannot be impleaded as respondent number 2 in the present arbitration proceedings. Then, my lord, further contentions are all considered. I'm going to skip that. Now, my lord, come to para 10.
Core issue.
The core issue that falls for our consideration is whether MDPL, being a non-signatory to the JDA dated 29/9/2010, can be implemented in the present proceeding as a proper and necessary party. The Honorable Supreme Court, my lord, then they consider Cox and Kings. I'm going to skip all that, my lord. Your lordships have seen it in great detail. Then come to the, my lord, Cox and Kings is considered in great detail, my lord. I'm going down, my lord. Please come to paragraph number 14. It is important for this tribunal to consider all the relevant transactions that took place between the parties since 26/6/2010. That is the date, my lord, on which the, I think the date is wrong. It should be, that was the first, the first MOU, my lord. 26/6/2010 is the first MOU. It preceded the JDA. Between 26/6/2010 to till date as a whole in its entirety and not in isolation. It is very clear from the bare perusal of all the agreements relating to the development of the project and the JDA and all other ancillary agreements referred to supra which were executed thereafter to facilitate the execution of the project that the parties to the transaction are common and that they have voluntarily involved themselves in the said transactions with a complete knowledge of the respective rights, duties, and obligations of the respective contracts. MDPL, being the parent company of CVPL, has from the inception been involved in the negotiations with the claimant to develop the said land. No doubt MDPL, in terms of clause 4.4, with supplementary agreement, provided that this second supplementary agreement does not amount to waiver of the rights, conditions, accuracy of representation, or any other term of the agreement, it so and so, and the representation made in the supplement. However, in the same second supplementary agreement, at clause F, it is seen that MDPL has nominated CVPL. It's only a nomination. Well, there's content in the document which is signed by them. Nominated CVPL to take on the rights and liabilities of MDPL under the framework agreement, but the actions and conduct of MDPL did not end in the year 2010, but continued till the year 2023. This would indicate that it has actively participated in the execution of the project as per the terms and conditions of the JDA and has tried to provide financial support for the execution of the project. In the given circumstances, clause 4.4 has not severed the relationship as argued by the learned counsel with the respondent. This argument does not appeal to us. Then, my lord, the financial support rendered by MDPL to the respondent as an obliger and guarantor may be through separate loan agreements and corporate guarantees, but the goal meant to be achieved by MDPL through such loan agreements aligns with the terms of the JDA, which is to complete the said project. This is commonality of intent. MDPL, being the original intended developer, after its severed relationship with the claimant, should have taken a back seat once it nominated CVPL to carry out its roles and duties under the agreement. But that has not been the case of MDPL, as it has continued its relationship with the claimants, as can be seen from the various correspondence and the various meetings which were held at the instance of MDPL with respect to the said project under the JDA. This has led to the claimant to legitimately believe that MDPL is a veritable party to the JDA, and all such positive and direct involvement of MDPL over the years has only strengthened such belief. Your Lordship saw that paragraph where they say, were you led to believe? Yes. The legal contention urged by C so-and-so for the proposed respondent, MDPL, was only offering services to CVPL and the communications meetings were in furtherance of the same cannot be accepted, as the invoice document submitted before this court is of the year 2017-18 and the same has been categorized as marketing, administrative, engineering costs also. The said service has no connection with the official communications and meetings held by MDPL with the claimants from 2011 to 2023 with respect to the execution of the project. MDPL and CVPL, being part of the same corporate group, have attracted the group of companies doctrine not because of mere ownership, but for satisfying the cumulative conditions as laid down by the Honorable Apex Court in discovery case. My lord, therefore, my lord, to say that the Honorable Arbitral Tribunal has simply applied the group of companies doctrine and therefore made MDPL a party is not correct. The Honorable Supreme Court of India in the above case has referred to circumstances. I'm going to skip that, my lord. We have all read it multiple times. Now, my lord, para 18 is very important.
Mutual intent of parties.
Yes, yes.
Distinct findings have been.
Everything has been considered. All mutual intent of the parties, relationship of non-signatory to a party which is a signatory to the agreement, commonality of the subject matter, composite nature of the transaction, performance of the contract. Now see para 19, my lord. These principles having been set out, the Honorable Tribunal applies the facts of the case to these principles. The tribunal, after carefully examining the material facts in terms of the agreement and MDPL's actions and involvement in the execution of the project and the JDA, and the ratio laid on the Honorable Apex Court in the cases referred to Subra, upon which strong reliance is rightly placed upon by learned counsel for the claimant, which case laws are aptly applicable to the facts issued in support of the claimant's case, whereas the legal submissions made by so-and-so with reference to the elaborate written note and distinctions ought to be drawn by him by inviting our attention to various paragraphs of the Constitution bench decision in the case of Cox and Kings, cannot be accepted by us as they are untenable and misplaced on the facts of the case. The tribunal is of the opinion that MDPL, even though a non-signatory, has by its action and conduct consented to the be bound by the arbitration agreement. The facts of this case, as referred to in above paragraphs, will comply with all the 5 tests laid down by the Honorable Supreme Court in discovery and approved in Cox and Kings. Therefore, application filed by the claimants under 21H read with section 17 to implead as respondent is hereby allowed. And then, my lord, the other are arbitrary defense. Now, if it is required, my lord, if your lot thinks it is relevant, I can point out the documents which are before the tribunal on the basis of which they came to this conclusion.
Which are prima facie just.
Prima facie, my lord, in the note. Please look at the note, my lord, that's enough for me. For the purpose of ease, my lord, I put it in the note itself. Kindly see Roman 3 at page 7 of 15.
Suppose if I consider all your arguments on merits, I'm asking this to both of you, and come to conclusion that the order is perfect, whether you can take up it as a ground under
Yes.
in appeal.
I would say yes.
Even when
I would say
we examine.
Yes, yes. Because
On merits.
your lordship's jurisdiction, your lordships are looking at it only as an extension of section 16. And 16.6 says. I'm not for a moment depriving an opportunity for him to look at it. In fact, my lord, that's my thinking, my lord. Subject, of course, my learned friend is the
What
best
I have done,
person,
I'm
best
sorry,
advisor.
what-
In fact, the best course would be, my lord, to simply not get any finding from your lordships on merits. I don't know, my lord. Maybe your lordships holding me in my favor or against my learned friend, that's a different matter. But now that the arbitral tribunal has come to a finding, 16.6 is available to them, not that they are shut out. They can always.
Our anxiety is, in the event we examine all that and record a finding that this order is perfect, whether that will stop him from challenging those findings when he
My lord.
suffers the award.
As an officer of the court, not as a lawyer appearing for this party, I would say, my lord, section 16
still open.
remedy is still open. That's how I understand the law, my lord.
But I can question the jurisdiction of the arbitrary tribunal with reference to section 16(2). But again, the word used is party. Party is defined into section 2H as a party to the arbitration agreement. That is the word used. So party means not just a party with reference to the so-called group of companies and all that. Party in 16(2) is defined as a person who is a party to the arbitration agreement.
Yes.
Now, my lord, Paris, in my note, I have referred to the documents. I will not detain your lordship for too long on the document. I just show it, my lord. If then, my lord, I will rest my case. Kindly turn to page 7 of my note. At para 16, my lord, Cox and Kings is referred. I'm not going to trouble your lordship. Now, my lord, please see para 17. Therefore, my lord, did I?
17. Therefore, mutual
Intent is established by considering relationship between legal entities, involvement of non-signatory in performance of contract, commonality of subject matter, composite nature of the transaction. In the present case, arbitral tribunal has rightly concluded that MDPL has shown mutual intent by involving itself in negotiations, communications, meetings, execution of loan agreements, and corporate guarantee. Now, what am I saying, my lord? Admittedly, now first I'm analyzing each of the factors. Relationship between
wholly owned subsidiary and one kade admission.
Mondo. There's no doubt about it. That my learned friend agreed. Your lordship recorded it the other day.
No. It's the other way. The Supreme Court says in Cox and Kings merely because of holding company.
That's not what I'm saying. That it is a wholly owned
Yeah.
subsidiary ಅಂತ ಅಷ್ಟೇ
That's
ಹೇಳಿದ್ದು.
not the criteria.
ನಾವು party ಅಂತ ಹೇಳಿಲ್ಲ.
Yes, sir. Sorry.
Relationship between non-signatory MDPL and signatory CVPL. Admittedly, and as per financial statement of CVPL is a wholly owned subsidiary of MDPL, with MDPL holding 99.99% of the shares. We have referred to the document, my lord, which we have produced along with the statement of objections. This is acknowledged as a 7th schedule to the loan agreement executed between Piramal Group. It shows that MDPL holds 99.99% shareholding and directors of MDPL holding the remaining 0.1%. It is a case of MDPL itself in the written submissions filed before the arbitral tribunal that CVPL was nominated since it is a special purpose vehicle of the Mantri Group. Now, that's critical. Then, my lord, the registered address of CVPL.
Same anta.
He is the same as the registered advisor of MDPL, as seen from the writ petition itself. Even in the present transaction, 2010 agreement and first supplementary agreement were executed by MDPL, and MDPL only nominated CVPL, thus disclosing a legal relationship between them. Then involvement of the petitioner in the performance of the underlying contract. As per Cox and Kings, I'm skipping that one out because we have already shown it to your lordship. Now kindly turn to para 24. MDPL was involved in the inception and conceptualization of the project, in execution of the 2010 agreement and the first supplementary agreement. Nomination of CVPL was purely for the sake of optimization and convenience. Arbitral Tribunal has rightly noted in para 14 of the impugned order that though the petitioner had nominated CVPL, its actions and conduct regarding the project did not end in 2010 and continued till date. Unlike ICF, ISCON, and so and so. The continued involvement of MDPL is demonstrated below. Now, what is it, Ballot? From 2010, MDPL invested a significant amount of rupees 20 crores in the project through the 2010 agreement and the first supplementary agreement. 2. Negotiations pertaining to the project and JDA were all done by MDPL. Recitals of the JDA itself narrate the involvement of MDPL in the project. Clause 23 of the JDA specifies that the name Mantri and the logo of the petitioner will always remain in the project. 3. Shortly after execution of JDA, MDPL issued a letter to home buyers of the project, revealing that it is MDPL which is constructing the project and taking bookings as well. Third parties, they went and said, yes, we are the ones, we have a brand name. MDPL specifically states
But that letter was not before that.
No. We have mentioned it, Madam. We have already said that, Madam. It was not. It was not. Now, in fact, Madam, I'm not really. I understand, Madam. Some document which is not before the tribunal, I can't rely upon. I'm not. Email communications in November 2010 show that it was MDPL who was involved in negotiating and finalizing the FSI sharing agreement under the JDA. One of the things was how to share the property, the income, which portion goes to me, which portion goes to them. Then 2018, email communications show that MDPL was giving regular updates about the project, including inventory, cash flow statement, revenue share, etc. Annexure R14. The draft of the fourth amendment to JDA and MOU were also negotiated by MDL. This clearly shows the involvement of MDPL in performing the JDA and ensuring completion of the project. It was MDPL and specifically Sushil Mantri, which was negotiating the loan agreement and inducing GSPL to provide security. Securing loan agreements facilities is the obligation of CVPL under the JDA. In furtherance of the completion of the project and the performance of the JDA, MDPL also gave its property as security to lenders. The Piramal loan agreement was also executed by MDPL as a party obligor to it. The same person has signed on behalf of both CVPL and NDPL. That's an important thing, Lord. Loan agreement, both are the same person signed.
600 crores.
Yes. Ide. Under clause 18.1.47, Piramal loan agreement, MDPL undertook to complete the project alongside MEPL, and the project is this. This is clinching. As recognition to its obligation as JDA, MDPL even gave a letter of undertaking to complete CVPL's obligation under the JDA, including payment of GSPL dues. We have put all that. All this was before the arbitral tribunal. 2020, it was MDPL and its representatives who were involved in negotiating with GBPL on the Swami Fund loan. There was another loan that had been taken, my lord, from SBI. 300.
ಈ letter ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ರು?
Yeah.
MDPL, he gave a letter of undertaking to complete CVPL's obligations.
To whom was it?
It was given to whom?
To whom was it? To us. To us. I showed that letter, man. I showed that letter.
This is in addition to guarantee. Is it in
No, I-
addition to
I will just-
guarantee?
Where is it?
Huh?
Prior to that,
Prior
everything
to
was
guarantee.
culminated in the.
No, do you dispute this letter?
No, it is not disputed. It is issued
Not
by.
disputed.
My lord, it is annexure R.
Issued by-
My lord, it is annexure R17 at page 296 of the
ಈಗ
statement of.
ಎರಡು ಪಾರ್ಟಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ಮೇಲೆ ಯಾವ್ದನ್ನ ನಾವು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತೇವಿ ಯಾವ್ದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಲ್ಲ ಅನ್ನೋ ಬಗ್ಗೆ ಏನಾರ ಸ್ಟೇಜ್ ಇರ್ತದನ ಅಲ್ಲಿ?
ಆದ್ಮೇಲೆ ಅದು ಎವಿಡೆನ್ಸ್ ಮೇಲೆ ಇವಾಗ ಮಾಡ್ಲಿಲ್ವಲ್ಲ ಅವರು ಇನ್ ದಿ statement of objections before the London Arbitral Tribunal in response to the application order 1 rule 10, they could have said sorry. Impleading application, I'm sorry, I use order 1 rule 10, that doesn't apply. To impleading, they could have said sorry, none of this is
But
applicable.
I'll clarify that. Pursuant to this application being allowed, they have filed the application for amendment. Amended petition itself them
Not
filed.
yet. You know,
Yes,
ಆಗಿಲ್ಲ
yes,
sir.
yes.
ಇನ್ನು application
Sir, served on us.
application
Sir.
ಹಾಕಿಲ್ಲ.
ಆಗಿದೆ served on us.
Hearing ಆಗ್ಬೇಕು ಅದ್ರ ಮೇಲೆ.
ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಅಮೆಂಡ್ಮೆಂಟ್
Amendment of the.
ಅಲ್ಲ, ಇದು ಇಂಪ್ಲೀಡ್ಮೆಂಟ್ ಅಲ್ಲ.
I thought that is over.
Say
Now
is-
second.
No, did you dispute
No, ma'am.
the documents which they had produced
No.
in their impleading application?
No, it was issued by Mr. Sushil Mantri. It was not issued by MDPL as such. And this was prior to the corporate guarantee which.
The genuineness of the
Nothing
document
is,
is
we are not disputing
not
anything.
in dispute.
No, no, cannot. We are not disputing anything.
Lord, kindly, so who has signed it, my lord? Please see page 296 of our statement of objections.
He himself.
He himself has signed it. And he signed it for monthly developers.
Same person
Same person signs also for CBPL.
while taking loan also.
Yes.
No, no.
Yes, I will show. No, anybody. Yes, sir.
That's true.
But I stood as a guarantor for all their loans.
You borrowed
Even the
money.
SBI.
No, you are a
Loans.
borrower also because you are a signatory to the loan
We are not the
document.
borrower. What we
Yeah,
have done
but-
is,
you are the
we
borrower.
have
Your capacity, in dual capacity, you have signed it.
That's why they are using the word alter ego.
That's.
The properties of MDPL are also hypothecated.
My lord, they borrowed money.
Only CVPL, no, I just clarify this. CVPL is not a special purpose vehicle only for. this.
You have
It
said
was
it.
established in 2001. The agreement is in 2010. Earlier it was as landmaster, then it became castle with it became
But
monthly.
it exists as it is, that you have admitted.
They took different avatars from 2001
No, no,
ultimately.
ಇಲ್ಲ, ಒಂದು ನಿಮಿಷ sir.
I'm sorry.
Now you are now saying that CVPL is not a special purpose vehicle.
No, you have admitted it.
Clear opposite stand at the
What I'm
stake.
saying
With
is,
arbitral
it was
tribunal.
I
created
get
for
it.
this purpose. It was created in 2001, established in 2001.
Correct,
Maybe.
but
Not for,
continue till end.
that's,
Unlike his client, where they stopped certain act.
Yes.
But you continued ಅಂತ record finding ಇದೆ.
we have
also.
And their stand before the London Arbitral
That
Tribunal,
one.
not that it is the SPV. ನೀವೇ written submissions ಹೇಳಿದಿರಿ.
if it is
Anyway.
created only for the purpose of executing the joint.
There were many other transactions also, and therefore it was as a common special vehicle, it was.
One.
ನೀವು ನಂಗೆ
Normally SPVs are created immediately after the joint development agreement or a major project is awarded to them.
But you have said it. You have taken the plea. I didn't say it. It is your stand before the arbitral tribunal, sir. Sir, my lord, your lordship may kindly see page 296. I'll just show that document, my lord. Page 296, exhibit R, annexure R17 with the statement of objections.
R17 is the letter undertaking.
Yes, given by MDPL. Yes, my lord. I'll read it, my lord. Your lordship may not trouble. I'll read this letter. To address to us, GSPL, subject registered joint development agreement dated so and so for development of Mantri Serenity was the name of that project. It was a project. my lord.
R5 was subsequently renamed.
Yes, correct. Yes, that's true. That's true.
Yes.
Is a project, my lord, belonging to in Kanakpura, my lord. They have a Krishna Leela project in the Martha. So that was the point. Registered joint development agreement dated 29 September 2010 for development of Mantri Serenity and amendments thereto, and the memorandum of understanding dated 2/6/2018 between Mantri Castles Private Limited, Gokulam Shelters and Krishna Leela Park. Letter of undertaking. Letter of undertaking from Mantri Developers Private Limited. This has reference to the obligations of MCPL under clause number so and so in MOU, in terms of which MCPL has agreed to obtain letter of undertaking from Mantri Developers with regard to the said obligations. Pursuant thereto, MDPL hereby irrevocably agrees and undertakes as under. During the subsistence of the existing security, including without limitation security over the sale proceeds from the project, MDPL will ensure payment of GSPL dues up to an extent of 35 crores to GSPL and KLPF. The amounts due as per clause 3.4.1 of the MOU will be paid from out of the sale proceeds with the consent of the financier, other funds of MCPL or MDPL. In the event of MCPL fails to make any payment to GSPL and or KLPF under the Serenity documents, MDPL as the original intended developer of the project undertakes to pay the same to GSPL and or KLPF as a case may be.
All.
And signed by whom? For Mantri developers by Sushil Mantri. Same person. And whether how much they are liable, to what extent they are liable, is it limited, is it unlimited, are all matters that has to be considered on merits before the learned arbitral tribunal. They can come and say, no, my liability is limited to the corporate guarantee, or my liability is limited to this amount. They can say it.
All.
This is the, and we have, even as of 2023, we have put all that, my lord, I'm not going to detain your lordship. Everything, and commonality of subject matter, my lord, is also there. And para 31 is very relevant, my lord. How many agreements have been signed? As rightly recognized by arbitral tribunal in para 14 of the impugned order, what that MDPL has executed several ancillary agreements essentially towards performance of the JDA. One is pyramidal loan agreement, escrow agreement, letter of undertaking, deed of hypothecation, memorandum of deposit title deeds, corporate guarantee. My lord, whether the liability is limited, unlimited, to what extent, these are all matters to be decided by the arbitral tribunal.
Para 31 you have read now.
Yes.
Yes. All. Want to say anything? Yes.
I started with the submission. What is the status? But I started with the statement as to what is the response to the corporate guarantee. They have not answered till now, what is my role in the arbitration procedure? Will it be enlarged, or whether the obligations undertaken under the corporate guarantee will be enlarged during the arbitration proceedings? And the reason for my involvement in the arbitration proceedings, especially when I specifically said in clause number 7 that I am bound by the arbitration award. Till now, they have not answered, except, my lord, the culling out the provisions, the legal principles in Cox and Kins, and also all this document. None of the documents are disputed. The entire gamut revolves around the corporate guarantee. The corporate guarantee is specifically undertaken. I am bound by certain clauses of the agreement and also the award. Beyond this, whether the role of the MDPL will be enlarged in the arbitration proceeding, and beyond this agreement, what are they going to do in the arbitration proceeding? This question is not answered even now. Therefore, my lord, if I make a submission on Wednesday, yes, we are ready to proceed with the arbitration and being a party to the arbitration proceedings. Lord, we may seek liberty to take all contentions available to CVPL, including the counterclaim, including questioning the jurisdiction, not with reference to the group of companies. It may be concluded with the judgment of your lordships if it is on merits. But under section 16.2, I can question the jurisdiction of the arbitrators. I can make the counterclaim, and I can attack the hypothecation need which they have attacked, and also question this agreement on many other grounds. If these liberties are given, I may concede on Wednesday that the order of the majority of the arbitrators may be confirmed. I'll make the submissions on Wednesday. Subject to the liberty of taking every one of the contentions available on earth. That's why I said, if I enter, as I said,
I had to straight away concede to what my learned friend is saying.
yeah, that is why I said,
Every one of the conditions available at the surface of this earth, provided within the four corners of law.
That's why I said it will be
no difficulty.
bull,
how can I oppose it, my lord?
Bull entering the China shop, but they take the risk, will enter.
You want to make submission on Wednesday?
On this submission, whether we will straight away concede.
Yeah.
Because it may be in our interest also sometimes that
Just
we'll discuss.
think and come back. Because
Certainly.
once if we write, we do not know how far that will be, how far the 34 or 37 court will
yes.
ignore our findings.
So with
We
this
do not know.
corporate guarantee, I may not be able to challenge 34. Now once I enter, 34 is available and every other avenues are available now.
All right. Just for further
So we are
hearing-
concerned, my lord, we have filed our written submission
Yes,
and everything.
we
So,
have
my lord, we have done.
further hearing on
Good.
this.
Wednesday, no?
Ah. Yes. Yes. Yes, sir. Yes. Yes, Mr. Secretary, why court orders are not being implemented? Madam,
Wednesday.
come to.
My lords, this is with respect to absorption of a part-time lecturer, my lords, and there was in the writ petition, the conditions of the absorption rules were not satisfied. But in writ appeal, we have lost the case, my lords. So, my lords, since the conditions, the three conditions which were in the absorption rules, two of the conditions were satisfied, my lord. One condition was not satisfied, my
But you
lord.
have
But
lost
after
the appeal.
Yes, yes, my lord. We lost the appeal, my lord. After we lost the appeal, my lord, we consulted with finance internally, my lords. The issue is, my lord, this has huge implications in other cases, my lords, because
But all contentions were available in appeal.
my lords,
May make this submission. It was an inadvertence on our part not to have brought to my lord's notice what actually were the facts also, my lords. I have requested the officer, the government to give me permission to file a review so that I'll satisfy my lords as to why the.
When that order was made.
My lords, this was made
June, my lords,
June
June.
24, my lords. There is a delay on our part. I will not
You-
even shy away from accepting the mistake on our part, my lords. My only request is, my lords may grant me 3-4 days time. By Wednesday, Thursday, I'll have the review filed. I will come before my lords as to explain as to what exactly was the mistake from our end, not bringing it to my lord's notice as to what exactly was that. Only with that intention.
yes.
They kept quiet for so
All this. Difficulty. They're saying we do not know. Sometimes it happens because everything secretary will not be able to, they will have tremendous pressure.
Yes.
We understand that. Call this matter on Monday. Monday, madam. Monday next, 17th.
Please, my lords.
17th.
Do we come back at
Thank you for coming and.
Yes, my lords.
Thank
This
you, my lords.
presence, my lords.
About
Great.
Ali. Then we will not pass this order.
No, my lords, I'll
Yes.
come back.
Ah,
Grateful.
Where is the principal secretary? Yes. Call. What was to be done?
There are 6 notifications
Ah, since 2000.
since 2000.
Yes. Please explain, madam.
Not judgments.
But in this 2000, one case was filed against the notification, my lord, which was pending till 2009, my lord.
Leave the secretary. They will have first-hand
Yes, ma'am.
information.
Yes, my lord. Yes, my lord.
Please, madam.
Okay.
Yes.
My lord, the submission here is, sir, we have the 2001, the backlog orders came to fill up the backlog orders. They have made attempts in the past, 2000, 2002, 2004, they've made different notifications. At that point in time, they didn't have any participation. So eventually, I have that information between 2004 to 2012. Between that period, we're not very sure what happened. But after the 2012, they have notified. But there was an issue here, sir. What has happened is, at that time, the KPSC was not identified as the appointing authority. They had something called a Salaha Mandaliya advisory council or an advisory body. They have created some discrepancies in the sense the lecturer post was identified for a particular subject, but they went ahead and identified somebody else. They shortlisted somebody else without that particular subject qualification.
ಒಳ್ಳೆ cyber judgment, ನಂದು ಒಳ್ಳೆ cyber judgment ಇದೆ. Have you seen this judgment of Honorable Chief Justice? Just face this.
Can we come back at
That was
2:30
very,
on Wednesday at 2:30?
very, if somebody has, no problem, no problem. Wednesday, 2:30.
Backlog basis, no? After this.
After this, what happened?
Sir, yes. After this 2022-21, sir, all the previous notification was cleared. They said there were a lot of discrepancies. They have taken opinion of the law department and the DPR at that point in time. And 2021, we resolved, we will go ahead with KPSC recruitment through KPSC. But inherently in the C&R, there was no provision for KPSC being appointed as the selection authority. So the KPSC, though we submitted the file in 2022 April to KPSC, they said these discrepancies have to be fixed and then send it back to us. And second observation was we had not done a reservation for a disabled category. That was also not fulfilled at that point in time. I think the act came eventually and that also had to be fulfilled.
Within what period this will be done?
Sir, already now the draft notification of the C&R, new C&R is issued. As per the Honorable Court permission, we have done it, sir. Now we have got some 27 objections. We have resolved that also. We feel 1 or 2 of them are valid. So I need another 2-3 weeks to finalize it because I need FD's approval. I will do the final notification. And in this 1 month's time, I'll submit it to KPSC for recruitment.
For rectification of these
The C&R amendment, I'll take about 2 to 3 weeks, sir. And 1 week's time, I will submit to KPSC for recruitment.
within 3 weeks, everything will be done.
1 month, Your
1
Honor.
month, you
1
need
month.
4 weeks.
I will submit it to KPSC. And KPSC will do the recruitment.
My lord, my grievance is not that. My grievance is now backlog vacancies of 2002, they have not been filled up till date. Even the learned secretary was telling, I have not applied in 2002, the copy is with me. The issue is, in spite of a specific direction of a state level social welfare board by the honorable minister's chairmanship, kindly peruse, my lord, it was resolved to give appointment for 3 scheduled caste persons, including the petitioner herein. 6 notifications were cancelled without reason or anything. By my humble submission, Justice, your lordship from oralized judgment, even if there is, in the absence of cadre and recruitment rules, the backlog vacancies which have been kept open for the last 23 years, no attempt has been filled up. Regarding KPSC also, KPSC asked so many queries to there is intra-departmental communication have been furnished along with the statement of objection. My humble submission is only kindly peruse, my lord, 7/3/2018 letter or page A14, page 63
I have the
of my petition. Kindly peruse.
It's been struck down.
Law department opinion has sought,
It's been struck down.
and 2002 it was reserved for SC, then it was ST, then it was corrected. My lord, kindly peruse A14. And also page 39 is the resolution passed by the state level high power committee of social welfare department to fill up the backlog vacancies, A5 that is. That was not honored. Post facto, in 2014, they call a meeting.
A14.
Page 63. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರದ ಕಡೆ ತಮ್ಮ ಗಮನ ಸೆಳೆಯಲಾಗಿದೆ. ಕಾವಾ ಸಂಸ್ಥೆಯ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವ ಸಂಬಂಧ ದಿನಾಂಕ 33/1/2010, 4/12/2012, 9/12/2002, 3/12/2012, 30/5/2013, 19/6/2014 ಪಡಿಸಲಾಗಿದ್ದ ಪ್ರಕಟಣೆಗಳನ್ನು ರದ್ದುಪಡಿಸಲು ಹಾಗೂ ರದ್ದುಪಡಿಸಲಾದ ಪ್ರಕಟಣೆಗಳಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ವಯೋಮಿತಿ ಸಡಿಲಿಸಿ ಹೊಸದಾಗಿ ಗ್ರಾಫಿಕ್, ಶಿಲ್ಪಕಲೆ, ಚಿತ್ರಕಲೆ ಸೇರಿದಂತೆ ಪ್ರಕಟಣೆ ನೀಡಲು ಅನುಮತಿಸಲಾಗಿದೆ. This has been given 2018. What happened thereafter?
By secretary.
Prayer in the application. Kindly see the prayer in the application.
And also kindly peruse, my lord,
One
A5.
second. ಒಬ್ಬೊಬ್ರು ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು. ಏನು ಅಪ್ಲಿಕೇಶನ್ದಲ್ಲಿ ಪ್ರೇಯರ್ ಏನಿದೆ?
Page number 30, my lord.
In the nature of mandamus, direct one into to fill up the backlog post of lecturer in sculpture in the response number 4 institute by notifying and to make selection science.
We are on that, my lord. We are on that, my lord. We are issued a notification, my lord. We are called an objections. It will be finalized within 4.
That's your prayer.
My lord, kindly peruse, my lord. My lord, what happened now?
Only
The same secretary had permitted the further recruitment to the Kawa. The meeting held on 9/2/2015, page 39
ಅಲ್ಲ,
A5.
Mr. Divakar.
No, my lord, my humble submission, the state level social.
Next week.
My lord, there.
Yes. The learned principal secretary,
Secretary.
Srimati So came and participated in the proceedings. First. It's a nice thing to happen that the government functionaries come to court and assist when requested. Okay.
But serial number 8, my lord.
Next week.
All right. Yes.
Thursday.
Can I make one request? Not,
You are disabled in serial number 80, disabled.
not, yes, not,
Whether it's
not,
disabled.
in fact, not said, heard it, not in the previous bench. It was supposed to have further hearing, but that is not there in the order. But this is a society matter where not said there may be requirement of CBI inquiry.
Okay.
The last date order, Lords, not said, Lord, there may be a need for an inquiry. Which was
Not part heard, but
not said, I had
was it-
concluded, not Mr. Holla had also not finished, not said, not thereafter sought here the society.
Yes. Post this matter before a bench, not comprising of Honorable Justice Huda.
Lord,
Okay.
can I make a request? Not if it can be treated, not
No, we have not treated it.
No, no, not
Now
this.
we cannot.
now,
treat.
now, yes, not, but the interim order may be extended.
Courtmaster, sir? Courtmaster, sir? Courtmaster, sir, I need to inquire about one matter. Courtmaster, sir? Courtmaster, sir? Courtmaster, sir, I need to inquire about one matter.
Hello.
Hello. Yes, Courtmaster, sir, I need to inquire about one matter.
Yeah, tell me.
Item number 5.3 in list number 2. What date has been given?
List number 2.
List number 2, item number 5.3. It was connected with 5.
And it will be called a 230 BM. It's a 230 list.
List number 3 is a 230 list, right? I am talking about list number 2.
Which list number 2, madam? There is no list number 2 at all.
Court Master, sir, this matter is Malika Arjun versus State of Karnataka, 5.3. Malika Arjun Shipping.
ಎಷ್ಟೊಂದು ಸೀರೆ ನಂಬರ್ ಈಟ ರೆಕಾರ್ಡ್ ಆಗಿಲ್ವಾ TPJ dealing from so and so direct SCP and call this meeting ಹೇಳ್ತೀರಿ ಸರ್ ಬಂದು ಇವಾಗ ಆರ್ಡರ್ ಇದೆ ಸ್ಟ್ಯಾಂಡ್ ಆಗೋದು ಮೇಲೆ ಸ್ಟ್ಯಾಂಡ್ ಆಗೋದು
Hello.
ಅವ್ರ ಮುಂದೆ ಹಂಗೆ ಹೇಳಿ ಮೆಮೋ ಕೊಟ್ಟಿದ್ದು ಒಂದು ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಮಾಡ್ಬಿಟ್ಟು PJ ಮುಂದೆ ಹೇಳ್ತೀನಿ ಹಿಂಗೆ ಪ್ಲೇಸ್ ರಿಪೋರ್ಟ್ PJ ಅಂತ ಮಾಡ್ಬೇಕು ಅವ್ರು ನಮ್ಮ ಮುಂದೆ ಇನ್ನೊಬ್ರು ಮಾಡ್ತಾರೆ.
Hello.
ಹಲೋ
Yes, Court Master, sir. The name of the matter is Sri Malika Arjun Shipping versus
Ma'am.
State of Karnataka.
kindly look into the cause list.
Yes, cause list. Cause
Yeah.
list. It's list number 2, item number 5.3 is coming at.
At what time? Kindly
Listed
look
for
at the time.
10:30 only. It was listed for 10:30 a.m. only. I
It is
need to
total
confirm
7. Item number 5.
Yes, my lord. Yes,
There is
ma.
There's no such 5 point this thing, madam. Only 230 matters are there before MNPJ. You might be speaking of list number 2.
Yes, I am speaking about list number 2 itself. You are saying it will be taken up at 2:30.
ಇದ್ರಲ್ಲಿ 5.2 ಇಲ್ಲ ಅದರಲ್ಲೂ ಇಲ್ಲ ಮೇಡಮ್ in 230 matter also there is no 5.2. In 1030 matter also there is no 5.2.
ಕೋರ್ಟ್ ಇರ್ಬೇಕಲ್ಲ ಸರ್,
ನಮ್ಗೆ ಎಲ್ಲೆಲ್ಲ ಸುಮ್ಮನೆ ಮೆನ್ಷನ್ ಮಾಡಬೇಕು.
ಬೇರೆ ಕೋರ್ಟ್ ಇರ್ಬೇಕು.
ಕರೆಕ್ಟ್ ಮೈಕಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ ಗೊತ್ತು ಅವ್ರದ್ದು ಚೆಕ್ ಮಾಡಿ
ಮೈಕ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಹಲೋ ಹಲೋ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ನೀವು ಅವ್ರದ್ದು ಎಲ್ಲ ಸೆಟ್ ಬರ್ಬೇಕು.
ಇಲ್ಲಿ ಏನ್ ಮಾಡ್ಲಿ ನಾನು ಹೊಸ ಆಯ್ತಲ್ಲ ಇದು ಪುಳಿಯೋಗರೆ ಗೊಜ್ಜು ಕಲ್ಸ್ಕೊಂಡ್ ಮಾಡಿದ್ರೆ ಅದು ಓಕೆ. ರೆಡಿಮೇಡ್ ಪುಳಿಯೋಗರೆ ಅಂದ್ರೆ ಬಹಳ ಹಿಂಸೆ. ಇದೊಂದು ಇದು ಕೊಟ್ಟು ನಮ್ಗೆ ಅಂದ್ರೆ ಅವರು ಪ್ರಿನ್ಸಿಪಲ್ ಟೂರಿಂಗ್ ಬರೀತಾರೆ ಹೇಳ್ಬೇಕು ಚೇತನ್ ಅದೆಲ್ಲ ಕೇಳ್ಕೊಳೋದಿಲ್ಲ. ಎಷ್ಟು ಡಿಸ್ಪೋಸ್ ಆಗತ್ತೆ ಸರ್ ಇವತ್ತು? ಡಿಸ್ಪೋಸಲ್ ಎಷ್ಟಾಗತ್ತೆ? ಇದು ಚೇತನ್ ಬರೀ ನಿಮ್ಮ ಅನುಕೂಲ ಕೊಟ್ರೆ ಆಯ್ತು. ಬಂದ್ಬಿಟ್ಬೇಕಾದ್ರೆ ಸೇರ್ಸ್ಕೊಳ್ಳಿ. ಒಂದ್ಬಿಡಿ ಸೆಕೆಂಡ್ ಸೆಟ್ ಇಲ್ಲೇ ಇರ್ಲಿ. ಅವ್ನು ಕಂಪ್ಯೂಟರ್ ಟೈಪ್ ಮಾಡೋದು ಮೋಸ್ಟ್ಲಿ. ಬಂದು ಸೇರ್ಸ್ಕೊಳ್ಳಿ. ಆಮೇಲೆ ಸೇರ್ಸ್ಕೊಂಡ್ಬಿಡಿ, ಮರಿಬೇಡಿ. ಸುಮ್ಮನೆ ಕನ್ಫ್ಯೂಷನ್ ಮಾಡಿ ಅವನು ಅಷ್ಟೊತ್ತಾಯ್ತು ಒಬ್ಬರೇ ಮಾಡ್ಬೇಕು ಬರ್ದ್ಬಿಡಿ. ಒಂದು ಸ್ಲಿಪ್ ಹಾಕೊಳ್ಳಿ. ಇರ್ರಿ ಯಾವ್ದೋ ಕೊಟ್ರು ದಿವಾಕರ್ ಅವರು. ಸುಮ್ಮನೆ ಇರೋದು ಮಾತಾಡಿದ್ರು ಹೋಗೋದು ಸಾಯದು. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಊಟ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತೇನೆ. ಅಮ್ಮಣ ಗೊಜ್ಜು ಇಲ್ಲ ರೆಡಿಮೇಡ? ಹಾ ಗೊಜ್ಜು ಚೆನ್ನಾಗಿರ್ತದೆ. ಒಂದು ಮೇನ್
ಚೇರು ಕುಟ್ರಸ್ತಿದೆ. ಇದು ಕೆಳಗೆ ಹಾಕೋತಿರಲ್ಲ ಅದು ಬೇಕಷ್ಟೇ ಒಂದು ಫುಲ್ ಸೆಟ್ಟೇ ಬೇಕು. ಫುಲ್ ಸೆಟ್ ಅಂತಂದ್ರೆ ಏನ್ ಬೇಡ ಅಲ್ವಾ? ಬೇಕಾ ಇದು? ಬೇಕಲ್ವಾ? ಅಲ್ಲೇನ್ ಬೇಕಾಗಿಲ್ಲ ನೀವು ಇಲ್ಲ ಕೆಳಗಡೆ ಮತ್ತೆ ಕೇಳಿದ್ರು ಕ್ಯಾರೆಟ್ ತಗೊಂತ ಇಲ್ಲ ಕ್ಯಾರೆಟ್ ನಮ್ ಸಿಂಗರ್ಗೆ ಇಲ್ವಲ್ಲ ಅಲ್ಲಿ ಸಿಕ್ಕಿದೆಯಾ? ಅದಕ್ಕೆ
ಫಸ್ಟ್ ಸೆಟ್ ಬಂದಿದೆ. ಇದೀಗ ಅಲ್ಲ ಸ್ವಲ್ಪ ಅದರಲ್ಲೇ ಬರೀಬೇಕು. ಅಲ್ಲ ನೀವು ಆರ್ಡರ್ ಶೀಟ್ ತೆಗಿದ್ರೆ ಇದು ಪ್ರಿಂಟ್ ತೆಗಿದ್ರೆ ಹೆಂಗೆ?
ಈ ತರ ಸ್ಟ್ಯಾಂಡ್ ವುಡ್ ಇದೆ ಇಲ್ಲಿ ವುಡ್ ಹಾಕಿದ್ದೀನಿ ಅವ್ರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮಾಡೋರೆ ಇದು ಸೀರೆ ಕೆಳಗೆ ಹೋಗ್ಬಿಡುತ್ತೆ ಮನೆ ಐಟಮ್ ಮತ್ತೆ ಇಲ್ಲಿ ಇರ್ತದೆ ಹಾ, ಅದೇ ಅಲ್ಲೇ ಇಟ್ಕೊಂಡು ಮಾಡ್ಕೊಂಡು. ಏನಿಲ್ಲ ಏನಲ್ಲಿ ಎಲ್ಲರೂ ಇದ್ದಾರೆ ನಿಮ್ಮಲ್ಲಿ ನಗರಸ್ಥ ಅದು ಇದು ಯಾರು ಇದ್ದಾರೆ
ಏನೇ ಮೈಕ್ ಅವತ್ತು ನೋಡ್ರಲ್ಲ ಕಂಪ್ಯೂಟರ್ ಲೇಟ್ ಹಾಕ್ಕೊಂಡಂಗಿಲ್ಲ. ಹೊರಗಾಗಿ ಮಾಡ್ತಾರೆ. ಫುಟ್ರೆಸ್ಟ್ ಇತ್ತಲ್ಲ ವೈಟ್ ಕಲರ್ದಲ್ಲಿ, ವೈಟ್ ಕಲರ್ ಲಿಸ್ಟ್ ಇಟ್ಬಿಡಿ, ಬರೀಬಿಡಿ.
Serial number 14.10. B. Ramesh, dismiss. ಅವ್ರು ಕೊಡಲ್ಲ ಬಿಡಿ ಅವ್ರು ಕೊಡಲ್ಲ. ಹಾ? ತಂದಿದ್ದೀನಿ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಅಷ್ಟೇ. ಹಾ? Serial number 4.
6689 of 25.
Oh. Peter, let's go. I did. Really come on, bring that. You.
ಮೈಕು ಸಾಕನ್ಸುತ್ತೆ ಇಲ್ಲಿವರೆಗೂ ಎಳ್ಕೋಬೇಕಾದ್ರೆ ಇಲ್ಲಿ ಸಮೇತ ಬರುತ್ತೆ ಬಟ್ ಇಲ್ಲಿ ಬೇರೆ ಕಡೆ ಇಡಕ್ಕೆ ಆಪ್ಷನ್ ಇಲ್ಲ. ಏನು ಹೇಳಬೇಕು ಬೇಡ ಅಂತ ಹೇಳಕ್ಕಿಂತ ಮುಂಚೆ ಇಟ್ಬಿಡ ಬೇಡ ಕೆಳಗೆ ಬೇಡ ಹಾಕ್ಬಿಡಿ ಕಮ್ಮಿ ಆಗ್ಬೇಕು. ಓಕೆ ಪ್ರೊಸೀಡಿಂಗ್ ತಂದು ಹಾಕಿದ್ದೀನಿ ನಾನು. ಹೇಳ್ತೀರಲ್ಲ
ನಾನ್ ಬರ್ಕೊಬೇಕಷ್ಟೇ ಏನಿಲ್ಲ
ಸರ್ ಇದು ಆಕ್ಚುಲಿ 6th ಕಳಿಸ್ಬಿಟ್ಟಿದ್ವಿ.
ಸ್ವಲ್ಪ ಕೊಡಿ
ಹೇಳಿ ನಮ್ಗೆ 15 ಸರ್
230ಗೆ
ಸರ್ ಇದೆ ಸರ್.
ನಂಬರ್ 4 ಅಲ್ಲಿ
25781 ಅಲ್ಲಿ ಸ್ಪಾಟ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ ಸರ್. ಆಯ್ತು ಪ್ಲಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಯ್ತು. ಇದು ನಂಬರ್ 14 5549 of 24.
ಇಲ್ಲ 14
ಎಲ್ಲ
ಇದೆ 14.7 ಇದು ನಂಬರ್ ಎಷ್ಟು
5549
14.7 ಅಂತ ಹಾಕಿದೆ 14.7
ಅದರಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಫ್ ಆರ್ಟಿ
ಇದೇನಾ ಎರಡು
14 ಅಲ್ಲಿ 14114 ಸ್ಪೇಸಸ್ 13.10 ಅದರಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆರ್ಟಿ $15 sir 722 ಇದರಲ್ಲೂ ಸೇಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆರ್ಟಿ ಆಮೇಲೆ 4 ಅಲ್ಲಿ ಇನ್ನೊಂದು ಪೇಪರ್ ಇದೆ ಸರ್ 4 ಅಲ್ಲಿ ಇನ್ಸ್ಪೆಕ್ಷನ್ ರಿಪೋರ್ಟ್ ಹೇಳಿದ್ರು 25781 I have 1 of 25 for impleading, proposed opponent. Filed by applicant, Rajeshwara PN. For years. ಇದು ಆಕ್ಚುಲಿ ಸರ್ 60ಗೆ ಬೋರ್ಡಿಗೆ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ವಿ ನಾವು ಅವತ್ತಿಂದ ಫೈಲ್ ರಿಟರ್ನ್ ಆಗಿರಲಿಲ್ಲ ಅದಕ್ಕೆ ಪಿಂಕ್ ಎಲ್ಲ ಕಳಿಸ್ಬಿಟ್ಟು ಗ್ರೀನ್ ಎಲ್ಲ ಸಿಕ್ಕಿದೆ.
ಇನ್ನೊಂದಕ್ಕೆ ಫ್ಲಾಗ್ ಹಾಕಿ ನೀವು
ಸರ್ ಇನ್ನೊಂದು ಹೆಂಗೆ ದಾಖಲೆ ಹಾಕಿದ್ದೀವಿ
ಸುಮ್ಮನೆ ಹೌದಾಗಿದ್ದು ಯಾವಾಗ ಪೇಮೆಂಟ್ ಫೋನ್ ಮಾಡಿದ್ದೀವಿ ಹೆಂಗೆ 772 ತನ
ಫ್ಲಾಗ್ಸ್
ಬೇಕಾ ಬಂದಿದೆ SOB
ಇಲ್ಲ ನಾವು ಕೊಟ್ಟಿದ್ದು
For orders, say number 2, M. Srinivasa. M. Srinivasa.
Sir, kindly pass over, senior is coming. Sir.
Four matters are being taken up, note that report of the registrar computers may be released.
That is one more.
Yes.
Is revenue side still, proceedings are pending.
Yes.
Committee has sought for extension, will grant it. Will grant 3 or 4 minutes
Please.
to complete the proceedings. We had by our order dated 11th July 2024, disposed the subject petitions, directing the petitioners to approach the committee constituted under the chairmanship of Justice, and the chairmanship of V.G. Bopaya. The term of the committee is said to have expired on 7/11/2024. Sorry, on 30/11/2024. And therefore, the committee has addressed a communication seeking extension in the light of several orders passed by us of the kind that is passed in the case at hand. In the light of the resolution of the list necessary and the work of inspection and drawing up of a report and considering the same at the hands of the committee so constituted, we deem it appropriate to extend the term of the committee by 4 months from today. All other conditions stipulated while constituting the committee shall continue till the subsistence of the functioning of the committee.
The report of the registrar computers.
That also. ಒಂದು ರಿಜಿಸ್ಟರ್ ಕಂಪ್ಯೂಟರ್ಸ್ ಒಂದು ರಿಪೋರ್ಟ್ ಇದೆ. ನೋಡಿ. We'll do it by the end. Let the things.
Last month.
Next.
Number 3, Saravana.
The presentation was for all.
Consider. A petitioner. Petitioners are before this court seeking a direction by issuance of a writ in the nature of mandamus, directing the respondent BDA to consider the representation submitted on 30th May 2024, seeking extension of the benefit in terms of a notification, either by regularizing the sites or for allotment of alternate sites. In identical circumstances,
we by our order dated 25th October 2024 has directed the BDA to consider the representations with an outer limit of 4 weeks and communicate the decision taken thereon to the petitioners therein. We have held as follows. Para 3 to 5. In the light of identical orders passed directly in consideration of representation, the case of the petitioner should also merit consideration in accordance with law and a decision taken thereon to be communicated to the petitioner within 3 months from the date of receipt of the copy of this order. Till such time, the respondent BDA shall not precipitate the matter.
Number 4, Rohan Osmat.
There is a spot inspection report that is.
Who are you? Stakeholder.
Erstwhile owner.
Erstwhile owner.
Erstwhile owner who has executed.
What
a
are your
state aid.
states?
He has filed a civil suit.
You are not a stakeholder, mistakeholder.
M has to be a prefix. ಜೋಕ್ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ. ಜೋಕ್ ಅರ್ಥ ಆಗಲ್ಲ ಯಾರು ಇರ್ಬೇಕಲ್ಲ. ಲಾ ಅರ್ಥ ಆಗ್ಲಿ ಬಿಡ್ಲಿ. ಸ್ಟೇಕ್ ಮಿಸ್ಟೇಕ್ ಹೋಲ್ಡರ್ ಅಂತ. Yes. If you are erstwhile,
what is your
owner,
rights?
what's your stake? Read Razia Begum, 1958 Supreme Court. Razia Begum versus Shahnaz Begum. You are not even in the penumbra of proper parties, let alone stakeholder. Rejection. ಅಲ್ಲಿ ಸೂಟ್ನಲ್ಲಿ ಏನಾಗತ್ತೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಇಲ್ಲಿ ಇಲ್ಲೇ ಬರ್ಬೇಕು ನೀವು.
Let them consider. Nim representation. ಮಾಡ್ತಾರೆ ಬಿಡಿ.
ನಿಮ್ದಲ್ಲ petition. You can't bathe under the waters of other persons. You file writ petition, I will consider.
Separate ಹಾಕಿಬೇಕು. You will consider. Application.
ತರಿಸಿ ಅಪ್ಲಿಕೇಶನ್ ತರಿಸಿ.
ಇದೆಯಾ ಇಲ್ಲಿ? ಇದೇನಾ?
ಇದೆಯಾ?
ಮುಗಿಸ್ಬಿಡೋಣ. First we will deal with that. Where file ಕೊಡಿ.
I need.
What has happened?
Seek some instructions.
Why?
I was not informed that the copy was already given.
You are not present.
I was present. No, but I need to seek instructions from the petitioner with respect to the spot inspection report.
It is cutting across. In instruction, it is cutting across.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ.
It was notified for lands left out in preliminary and final notification.
But now road includes.
If the road is passing, then it may be disposed in the matters.
ಅದೇನು ಮಾಡ್ಕೊಂಡಿಲ್ಲ. Covered by judgment.
Leaving open to the remedies available to you, we'll close this.
In the light of similar orders that is passed.
Road orders.
Please.
ಒಂದು ಕೊಡಿ.
ಒಂದು road. This is the road to justice is blocked because of this.
I don't think I have it right.
Covered by judgment.
Disposed and is IA dismissed. Same orders, that way we will pass the same order.
Covered by judgment.
Insofar as the vacant land, my only request is this. Since about 2,000 or 1,500 square feet would be the built-up area. The remaining portion of almost about 10,000 square feet. The allotment in both the cases will be considered with respect to one unit. That's my only request. We will add all this Manoj in the representation.
Covered by judgment.
No, sir, only that, Rohan, whatever we have passed in other cases.
It's some similar protection.
Protection, same, whatever is passed.
Please.
Yes. Dismissed. Implementing application dismissed. ಆಶ್ಚರ್ಯ ಆಗ್ತಾ ಇದೀರ.
Stakeholder.
Sir, it is his petition.
So how we can decide your sale deed is spurious or nominal? That suit is going on there. You fight that suit.
ಅದಕ್ಕೆ you file a separate petition, we'll consider.
Consider.
Don't intrude in his. That's why your marriage is his family.
Yes.
Yes.
Number 5, Manjuna Karthi.
That's one of his objections. I was supposed to keep this book on library.
You have not given?
Permitted to produce.
What ಬೇಕಲ್ಲ?
I'll produce.
Word power ಯಾವ್ದದು?
48 laws of power.
48. What ಬೇಕು?
Page number 107, my lords. I permitted to take.
There are 5 office objections. 5 ಇದೆ, ಒಂದಲ್ಲ.
All minute. A week's a time.
That's fine. Council, what's the impending urgency? Interim order ಇದೆಯಾ?
My lords, there is an interim. Let's page number 107, my lords.
48 laws of power ಕೊಟ್ಟಿಲ್ವಲ್ಲ.
Lord, certain lands has been regularized by the order of Supreme Court. Lord, thereafter, the lands has been acquired.
Consider representation.
Although Ramswamy versus State of Karnataka, lands requires to be denoted.
Not all those. Representation will consider. It's a consideration simpliciter.
There are certain islands of property.
Then you comply with the office objections and come.
Please.
Yes.
A week's accommodation.
Representation consider ಅಂದ್ರೆ ಇವಾಗಲೇ ಕ್ಲೋಸ್ ಮಾಡಿ.
ಅಷ್ಟೇ ಅದು. ಅದೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆದ್ಮೇಲೆ ಆಗೋದು ಅಷ್ಟೇ.
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ಎಲ್ಲ ಹೇಳಿದೀರಾ?
Please, madam.
ಅದು ಸರಿ ಅಷ್ಟೇ. ಕೊಡಿ ಫೈಲ್.
A status quo order.
That will be there till they consider and pass. The petitioners, the separate order sheet ಮಾಡಿ madam. Learned Counsel Shiva Prasad Shantan Gowder is directed to accept notice for the respondent 2, 3, 4, 5, 1 AGA. The petitioners are before this court seeking twin prayers. One, quashment of the acquisition proceedings notified by the respondent BDA on 30/12/2018. The same cannot be considered in the light of the judgment of the apex court, in the light of the orders passed by the apex court. Insofar as the other prayer is concerned, the prayer is to direct consideration of a representation submitted by the petitioner on 2/9/2023, relying on 2/9/2023. The learned counsel for the petitioner would reiterate the contentions advanced in the representation submitted before the BDA, seeking the relief of dropping the property from acquisition proceedings. The learned counsel Shiva Prasad Shantan Gowda submits that if reasonable time is granted, the representation of the petitioner dated 2/9/2023 would meet its consideration and appropriate orders would be passed in accordance with law. In that light, we deem it appropriate to dispose the petition, directing the respondent BDA to consider the representation and communicate the order passed thereon to the petitioner, all within an outer limit of 3 months from the date of receipt of the copy of this order. Till such time, no precipitative action shall be taken again, till such time, status quo where the property be maintained by the BDA, by the parties.
Number 6, Rohan Osmat.
Legibility, copy of the sale deed.
Office objection ಏನು?
Annexure A is not legible and copy of the sale deed, page 13, it's legible.
What's the prayer?
Road matter,
Road man.
covered, and it's kindly
So
see the
Prasad,
Google
covered
image.
up.
The notice account covered, it's a covered by judgment, na?
Road andre
Page 27 minutes is the Google satellite image.
ಹಾ ಎಲ್ಲಿ ಬರುತ್ತೆ ಪ್ರಾಪರ್ಟಿ ನಿಮ್ದು?
These trees, your lordships, minutes.
ಇಲ್ಲಿ
ಅದ್ರ ಪಕ್ಕದಲ್ಲಿ small.
ರೋಡ್ ಮೇಲೆ ಇದೆ. ರೋಡ್
ಮೇಲೆ.
ರೋಡ್ ಕ್ಲಾಸಸ್ ಸೇಮ್ ಮಾಡಲ್
Covered by judgment.
Same one. The larger extent is vacant, but
that they will that's what we have passed in that. Previous ಮಾಡಿದ್ವಲ್ಲ.
Same.
ಮೇಡಮ್ ಅದು ಸೇಮ್ ಅಂತ ಬರ್ಕೊಳ್ಳಿ. ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದು ಕೊಟ್ಟರು ನೋಡಿ, ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ.
4 ಇದೆಯಲ್ಲ ಅದೇ.
ಸಪರೇಟ್ ಆರ್ಡರ್ ಶೀಟ್. ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಶಿವಪ್ರಸಾದ್ ಶಾಂತನ್ ಗೌಡರ್ಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಆಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್. ಬಿಡಿ ಎಲ್ಲೆಲ್ಲಿದೆ ಅವ್ರಿಗೆ ಮಾಡಿ, AGA 1 ಅಂತ ಮಾಡಿ, ಆಮೇಲೆ ಆರ್ಡರ್ ಮೇನ್ ಆರ್ಡರ್. ಇದು ಈ ಶಿವಪ್ರಸಾದ್, ವಾಟ್ ಡು ಯು ವಾಂಟ್ ಇನ್ ದಿಸ್? Report. Yes, next.
Seal number 7.
serial number 7, I'm instructed to appear in this matter. Lords may kindly have it after 2 weeks, once I'll comply with the office objection.
28.
ಏನದು prayer ಏನು?
Minutes, the petition was filed, minutes, challenging these are similar matters, minutes of revenue site holders. That was disposed of.
We have disposed.
Covered by
We have
judgment.
disposed those cases also.
After that, minutes, what had happened was similar to minutes serial number 14. Matter will be taken up along with serial number 14
ಆಯ್ತು,
itself.
14 ಜೊತೆ ಕರೆಯ.
14 ಜೊತೆ ತಗೊಂಡು. All right.
Number 8.
By judgment.
Let's,
Gaurav.
matter pertaining to regularization of house construction, Millets. Applications were filed in 2021 itself, Millets. It's not been considered. It's not for mandamus directly.
Yes, Shivaprasad. Which committee?
Before the Justice A.V. Chandrasekhar.
Committee is not there now.
Millets, my immediate neighbors, Millets, it's been regularized, Millets.
ನೀವು consider
Leave
ಮಾಡಿ.
it, yes. No, they will give you a representation now, afresh.
Please, Millets. Similar matters at serial number 20 and 22, Millets.
20 and 22.
Please, Millets.
7, 8, 20 and 22.
Two minutes.
Same order will.
Please, Millets.
Kudi. Madam, separate order ಮಾಡಿ, but same identical. The petitioner is before this court. Same petitioner, different.
ಬೇರೆ ಬೇರೆ ಇದ್ದಾರೆ.
Very petitioners.
The petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus directing the respondent 1 and 2 to the petitioner dated 5/7/2021. The learned counsel appearing for the respondent BDA would submit that the representation was submitted to the committee, which is no longer in subsistence. In that light, we deem it appropriate to dispose the petition directing or reserving liberty to the petitioner to submit a fresh representation to the BDA. Identical to what was placed before the committee on 5/4/7/2020. On 5/7/2021. Even the representation is submitted in the next 2 weeks. The BDA shall consider the same and pass necessary orders on the representation and communicate the decision taken within 8 weeks thereafter. Saka, within 8 weeks thereafter, till such time, status quo where the property be maintained by the parties. It is made clear that we have not entered into the merit of the claim of the petitioner.
Pledge.
8 to 20 and 22 same order. Separate order. ಅದು ಹಿಂದೆ ಹೇಳಿದ್ನಲ್ಲ, ಶಿವಪ್ರಸಾದ್ ಶಾಂತನ್ BDA, AGA separate.
Question number 9, Vijay Bhaskar,
Welfare Association.
Balrajar,
In Welfare Association.
Consider point accuracy.
The petitioner is before this court. Petitioner Owners Welfare Association. Petitioner Welfare Association is at the doors of this court along with its members, seeking a direction to consider the representation of the representation, no, final notification costment to ಕೇಳಿದ್ದಾರೆ. ಇಲ್ಲ, it's comply ಮಾಡಿದ್ದಾರೆ. 2 weeks time.
Bashment ಇದೆ.
2 weeks time is granted to comply with the office objections. ಆಮೇಲೆ notice. These review petitions will take it. Clifton. ಇದು ಆಮೇಲೆ ತಗೊಂತೀವಿ.
ಇವತ್ತಾಗುತ್ತೆ 20th, not today.
20th.
20th.
The intermodal that. Intermodal ಹೇಳಿದೆ.
number 11, Nishant Eve,
Happy for the
Application.
petitioner. But from the previous day, AG I thought saying that with respect to allotment of alternate land, my lords, in terms of
ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಏನ್ ಬಂದಿದೆ?
Yes, sir. You had said that other day the alternate land would be granted. We have recorded it. Please see the order.
ಅಲ್ಲ ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಲಾಸ್ಟ್ ಟೈಮ್. ಕೊಡಿ ಫೈಲ್ ಕೊಡಿ ನಿಮಿಷ.
We haven't made an order also.
I guess that's the same matters. Consider representation.
It is a direction because
I think so.
you said specifically alternate land would be granted. We remember, that was a month back. My brother made that order actually.
ಇನ್ನೊಂದು
You should be granted.
should be granted.
20th.
Just the matter on 20th.
number 12, Vivek Kolla,
Petition at the end.
This is, it's covered.
My lord, this is the matter which is covered with the writ appeal. It's connected with the writ appeal.
True.
Yes.
But the issue also is covered. We have. Yes. The reserve this also, we have heard it.
Lord, no, my lord, this matter has not been heard. In this, there are 3 matters that are connected. One is with respect to the house. Only portion of the house has been regularized. All
Same thing, we have
constructions-
reserved all identical matters. We have reserved identical
Reserve that identical matters. If anything needs a new thing to be added, add.
Well, then let it be had on the 20th. There's anything to be added, Mr. Holla will address those arguments.
Reserve it. That's 12.1 because identical
But
matters. we have
The
reserved.
only thing is in that, in the farm that they claim that it's vacant land, there are structures which are permanent structures. It's a
See,
stud
the
farm,
other
so.
matters are also of the
Yes.
kind, same kind.
Same matter.
But reserved.
Hello, 12.1.
12.1 and 2 in.
2 is the house, my lord, which is only portion of the house has been
Anyway,
regulated.
that will fall.
That will have.
12.1 reserved. The other two list them on 20th.
Correct, ethical, what is it?
Number 13, Narayan Swamy PM.
For petitioner in this case. In this case, the petitioner owning a land in survey number 43/6 measuring 20 guntas in Dodbetalli village, Yalanka Obli, North Bangalore.
Huh?
Road.
Cutting across.
If road is passing, road judgment.
Road notification was in 2008 and final notification after lapse of 10 years in 2018.
You know, in all these cases where road passes through the property, or property is in a place where road is passing by, we have passed some orders. And we can't grant the relief that you are asking, but they will definitely grant an alternate site. That is the order we have passed. Nodi order ಬೇಕಾರೆ. Same order will pass. ಬೇರೆ ಏನಾಗಲ್ಲ.
ಅಷ್ಟೇ ಅದು.
ನೋಟಿಫಿಕೇಶನ್ ಚಾಲೆಂಜ್ ಎಲ್ಲ ಹೋಯ್ತು. ಅದೆಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಗೋಗಿದೆ.
ನೋಟಿಫಿಕೇಶನ್ 2008 ಆದ್ಮೇಲಿಂದ ಲ್ಯಾಪ್ಸ್ ಆಫ್ 10 years 2018.
ಅದೆಲ್ಲ ಅಲ್ಲೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಗೋಗಿದೆ ಎಲ್ಲ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಅಲ್ಲೇ ಮುಗಿಸ್ಬಿಟ್ರಿ ನೀವು.
ಅಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಬಂದಿರೋದು ಇದು ವಾಪಸ್ ಇಲ್ಲಿ. ಅದೆಲ್ಲ ಅಫರ್ಮ್ ಆಗಿದೆ ಗೊತ್ತಲ್ಲ ನಿಮ್ಗೆ. ಅಲ್ಲ ಇರ್ಲಿ. ಅದ ರೋಡ್ ವಿಲ್ ಪಾಸ್ ದಿ ರೋಡ್ ಆರ್ಡರ್.
Road orders.
Yes. ಅದನ್ನ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ಡ್.
Issue notice.
Shivaprasad Shantan orders also disposed in terms of that order. That's the only relief that can be granted.
Issue notice.
ಅಲ್ಲ ಆಯ್ತು. Dispose ಆಯ್ತು. Yes.
Receive.
Number 14, Rohan Osmat.
Yes, Ron.
I appear in serial number 14.
ಮೈಕರ್ ನಿಟ್ಕೊಳ್ಳಿ.
But in serial number 14 pertains to an educational institution. It's the portion that was earmarked for a playground when the premises was running is now utilized for the purpose of road formation. It's apart from that, beyond the playground, there are about 3 dwelling houses of these very persons which were situated. Those also, my lords, the road is passing through. Now, my lords, I'm left in a situation where there is not enough space for my playground. Therefore, my lords,
How many students are there in each of the institutions or only one institution?
only one institution.
How long it has been functioning?
Lords, I may be permitted to file a memo. I have also given the list at document number 3, page 6, the total list of students, my lords, which works up to around 270 students.
How long, since how long institution is functioning?
2006 itself.
2006?
Please.
Public school.
Land, agriculture land. School ground ಎಲ್ಲಿದೆ?
But it's in the photographs.
Document number 4 ಗೆ ಬನ್ನಿ.
Document number 4. Well, it's now your lordships are seeing the second photo, minutes at page 19, the second photo.
Yes.
But it's, this is the only space that is left. The portion that is behind, my lords, the third photo where the vans are, my lords, that is sought to now, my lords, be made as the playground.
Playground ಕಣ್ಣಂಗ್ ಕಾಣೋದೇ ಇಲ್ಲ. ಎಲ್ಲ ತೆಂಗಿನ ಗಿಡ ಇದೆ ಇದು.
ಈಗ
ಮಾಡಬೇಕು.
Your lordship may kindly turn to the next page, page 20. This was previously the playground where the road was formed.
Ah.
This is after acquisition, sir.
Sorry,
This is now road is formed here.
road is formed.
Where are your documents that you have given to the education department saying that this is our playground, this is the school, this is the building? Where are those documents?
But they were all submitted before the committee.
Give us.
But it's document number 1 and 2 are the permissions that we have obtained.
ನಿಮ್ಮ ರೂಲ್ಸ್ ಎಜುಕೇಶನ್ ರೂಲ್ಸ್ ಕೆಳಗಡೆ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ 83 ಕೆಳಗಡೆ ರೂಲ್ಸ್ ಇದಾವಲ್ಲ, ದಿ ಕರ್ನಾಟಕ ಎಜುಕೇಶನ್ ಕೋಡ್, ಅದರಲ್ಲಿ ಲ್ಯಾಂಡ್ ಮತ್ತು ಬಿಲ್ಡಿಂಗ್ ರೋಡ್ ಅದರದ್ದು ಲೇಔಟ್ ಪ್ಲಾನ್ ಕೊಡೋದಿದೆ. ಯಾವ ರೂಲ್ ಅದು? ವಿಚ್ ಇಸ್ ದಟ್ ರೂಲ್?
ಇದು ರೂಲ್.
Where are the initial permissions granted for the educational institution?
But it's that I have not produced. I will produce those.
Produce all that. You
Please.
produce the, we get a report from
DDPI.
DDPI there.
Please.
ಅದನ್ನ ಇದನ್ನು ಕೊಡ್ಬೇಕು ಅವರು. ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಗ್ರಾಂಟ್ ಆಫ್ ಪರ್ಮಿಷನ್, ಅಪ್ರೂವ್ಡ್ ಪ್ಲಾನ್, ಅದನ್ನೆಲ್ಲ
The
ಕೊಡ್ಬೇಕು.
petitioners,
Appellants.
oh, appellants, the appellants are before this court seeking that the road formed in the layout has taken away the space that was being used by this educational institution as a playground. The learned counsel Rohan Hosmat has produced a memo appending to it certain documents seeking to demonstrate that the educational institution is functioning with 262 students. And for the said student strength, the playground, the space that is left for the playground after formation of the road is grossly inadequate. The therefore, the state shall now cause an inspection from the hands of the DDPI of the jurisdiction and place a report of such inspection before this court. The inspection shall be conducted in the presence of the petitioner. The report of inspection shall highlight the beginning of the school with necessary application and refer to all the records maintained in the department with regard to the functioning of the educational institution, which is said to be from the year 2006 itself. The inspection shall be caused and report shall be placed before this court on the next date of hearing. List the matter on 20th.
Please.
As on the day of application, how many students were there?
As on the date of notification.
Application made to be committed, because they were
The entire thing, let them.
So now the students may have increased.
No, as on the date of the first, second notification.
2018.
18. So 3/8/2000.
3/8/2018.
As on 3/8/2000. The student strength as on 3/8/2018 anta.
Yeah.
Yes. Please.
Copy ಕೊಡಿ ಅವ್ರಿಗೆ. That will give. Thank you.
Your lordships are fixing any date for inspection?
Shall we do that? Since the parties, along the last barcode, since the parties are represented by the respective councils, we direct the inspection to be conducted on, say, 12th. On the 12th at 11 AM. No separate notice need be issued to the petitioner in the light of, issued to the petitioner. He shall be present at the time and spot of inspection. 14. All other matters are what, 14?
It's 14.1, my lords. These are leftover lands, my lords, that were included in the 2022 notification.
8.1 is separate. There's 14.2 onwards. There is small structure which has been constructed. They're seeking regularization of
The entire area, that's
14.1 is
14.1 dealing money, dealing 14.1 from the tax petitions. Listed separately on 20th.
14.3 also. So one bit of land is ordered to be regularized, another.
Correct, ಅದನ್ನೇ ಹೇಳ್ತಿರೋದು.
Please.
Same. All other matters, all other ಅಂದ್ರೆ 14 series, not all. 14 point?
ಏನದು?
Correct, both are there in that, yes.
Entry models.
Entry models will continue. Up to 14.11, except 14.1 delinking, all others 20th. 20th, yes. Separately.
0.6, the farmhouse.
14.6.
May be taken up separately.
ನಾವು ಅದು ಬರ್ದಿದೀವಲ್ಲ.
Farmhouse already we have covered, I think, from by the Supreme Court.
ಫಾರ್ಮ್ ಹೌಸ್ ಯಾವ್ದು ಬರ್ದಿದೆ ಇಲ್ಲಲ್ಲ?
these are all they say now they are saying it's a farm.
ನಾವು ಫಾರ್ಮ್
Now,
2018.
as of 1989, my lords, this was constructed.
Couple of matters have been resolved.
That's what.
Now they are saying
Then we'll resolve this also, if it is farm house.
Lords, no, but I have some submissions.
Then
to be
just
made.
Tell.
Please.
part of the building goes on road. Part of it.
ಫಾರ್ಮ್ ಹೌಸ್ ರೋಡ್ ಏನ್ ನಿಮ್ದು?
ಎರಡು ಇದೆ.
Farmhouse ಅಲ್ಲ, waiting venue.
Let's.
So when it's not a waiting venue, it becomes farm.
Alternates.
But part of the building goes on for road.
Please. It's originally, my lords, this entire survey number.
14.6.
14.66.
Padi.
It's its subject land is survey number 66 minutes, which originally measures about 25 acres, 1 gunta, out of which minutes I am the owner of 1 acre, 15 guntas. The petitioner's mother minutes, in a compromise entered before the Honorable Supreme Court with the original owner who bequeathed the property by way of a will minutes, her names were mutated, and this was originally minutes a stud farm. In that minutes, there was a farmhouse that was constructed right in 1989 itself. These petitioners, this is in the original scheme, and the petitioners, my lords, did not approach the committee. Thereafter, my lords, your lordships had directed BDA to conduct a spot inspection, my lords. By memo dated 3/7/2024, my lords, there is a spot inspection report that is submitted. In terms of the memo, my lords, lordships may kindly take page 2.
ತಾಂತ್ರಿಕ ವರದಿ. ತಾಂತ್ರಿಕ ವರದಿ.
ತಾಂತ್ರಿಕ ವರದಿ.
Please.
Technical report.
Yes, technical report.
Yes,
this document number 1.
Yes. In this, my lords, point 3, 4, and 5, they clearly say that the constructions have come up prior to the cutoff date.
ಗೂಗಲ್ ನಕ್ಷೆಯಲ್ಲಿ ಕಂಡು ಬರುತ್ತೆ 2008 ಹಿಂದಿನ ಕಟ್ಟಡಗಳಲ್ಲಿ ಕಂಡುಬಂದಿದೆ. No, there Google Earth images, Shivaprasad.
It's produced. It's also there.
Google Earth images which say that it has come up.
The time of spot inspection, but they have come to the inspection. Prior to 2018, there was
Structures. Stud farm prior to that or what? Correct. ಈಗ what structures is the BDA referring to? It is scattered structure or?
What inspection? There are multiple structures. Spread across the.
ಒಂದು
ಅದೇ ತರ ಫಾರ್ಮೆಟ್ ಮಾಡಿ.
The board is passing to the front portion of the block.
Post it on 20th.
Please.
Post on 20th.
It may be dealing from this.
14.6, madam.
Separate.
14.6 to dealing.
Please.
Number 15, M. Shiva Prakash.
Where the objection. 14.11 is different from 15. Well, in that matter, it is second notification 2022.
ಅದೆಲ್ಲ ಮಿಕ್ಸ್ ಇದೆ ಅದರಲ್ಲಿ.
ಇದರಲ್ಲಿ ಅಂದ್ರೆ
series ಅಲ್ಲಿ ಎಲ್ಲ ಇದೆ.
even the sketch produced by the learned counsel by the representative BDA, nowhere it is shown about any connectivity or contiguity. It's altogether different slot and different plot mallet. The all other adjoining 8/1, 8/2, 7/2, 8/3, all are revenue pocket developed layouts. This is the only one island where now they have notified it. And now the connectivity as well as contiguity, there is no layout or there is no connectivity for this layout. Now they have notified it, and mine is from 1990. The first petitioner is Karta, and all other 4 daughters and 1 son. They are doing this animal husbandry, and also they have about about 5 to 6 houses. All are there now. As it is now, they have given a report that award is passed, portion is taken. My dwelling house is there. I am residing there, and
Well, sir.
no,
Including mosquitoes.
5 to 6. No, it's not like a good old method where the sophisticated dairy.
Oh, dairy.
And pollution, all those things we're not doing to neighbors. It's 1 acre, 14 gunnas. We are growing this fodder and also rearing this 8 to 10 cows and supplying milk from 1990 onwards. Now if it is a
ಯಾವ ಡೈರಿಗೆ ಹಾಕ್ತೀರಿ ಹಾಲನ್ನ?
ಡೈರಿ ಸುತ್ತಮುತ್ತಲು ಮನೆಗಳಿಗೆಲ್ಲ ಆಗ್ತಾ ಇದ್ದೀನಿ.
ಡೈರಿಗೆ ಯಾವ ಡೈರಿಗೂ ಕೊಡ್ತಾರೆ?
ಅಲ್ಲಿ ಸುತ್ತಲೂ ಯಾವ್ದು ಡೈರಿ ಇಲ್ಲ.
ಎಷ್ಟು ಹಸು ಇದೆ?
10 ಹತ್ತಿದೆ. ಮೇಕಂಡ್ಲಿ ಪಾಸ್ ಅವ್ರ ಮೇಲೆ ಸ್ಟಿಲ್ ಅಂಡ್
ಕೊಡಿ.
ಅದ್ರ ಜೊತೆಗೆ about sheep and goat also about 10-15. It's also a caged. Quote up, sir.
ಸಾಕು ಅದೇ ಹಸು
ಸಾಕಷ್ಟು
ಒಂದೇ.
ಸಾಕಷ್ಟು ಹಸುಗಳಿದೆ.
ಇದೆಲ್ಲ ನಿಮ್ದೇನಾ?
ಅದ್ ನಂದೇ.
ಒಂದೇ ಹಸು.
4-5 ಜನನು ಡಿಪೆಂಡೆಂಟ್ ಅದ್ರಲ್ಲಿ.
ನೀವೇನ್ ಎಲ್ಲ ಹಸುಗಳನ್ನ ಡಿಫ್ರೆಂಟ್ ಆಂಗಲ್ ಅಲ್ಲಿ ಫೋಟೋ ತೆಗೆದು ತುಂಬಾ ಹಸು ಇದೆ ಅಂತ ಹೇಳ್ತಾ
ಇಲ್ಲ, ಅದ್ ಮೇಯಕ್ ಬಿಟ್ಟಿರೋದು. ಮಧ್ಯಾಹ್ನ ಹಸು ಮೇಯ್ಲಿಕ್ಕೆ ಬಿಟ್ಟಿರೋದು.
ಅಲ್ಲ, ಹಸು ಒಂದೇ ಫೋಟೋ ತೆಗ್ದಿರೋದು 4.
ಇಲ್ಲ. ಮತ್ತೆ
ಹೌದಾ?
ಈ ಹಸುಗಳೆಲ್ಲ ನಿಮ್ದೇ ಅನ್ಲಿಕ್ಕೆ ಏನಾದ್ರು ರೆಕಾರ್ಡ್ ಇದೆ ಏನೋ? ಎಲ್ಲಾದ್ರೂ ಒಂದ್ರ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರಲ್ಲ ಯಾವ್ದೋ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ? ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು? ಜಾನುವಾರುಗಳ ಸಂಖ್ಯೆ.
ಇತ್ತೀಚೆಗೆ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕ್ಸ್ ತಗೊಳಕ್ಕೆ ಈ ವರ್ಷ ಬಿಟ್ಟಿದ್ದಾರೆ. ಮೊದ್ಲೆಲ್ಲೇನು ಅಂತದ್ದೇನಿಲ್ಲ ಜಾನುವಾರು ಜನಸಂಖ್ಯೆಗೆ
ಇತ್ತು.
ಅಂದ್ರೆ animal husbandry has begun after the notification. Animal husbandry has begun after the notification.
Statement of objection should have produced a map. There is entire extent of 1 acre.
Vacant.
ಮಧ್ಯದಲ್ಲಿ ಒಂದು ಶೆಡ್ ಇದೆ.
ಅಲ್ರಿ, ಈಗ ಇವ್ರಿಗೆ ಯಾರಿಗೆ ರೈತರಿಗೆ ಒಂದು ಕಾರ್ಡ್ ಕೊಡ್ತದಲ್ಲ ಗೌರ್ಮೆಂಟ್, ಎಷ್ಟು ಜನ ಹೆಂಡಂದ್ರು, ಎಷ್ಟು ಜನ ಮಕ್ಕಳು, ಎಷ್ಟು ಹಸುಗಳಿದೆ, ಎಷ್ಟು ಎಮ್ಮೆ ಇದೆ, ಆ ರೀತಿದೊಂದು ಕಾರ್ಡ್ ಇದೆ. ಅದು ಐ ಫಾರ್ಗಾಟ್ ಇಟ್ಸ್ ನೇಮ್. ಅದು ಎಂತ ರೈತ ಮಿತ್ರ ಪತ್ರ ಅಂತ ಸಮಥಿಂಗ್ ಎಂತದ ಒಂದಿದೆ ಒಂದು.
ಕೃಷಿ ಬುಕ್ ಅಂತ ಒಂದಿರ್ತದೆ.
ಹಾ,
ಅದ್ರ ಜೊತೆಗೆ ಕೃಷಿ ಬುಕ್ ಅಂತಿದೆ, ಅದಿದೆ. ಅದು ಬೇಕಾದ್ರೆ ನಾನು ಹಾಜರು ಮಾಡ್ತೀನಿ. ಮತ್ತೆ ಈ ನಾವು ರೆಗ್ಯುಲರ್ ಆಗಿ ವೆಟರ್ನರಿ ಹಾಸ್ಪಿಟ್ಲು ಮತ್ತೆ KMF ಅವರು KMF ಅವರು ವೆಟರ್ನರಿ ಹಾಸ್ಪಿಟಲ್ ಡಾಕ್ಟರ್ಸ್ ದೇ ವಿಸಿಟ್ ಫಾರ್ ಇನ್ಸೆಮಿನೇಷನ್ ಎಕ್ಸೆಟ್ರಾ. Those receipts and those visiting cards also I have. Right from 20 years I maintained it.
ಇದೆಲ್ಲ ಯಾಕೆ? ನಿಮ್ ಕೃಷಿ ಪುಸ್ತಕ ಕೊಡಿ.
ನಿಮ್ಮ ಕೃಷಿ ಪುಸ್ತಕ
ಯಾವಾಗಿಂದ ನೀವು ಇದು ಮಾಡ್ತಾ ಇದ್ದೀರಿ? ನೋಟಿಫಿಕೇಶನ್ ಆದ್ಮೇಲೆ ಬಂದಿದೆ ಇದು?
ಇಲ್ಲ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಸುತ್ತಮುತ್ತಲು ಇರುವಂತವ್ರಿಗೆ ನಾವು 20 ವರ್ಷದಿಂದ ಹಾಲು ಸರಬರಾಜು ಮಾಡ್ತಾ ಇದ್ರೆ, ಇವತ್ತು
ಹಾಲು ಸರಬರಾಜು 20 ವರ್ಷದಿಂದ
ಮನೆಗೂ ಆಗ್ತಾ ಇದೆ.
ಮನೆಗೆ ಹಾಕ್ಬೋದು. ಬಟ್ ಸಾಮಾನ್ಯ ಹಿಂಗೆಲ್ಲ ಇದ್ದಾಗ ಡೈರಿಗೆ ಎಲ್ಲರೂ ಡೈರಿಗೆ ಹಾಕಿದ್ದು ಮಾಡಿದ್ದು.
ಹೌದು.
ಕೋಆಪರೇಟಿವ್ ಡೈರಿಗೆ ಹಾಕಿ. ಆರ್ ಯು ಮೆಂಬರ್ ಆಫ್ ಎ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ?
KMF ಸೊಸೈಟಿ ಇದೆ.
ಮೆಂಬರ್ಶಿಪ್ ಇದೆಯಾ?
ಮೆಂಬರ್ಶಿಪ್ ಅಂದ್ರೆ ಇಲ್ಲೇನಾಗುತ್ತೆ ಅಂದ್ರೆ ತಗೊಂಡ್ಕೊಂಡಿದ್ದಾರೆ 1990 ಅನ್ವರ್ಡ್ಸ್. ಇಲ್ಲೇಂದ್ರೆ KMF ಅಲ್ಲಿ ಹೋದ್ರೆ ಅವ್ರ ಬಾರೋಮೀಟರ್ ಹಾಕಿ ಎಲ್ಲಾನು ಕಡಿಮೆ ರೇಟ್ ಕೊಡ್ತಾ ಅಂತ ಮನೆಗಳಿಗೆ
ನೀರ್ ಹಾಕಿ ಮಾರೋದಿದ್ರು ಮತ್ತೆ ನೀರು ಹಾಕಿದ್ರೆ ಮತ್ತೆ ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಎಲ್ಲಾದ್ರು ನಿಮ್ದು ಆರ್ ಯು ಮೆಂಬರ್ ಆಫ್ ದಿ ಹೈನುಗಾರಿಕೆ ಹಾಲು ಉತ್ಪನ್ನ ಅಂತದ ಸಂಘ? ಸಂಘ ಕೋಆಪರೇಟಿವ್
ಕರ್ನಾಟಕ ಮಿಲ್ಕ್ ಫೆಡರೇಷನ್ ಅಲ್ಲಿ
ಅದು ಒಂದಾಯ್ತು. ಅದು ಬಿಡಿ,
ಅವರೇ ಎಲ್ಲಾ ಕಡೆ
ನಿಮ್ಮಲ್ಲೇ ಇರುವಂತದ್ದು ಯಾವ್ದಾದ್ರು ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಮೆಂಬರ್ ಆಗಿ ನಮ್ಮ ಇಷ್ಟು ಹಸುಗಳಿದೆ.
ಈಗ ಡೈಲಿ 150 ಲೀಟರ್ಸ್ ಮಿಲ್ಕ್ ಎಲ್ಲಿ ಕೊಡ್ತೀರಾ? 150 ಲೀಟರ್ಸ್ ಮಿಲ್ಕ್ ಎಲ್ಲಿ ಕೊಡ್ತೀರಾ?
150 ಇಲ್ಲ, ಇದೆಲ್ಲ ಆಗೋದೆಲ್ಲ ಸುಮಾರು ಒಂದು 50 ರಿಂದ 60 ಲೀಟರ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ.
60 ಲೀಟರ್ ಮಿಲ್ಕ್ ಎಲ್ಲಿ?
ಇನ್ ಕೆಲವು ಅಲ್ಲಿ
60 ಮನೆ ಕೊಡ್ತೀರಾ?
ಮನೆಗಳಲ್ಲಿ ಇದಾರೆ ಎಲ್ಲ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಪಕ್ಕದಲ್ಲಿ ಆಗಿರೋದು. ದಿನ ಬೆಳಗಾದ್ರೆ ಸಪ್ಲೈ ಮಾಡ್ತೀರಿ, ಅಲ್ಲಿಂದ ನಮ್ ಜೀವನ ನಡೀತಾ ಇರೋದು.
ನೋಟಿಫಿಕೇಶನ್ ಆದ್ಮೇಲೆ?
ಇಲ್ಲ ಮೊದ್ಲಿಂದ ಕೊಟ್ಟಿರೋದು. ಅವರೆಲ್ಲ ದಿನ ಆಗದಲ್ಲಿ 1 ಲೀಟರ್ 2 ಲೀಟರ್ ಅಂತ ದುಡ್ಡು ಕೊಟ್ಟಿರೋದು. ಚಿಕ್ಕ ಬುಕ್ಗಳು ಮೇಂಟೈನ್ ಮಾಡ್ತಾರೆ. ಅವು ಬೇಕಾದ್ರೆ ನಾನು ಹಾಜರು ಮಾಡ್ತೀನಿ.
ಹಾಲು ರಸೀದಿ ಪುಸ್ತಕ?
ಹೌದು, ಅದು ಹಾಜರು ಮಾಡ್ತೀನಿ.
ಒಂದು ಸ್ಮಾಲ್ ಶೆಡ್ ಮಾತ್ರ ಇದೆ.
2 ಶೆಡ್ ಇದೆ. ಒಂದು
ಬರೀ ಶೆಡ್ ಇತ್ತು, ಆಮೇಲೆ ಅನಿಮಲ್ಸ್ ಹ್ಯಾವ್ ಕಮ್.
ಇಲ್ಲ, ಒಂದು ಶೆಡ್ ಅಂದ್ರೆ ಆಸ್ಪೆಸ್ಟಾಸ್ ಶೀಟ್ ಹಾಕೊಂಡು, ಯಾಕಂದ್ರೆ ಇವರೆಲ್ಲ ಬಡತನದ ಕಾಲಿಗೆ ಇರುವಂತ ಅಂತ ಸಾವುಕಾರಲ್ಲ. ಒಂದು ಪೋರ್ಷನ್ ಪೂರ್ತಿನೂ ಇವರು ಹಸುಗಳಿಗೆ ಇಟ್ಕೊಂಡೆ, ಇನ್ನೊಂದು ಪೋರ್ಷನ್ ಅಲ್ಲಿ ರಾಮಚಂದ್ರ ಅನ್ನೋರು ಮೊದಲನೇ ಪಿಟಿಷನರ್, ಅವ್ರು ಅಲ್ಲೇ ವಾಸ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. 1-2 ಇದು ಬೋರ್ವೆಲ್ ಇದೆ. ಬೋರ್ವೆಲ್ ಇಂದ ಹಾಕೋದಕ್ಕೆ ಅದನ್ನು ಸ್ಮಾಲ್ ಇದು ಸ್ಟೋನ್ ಸ್ಲ್ಯಾಬ್ಸ್ ಹೌಸಸ್.
ಬಟ್ ಗೂಗಲ್ ಅರ್ತ್ ಇಮೇಜ್ ಅಲ್ಲಿ ಒಂದು ಅನಿಮಲ್ ಕಾಣ್ತಾ ಇಲ್ಲ.
ಇವರು
ಲ್ಯಾಂಡ್ ಮಾತ್ರ ಇದೆ.
ಸ್ಯಾಟಲೈಟ್ ಪಿಕ್ಚರ್ಗಳು ರಾತ್ರಿ ಹೊತ್ತು ತೆಗಿತಾರೆ ಅವರು.
ರಾತ್ರಿ ಹೊತ್ತು ಪಾಪ ಯಾರು ಇರ್ತಾರ ಅವ್ರ ಮನೆಗೆ ಹೋಗಿರ್ತಾವ.
ನಾವ್ ಇವಾಗ ನೋಡೋದು ಇಸ್ರೇಲ್ ಅವರು ಇವೆಲ್ಲ ರಾತ್ರಿ ಹೊತ್ತು ತೆಗ್ದೆ ನಮ್ಗೆ ಆ ಬೊಂಬಾಟು ತೋರ್ಸೋದವ್ರು. ಹಂಗೆ ಇವ್ ತೆಗ್ಸಿದ.
ಇದು ಹಗಲೊತ್ತೆ ತೆಗ್ದಿರೋದು.
ಕೃಷಿ
ಟೈಮ್ ಸ್ಟಾಂಪ್ ಇದೆ ನೋಡಿ, ಹಗಲೊತ್ತೆ ತೆಗ್ದಿರೋ
ಇದೆ.
It is taken in broad daylight and except one shed and everything else is vacant.
ಇಲ್ಲ 3 ಶೆಡ್ ಇದೆ. ಅದು ಇನ್ನೊಂದೆರಡು ಸ್ಟೋನ್ ಸ್ಲ್ಯಾಬ್ ಇರುವಂತ
ಸ್ಟೋನ್ ಸ್ಲ್ಯಾಬ್ ಇಲ್ವೇ ಇಲ್ಲ, ಬರೀ ಆಸ್ಬೆಸ್ಟಾಸ್ ಶೀಟ್ ಹಾಕಿ 4 ವಾಲ್ ಮಾಡಿದ್ರೆ ಅಷ್ಟೇ. ದಿಸ್ ಇಸ್ ದಿ ಶೆಡ್. ಆಮೇಲೆ ಅನಿಮಲ್ಸ್ ಹ್ಯಾವ್ ಕಮ್ ಇನ್.
ಮತ್ತೆ ಅವು ಶೆಡ್ ಇದ್ದಲ್ಲಿ ಹೋಗ್ತಾವ.
ಇದು ಎಲ್ಲಿ ತಗೊಂಡ್ರಿ
ಹಸುಗಳು? ಹೆಬ್ಬಾಳ ಫಾರ್ಮ್ ನಲ್ಲಿ ತರ್ತೀರಿ, ಚಿಕ್ಕ ಕರುಗಳಿರಲ್ಲಿ ತಂದು ಅದನ್ನ ಸಾಕೋದು. ಅದನ್ನು ಹೌದು, ಅದನ್ನು ರೆಸಿಪ್ಟ್ ಬೇಕಾದ್ರೆ ನಾನು ಹಾಜರು ಮಾಡ್ತೀನಿ. ಇದಾವೆ, ಅದು ಇದೆ. ಆಮೇಲೆ ಕುರಿ ಮೇಕೆಗಳು ಇದು ವಾರ ಮಾರುವಂತದಕ್ಕೆ ಅದಕ್ಕೂ ರೆಸಿಪ್ಟ್ ಇಟ್ಟವ್ರೆ. ಆಮೇಲೆ
ಇನ್ಶೂರೆನ್ಸ್ ಮಾಡಿಸಿರ
ಕೆಲವೊಂದು ಹಸುಗಳಿಗೆ ಇನ್ಸೂರೆನ್ಸ್ ಮಾಡಿ ಆ ಕಿವಿಗೆ ವಾಲೆ ಹಾಕಿದ್ದಾರೆ. ಇದೆ, ಅದ್ರಲ್ಲೂ ತೋರಿಸ್ಬೋದು, ಅದು ಹಾಕಿದ್ದಾರೆ, ಅದು ಇದೆ. ಅಲ್ಲ, ಅದು ಮಾರ್ಕ್ 2-3 ಕಡೆ ಇನ್ಸೂರೆನ್ಸ್ ಅಲ್ಲಿ ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ ಅಂತ ಒಂದು ಮಾರ್ಕ್ ಹಾಕ್ಬಿಡ್ತಾರೆ, ಟ್ಯಾಟೋ ಹಾಕ್ಬಿಡ್ತಾರೆ.
ಕರೆಕ್ಟ್. ಇಲ್ಲಿ ಕಿವಿಗೆ ವಾಲೆ ಇದಕ್ಕೆ, ಇವ್ರ ಕಿವಿಗೆ ಹೂ ಹಾಕ್ಬಿಟ್ರೆ
ಅಲ್ಲ, ಶಿವಪ್ರಾಸಕ್ಕೆ ನಾನು ಹಾಕಕ್ಕಾಗಲ್ಲ.
Yes. Take it on 20th. Produce everything.
I'll produce it. I'll produce
all the receipts
and milk weighing books.
ಉತ್ಪನ್ನ ಆಗೋ ಹಾಲ್ನ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ, ಅದು ಹಾಕ್ತೀರಿ. ಮತ್ತೆ KMF ಅವರು ಡಾಕ್ಟರ್ಸ್ ವಿಸಿಟ್ ಮಾಡ್ತಾರೆ ಅವಾಗ.
ಅದು ವೆಟರ್ನರಿ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ನಿಂದ ಇವ್ನು ಬೈ ಮಾಡಿದ ಬಗ್ಗೆ
ಅದೊಂದು ರಿಸಿಪ್ಟ್ ಕೊಡಿ ಸಾಕು.
ಅವೆಲ್ಲ ಒಂದಷ್ಟು
ಕೃಷಿ ಪುಸ್ತಕ ಇರುತ್ತೆ.
ಕೃಷಿ ಪುಸ್ತಕ ಇಲ್ಲಿ ಗ್ರಾಸ್ ಬೆಳೀತಾ ಇರೋದು, ಅದರಿಂದ ಅದಕ್ಕೆ ಯಾಕಂದ್ರೆ ಮೇವು ಅದೇ ನೇಪಿಯರ್ ಗ್ರಾಸ್, ಪ್ಯಾರಾಗ್ರಾಸ್ ಅಂತ ಹೇಳಿದೆ ಈ ಹಸುಗಳಿಗೆ, ಸೀಮೆ ಹಸುಗಳಿಗೆ, ಅದನ್ನ ಬೆಳೀತಾರೆ. ಅದಕ್ಕೆ ಕೃಷಿ ಪಾಸ್ಬುಕ್ ಎಲ್ಲ ಇದ್ರೆ ನಾನು ಕೇಳಿ ಅದನ್ನು ಹಾಜರು ಮಾಡ್ತೀನಿ.
ಏನಿದೆ ಎಲ್ಲ ಹಾಜರು ಮಾಡಿ.
I'll produce it, Mala. Yes, produce. ಇಲ್ಲಿ ಇವರು ಪ್ರೊಡ್ಯೂಸ್
ಪ್ರೊಟೆಕ್ಷನ್ ಇಂಚಿನ ಹೌಸಿಂಗ್
ಎಲ್ಲ ಅಂಡ್ ಇನ್ಶೂರ್ಡ್ ಅನಿಮಲ್ಸ್ ಇನ್ಶೂರೆನ್ಸ್
ಎಸ್
ಎಲ್ಲ
ಎಸ್ ಐ ಕಲೆಕ್ಟ್ ಇಟ್. ಇದು ಮತ್ತೆ ಇವ್ರು ಹಾಜರು ಮಾಡಿರುವಂತ ಸ್ಕೆಚ್ ನಲ್ಲಿ ನಾನು ಎರಡು ಹೇಳಿದೆ, ಕನೆಕ್ಟಿವಿಟಿ ಮತ್ತೆ ಕಂಟಿನ್ಯೂಟಿ ಇದ್ರೆ ಹೇಳಿ. ಅವರು ಯಾವುದೂ ಇಲ್ಲ, ಸುತ್ತಮುತ್ತಲೆಲ್ಲ ಡೆವಲಪ್ ಆಗೋದು, ರೋಡು ಇಲ್ಲ, ಎಂಥದ್ದು ಇಲ್ಲ. ಇದು ಸಬ್ಸಿಕ್ವೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಬೇರೆ ಯಾರ್ದೋ ಬಿಟ್ಟು ಅದೇ ನಮ್ಮ ಕಡೆ ಹೇಳಂಗೆ ಇದು ಎಮ್ಮೆಗೆ ಜ್ವರ ಬಂದ್ರೆ ಎತ್ತಿ ಇದು ಹಸುಗ್ ಬರೆ ಹೇಳ್ದಂಗೆ ಅವ್ರದ್ದು ಯಾವ್ದೋ ಬಿಟ್ಟು
ಇರೋದು ನಿಮ್ಮ ಹತ್ರ ಮತ್ತೆ
ಅಲ್ಲ ಅವ್ರದ್ದು ಯಾವ್ದೋ ಬಿಟ್ರು ನಮ್ಮನ್ನ ಸೇರಿಸ್ಬಿಟ್ರಿ.
ಕರೆಕ್ಟ್. ನಿಮ್ಮ ಹತ್ರ ಏನಿದೆ ಅದಕ್ಕೆ ಬರೀ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಹಾಗಾಗಿ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್ ಮಲ್ಲ.
ಜಸ್ಟ್ ಆನ್ 20th.
ನಿಮ್ ರೇಷನ್ ಕಾರ್ಡ್ ಇದೆಯಾ?
ರೇಷನ್ ಕಾರ್ಡ್
ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಆಲ್ ಅದರ್ಸ್
ಎಲ್ಲ ಗೊತ್ತಾಗಿ ಹೋಗುತ್ತೆ.
The petitioner shall place on record all the incriminating documents to buttress his submission that that he is carrying out animal husbandry activities in the said property for the last 20 years, more so prior to the cutoff date fixed by the apex court, i.e. on 3/8/2018. Yes. Other dealing sounds, dealing ಮಾಡಿ order.
Scene number 15, M. Shivaprakash.
15 Mala, I represent petition Mala.
ಇದೇನು?
Now there are two survey numbers. One is in Doddabettahalli, another is in
Objections ಹಾಕಿದ್ದೀರಾ?
Eight applications. Of which 5 are approved. 3, my lord, had been sent to Supreme Court, but the pending approval. For your lordship.
ಓ ಇಲ್ಲೇ ಇದೆ.
The objections that they said, committee has already made its recommendation to be.
The other three also can be done.
Probably, my lord,
The report ಅಲ್ಲಿ ಇರಬೇಕು.
report. There are 150 such applications pending approval of the court.
Then we'll post them all on 20th. The report, whichever applications are they looking into it, whatever is to be passed, we'll do it. Yes. 20th.
is one.
Scene number 16, Bharadwaj.
Bring for petitioner in this case, previous time, you know.
Previous
there is
time.
not well,
No grants time. Yes.
the short accommodation unit.
So, yeah, what prayer in?
Fresh matter, my lord.
Fresh matter.
Yes, you know.
ಏನ್ prayer ಏನು?
The short accommodation, you know.
ಅಲ್ಲ ಅಕಾಮಿಡೇಷನ್ ಕೊಡೋಣ.
Petition ಅಲ್ಲಿ prayer ಏನು?
Senior ಗೆ ಹುಷಾರಿರ್ಲಿಲ್ಲ, ಫೈಲ್ಸ್ ಎಲ್ಲ ಕಾರಲ್ಲಿದೆ, ಎನಿ ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್. ಬಂದು ಮಾರ್ನಿಂಗ್ ಬಂದು ವಾಪಸ್ ಹೋಗಿದೆ.
ಮಾರ್ನಿಂಗ್ ಬಂದು ಆಫ್ಟರ್ನೂನ್ ಮನೆಗೆ ಹೋದ್ರು.
ಎಸ್ ಇರೋ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ರೆಕಾರ್ಡ್ ಮಾಡಿದೆ.
ಇಲ್ಲ
ಐಡೆಂಟಿಕಲ್ ಆಗ್ತಾ ಇದೆ.
2 ವಾರಕ್ಕೆ ಒಂದ್ಸರಿ ಒಂದೇ ಸಬ್ಮಿಷನ್.
ಬ್ಯಾಕ್ಟೀರಿಯಾ ರೆಸ್ಟಿಡಿಕೇಟ್ ಅಪ್ಲೈ ಆಗಲ್ಲ, ಕರೆಕ್ಟ್. ಬಟ್ ಅದೇ ಹೇಳಬತ್ತಿ ಸ್ವಲ್ಪ ಬೇರೆ ಗ್ರೌಂಡ್ ಅಲ್ಲ ಹೇಳಿ.
ಯು ಶುಡ್ ಕಮ್ ಅಪ್ ವಿತ್ ಬೆಟರ್ ಗ್ರೌಂಡ್ಸ್.
ಇಲ್ಲ
ಇಲ್ಲೇ ಅದನ್ನೇ ರೆಕಾರ್ಡ್ ಮಾಡಿ.
ಸೇಮ್ ಗ್ರೌಂಡ್ ಹೊಸ ಕಂಡು ಹಿಡಿಬೇಕು.
20th.
ಪ್ಲೀಸ್
ಫೈನಲಿ.
That's petitioners have sought for a writ of mandamus.
Scene number 17, Virupakshaya.
That's in respect of adjacent site holders, my lords, lordship had.
The petitioner, ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ?
There are 6 petitioners. my lord.
The petitioners are before this court seeking the following prayer. The learned counsel for the petitioner submits quae the adjacent landowners. This court has passed the following order. Quote that, madam. The prayer in the case at hand is identical to what was directed to be considered as aforequoted. In that light, we deem it appropriate to dispose the petition directing the respondent BDA to ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಆರ್ಡರ್ ಸೇಮ್.
Great.
Separate order, notice separate.
2541. Number 18. K. Shobha.
Petition. Sought for mandamus to consider the representation. Notice has to be.
Notice first issue, ma.
Actually.
Yes. The same, madam, same drill. Yes. The petitioners are before this court seeking the following prayer. The learned counsel for the petitioner taking this court, so the documents appended to the petition with particular reference to the representation so considered, the learned counsel would submit that BDA has to regularize the property by collecting certain development charges which the BDA has not acceded to in the representation so submitted. The learned counsel for the representation.
Annexure A and B.
The learned counsel, Shiva Prasad Shantan Gowda, representing the BDA, would submit that if reasonable time is granted, representations would be considered and appropriate orders would be passed in accordance with law. In that light, we deem it appropriate to dispose the petition directing the respondent BDA to consider the representations of the petitioners and pass necessary orders in accordance with law and communicate the orders so passed. Any document necessary for the consideration of the representation can be solicited from the hands of the petitioners till the consideration of the representation and communication of the same, consideration of the representation would happen. The parties to maintain status quo the property ordered according to this.
Number 19.
Yeah, for the
Avani Chokshi.
My lord, I'm seeking an interim order, my lord. I'm before this court, my lord. The petitioners are the absolute owners of survey number 12/1, my lord, in Veerasagar village.
Matter.
It's a fresh matter, my lord. In this matter, my lord, I'm challenging the confirmation letter issued by BDA, issued to the respondents number 3 and 4. The background, my lord, is preliminary notification and final notification. My name is reflected. In 2010, behind my back, Tehsildar comes to pass an order removing my name from 12/1 on a representation pertaining to survey number 12/3, which is in fact connected with the respondents number 3 and 4. The AC court, my lord, has granted a stay on that order. But recently we have come to know that BDA has granted a confirmation order in respect of respondents number 3 and 4, whereas I was shown as the party in the preliminary and final notification.
Second prayer can be considered.
Because you have represented to them what you have sought here.
Please, my lord.
They are considering. Because they have called in question the confirmation letter issued to whom is that?
To the respondents number 3 and 4, my lord.
Points 3 and 4.
This one.
Because that may result in prejudice to them. Yes.
Have challenged that confirmation letter, my lord. The representation has already been issued, my lord. So I was.
Notice go to the others.
Please, my lord.
Let notice go to the others.
Please, my lord.
1 and 2, Shiva Prasad Shantan Gowda. 5 AGA, 3 and 4 emergent notice, returnable by the 20th. Status quo the property be maintained till the next day. That structure is there.
My lord, it's 34 guntas, my lord.
There is nothing.
But status quo may be maintained, my lord. In case they act pursuant to the confirmation order, my lord.
No, that cannot be relevant. Only structures idre matra.
Any buildings are existing?
Building structures, anything on the land?
May I take instructions on that if it's passed
Your
over?
client is here asking. No buildings.
My lord, the only thing is that till next date.
Let them come. Let the private respondents appear.
Please, my lord.
Number 21, Srinivas V.
But a petitioner in this case.
Blood.
The site of the petition.
Yes, brother.
Well, the site of the petitioner was regularized pursuant to the order of the Honorable Apex Court, which is a regularization order is at Annexure C, page number 14.
ಏನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮತ್ತೇನ್
ಈಗ RMP ರೋಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಅದರಲ್ಲಿ ಅದು ಕಾಂಪನ್ಸೇಷನ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ, ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟು ಕೊಡ್ತಾ ಇಲ್ಲ. Therefore, I made a representation. Annexure D is the endorsement. ನಾವೇನ್ ನಿಮ್ ಸೈಟ್ ಅಲ್ಲಿ ರೋಡ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ. But my lord, the road has almost approached my property. Almost. 100 feet away ಅಷ್ಟೇ ದೂರದಲ್ಲಿ ಅದು.
ಏನ್ ಎಷ್ಟು ಕಿಲೋಮೀಟರ್ ದೂರ ಇರ್ಬೇಕು ನಿಮ್ಮ ಮನೆಯಿಂದ?
ಅಲ್ಲ ಪಾಸ್ ಆಗುತ್ತೆ. Just if they demolish, they should let them follow the directions of this court into WP 25414 ಅಷ್ಟೇ. This is covered by this thing, my lord. My lord, one judgment of your lordship's Annexure E.
ನಾವು ಏನ್ ನಿಮ್ ಮನೆ ಒಳಗಡೆ ಹೊರಟಿದೆ ರೋಡ್ ಅಂತ ತಿಳ್ಕೊಂಡಿದ್ವಿ.
ಅಲ್ಲ ಒಡೆದು ರೋಡ್ ಮಾಡೋ ಸಾಧ್ಯತೆ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರನೇ
ನೋಡಿ ಎಲ್ಲರೂ ಸಾವಾಗೋ ಸಾಧ್ಯತೆ ಇದೆ. 100 ವರ್ಷ ಆದ್ಮೇಲೆ ಇಲ್ಲರೂ ಹಾಗೆ ಅನ್ಕೊಂಡು ನಾವು ಯಾರನ್ನು ಇದನ್ನ ಮುಟ್ಟು ಮಾಡ್ಬೇಕು. ಏನು ವಾಟ್ ಈಸ್ ಯುವರ್ ರೈಟ್? ಏನ್ ರೈಟ್ ವೈಲೇಟ್ ಆಗಿದೆ? ಎಷ್ಟು ಅಲ್ಲಿ ಇಸ್ಲಾಮಾಬಾದ್ ನಲ್ಲಿ ರೋಡ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಏನ್ ಸಂಬಂಧ?
Allah, if they demolish, my lord, if they happen to demolish, let them follow the directions which your lordship has given at
in anticipation, no direction.
My lord, any point of time, my lord, they have not issued notice also for me to vacate.
ಏನು ನೋಟಿಸ್ ಯಾಕೆ ಕೊಡ್ಬೇಕು? ಅವ್ರು 100 ಫೂಟ್ ದೂರದಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇದನ್ನ ಏನೋ ರೋಡ್. ನಿಮ್ಗೆ ಯಾಕೆ ನೋಟಿಸ್? ನಿಮ್ ಪರ್ಮಿಷನ್ ತಗೋಬೇಕು ರೋಡ್ ಮಾಡುವಾಗ.
No, I'm not on that, my lord. I'm only seeking that if they happen to demolish my property, let them give notice in compliance with the direction
How
of
do you think that they will not give notice and straight away come and demolish the property?
Because it is almost close to my property and road has to pass
100 feet.
ಅವ್ರದ್ದೇನ್ರಿ ಅವ್ರದ್ದೇನ ಬೇಕಾಗಿದೆ ಆ ಬಿಲ್ಡಿಂಗ್? ನೋಡ್ರಿ ಅದು ಬೇಕಾದ್ರೆ ನೀವು ಆ ಬಿಲ್ಡಿಂಗ್ ತಗೋಬಹುದು. ಈಗ ಹೆಂಗಿದ್ರು ಕೇಸ್ ಬಂದಿದೆ.
We are also ready to give, my lord, if they take that, ready for alternate compensation, because in that road it's
ಇದು ಈಗ ಇಟ್ಕೊಳ್ಳೋದಕ್ಕಿಂತ ಅವ್ರಿಗೆ ಕೊಡೋದೇ ಬೆಟರ್.
ಕೊಡೋದೇ ವಾಸಿ.
ನೋಡಿದ್ರೆ ವಿತ್ ದಟ್ ಇಂಟೆನ್ಷನ್ ಹಾಕಿದಂಗಿದೆ. ಏನಾರ ಆಗಿ ಬಿಲ್ಡಿಂಗ್ ಅದನ್ನು ಹೋಗಿದೆ.
Building by itself may collapse ಆಗಿದೆ.
ಅದಕ್ಕೆ ಅವ್ರು ಬೇಗನೆ ಬಂದ್ಬಿಟ್ಟಾರ ಕೋರ್ಟಿಗೆ.
ಬಿಲ್ಡಿಂಗ್ ಬೀಳೋದ್ರೊಳಗೆ
ಕೇಳಿ ಕೆಡವಿರಿ ಅಂತ ಹೇಳಕ್ ಬರ್ತದೆ ಅಂತ. ನೀವು ಸ್ಟೇ ಕೊಡ್ಲಿಲ್ಲ, ಹಂಗಾಗಿ ಕೆಡವ್ಯಾರ ಅವರು.
ಬಿಲ್ಡಿಂಗ್ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ. AGA 1234 ಶಿವಪ್ರಸಾದ್ ಶಾಂತನ್ಗೌಡ. ಲಿಸ್ಟ್ ಆನ್ 20th March. ಅಷ್ಟರಲ್ಲಿ ಬಿದೋಗಿದ್ರೆ ಹೇಳಿ. ಅದು ಹಂಗೆ ಇದೆ, ಡೈಲಾಪಿಟೇಟೆಡ್ ಕಂಡೀಷನ್ ಇದೆ.
ಬಂದಂಗಿದೆ ಅವರು.
Number 23, B group under Jagdishachari.
23.
ಇದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇರ್ಬೇಕು. ಎಸ್ ಶಿವಪ್ರಸಾದ್.
ಕನ್ಸಿಡರ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅನ್ನೋದು
ಅದೇನಾ? ಇದು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆನ್ ರಾಜ್ ಕಾಲ್ವೆ. ಅದೇ ದಟ್ಸ್ ದಿ ಗ್ರೌಂಡ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಇದ್ರಲ್ಲ
ರಾಜ ಕಾಲುವೆ.
ಸೇಮ್ ಇದನ್ನೇ ಅಲ್ಯೂಮಿನಿ ಅಸೋಸಿಯೇಷನ್ ಯೂನಿವರ್ಸಿಟಿ. ಓಕೆ, ಆರ್ಡರ್. No representation. We have the petitioner list on 20th.
Shashank Nagendra.
Petitioners in this matter. So 2018 notification, my lords. Certain portions of my land was regularized. The remaining portion, my lords, I'm seeking regularization.
20th. List enter ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಸರ್.
ಇಲ್ವಾ, ಏನಿಲ್ಲ. 20th.
25.
Vacant.
No, 24, my lords, is portion of it is regularized. 25 is vacant.
List on 20th. 24, 25 both.
Vivek Ulla.
List of dates. Lord, in this, we had not filed the list of dates because they filed objections late and then we have to file a rejoinder.
Yes.
Our copy ಕೊಟ್ರಾ? Even the copy is here. Without. Where is that earlier order? Copies of this. What happened? Only 3 years.
ಇದು ಸರ್ close the committee. No, ಇದು seizure of the records of Gram Panchayat concern. That point. Sir. ಇದು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಇಂದ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಎಸ್ ನೋಡ್ಬೇಕು. ಎಸ್ ವೇರ್ ಆರ್ ದಿ ರಿಪೋರ್ಟ್ಸ್ ಎಲ್ಲ ಹಾಕಿದ್ರು. ಎಲ್ಲಿದೆ? ಯಾರ ಆಫೀಸಲ್ಲಿ? ಹಾ, ಗೆಟ್ ಇಟ್. We will just look into it and then.
So that Mr. Holla also look into.
Yes. List the matter on 20th. The learned AGA submits that in terms of order dated 10/1/2025, all the records are seized and the resolution books are kept with them. The same be produced before this court on the next date of hearing. List the matter on 20th.
What is better reason on the all?
Which Gram Panchayat alla? Yav Gram Panchayat adu?
ಗ್ರಾಮ ಪಂಚಾಯತ್ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರ?
Served anti.
ಸರ್ಡ್ ಅಂತಿದೆ. ಅಲ್ಲ, if you want to appear, you will take.
Have you taken out
ಕಾಸ್ಟ್ ಟೈಟಲ್ ಒಂದು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ.
Served ಅಂತಾನು ಇದೆಲ್ಲ R4. Don't worry.
You have served the notice.
ಅಲ್ಲ ಕಾಸ್ಟ್ ರೇಟ್ ಒಂದು ಹಾಕ್ಬಿಟ್ಟು ಗ್ರಾಮ ಪಂಚಾಯತ್ R4.
Please.
ಕಾಸ್ಟ್ ಟೈಟಲ್ ಒಂದು.
Very well.
ಇದು ಇದಕ್ಕೆ ಅದರಲ್ಲಿ.
Number 27.
My lord, there are as many as 4 writ petitions, my lord, which are clubbed. There are as many as 28 petitioners, my lord, in all the 4 writ petitions. It is my lord, the land which came to be converted during the year 2004. Sale deeds have been executed during the year 2005. There is a approved layout plan, my lord. Now, what the BDA is doing, my
Approved
lord,
layout plan means by whom approved?
my lord, by the panchayat at that particular point of time. And now what they are doing, my lord, they are integrating my layout with the other layout, my lord, which is my lord, formulated by the BDA. Mine is the extreme end. This is the last acquired land, my lord. Beyond that, there is no.
Integration is what is the scheme about?
Not wherever there was vacant area, my lord, they have formed layout, and with the existing roads, they have connected that particular road. And insofar as several constructions which have already come up, they have been regularized. And these 28%, my lord, are intermediate site holders.
The vacant site.
Vacant sites.
There are 4 persons, my lord, who have put up constructions.
The revenue side committee. Can we send them now?
It's a revenue side.
Revenue committee ಮುಂದೆ ಹೋಗ್ಬೇಕು.
ಕಮಿಟಿ ಮುಂದೆ ಹೋಗ್ಬೇಕಾಗ್ತದೆ. ಸ್ವಲ್ಪ ಕರೆಕ್ಟ್ ಮಾಡಕ್ ಹೋಗ್ತದೆ ಅಂತ ಬಟ್ ಆ ಡೇಟ್ ಮುಗಿಯತ್ತೆ ಅಂತ ಆ ಡೇಟ್ ಬೇಕಾದ್ರೆ ಇದು ಹಂಗ್ ಮಾಡೋ ಬದಲಿಗೆ ಕಮಿಟಿ ಟರ್ನಲ್ಲಿ ಇಡ್ಬೇಕು ಈಗ
ಆಮೇಲೆ
ಒಂದು ಡೇಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಲ್ಲ ಯಾವುದು ಕಮಿಟಿ ಮಾಡೋದು ಕಷ್ಟ ಅದೇ ಕಮಿಟಿ ತಾನೇ ಅದು
ಸೇಮ್ ಕಮಿಟಿ ಈಗ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ರಲ್ಲ ಅದೇ
ಎಕ್ಸ್ಟೆಂಡ್
committee.
ಮಾಡಿದ್ವಲ್ಲ 4 months
With respect to the passing of the order of the.
anyway now we have extended tenure of the committee ಹೌದಾ ವಿದಿನ್ ದಟ್ ಅವ್ರ ವಿದಿನ್ ನೆಕ್ಸ್ಟ್ ವಿನ್ 1 week ನಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡ್ಲಿ ಆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕಮಿಟಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಷ್ಟೇ ಅಷ್ಟೇ ಮಾಡಬಹುದು
That committee is constituted for that purpose only.
Not, there is one more submission, not. They can collect not the layout charges and whatever is that.
That the committee will decide.
ಅವ್ರ ಮುಂದೆ ಹೇಳಿ ಇದನ್ನೆಲ್ಲ ಅದ್ರ ಸಲುವಾಗಿ ಕಮಿಟಿ ಇದೆ ನಾವು ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಆ ರೀತಿ ಕಮಿಟಿ ಮುಂದೆ ಹೋಗ್ಬೇಕು ಬಟ್
We'll pass that order then. Yes. Good. All these cases. The WP 24125 was thoroughly. The petitioners, in all these cases put together are said to be 28 in number. All these petitioners are holders of revenue sites which are lying vacant. The learned counsel,
There are 4 constructions in respect of 4 of the properties. 24 is vacant.
most of which are lying vacant. The learned counsel for the petitioner submits in 4 of the properties, in 4 of the properties of the 4 of the petitioners, there are certain constructions put up. Barring this, the lands are largely vacant. The submission of the learned counsel for the petitioner is that the layout to be formed by these petitioners are said to be integrated into the layout that is formed by the BDA. And it is at the end of the
Last acquired land. This is the last of the acquired land.
and it is the last of the acquired lands. In that light, the last of the acquired lands. Since the petitioners are revenue site holders, the petitioners have to approach the VG Bopaya committee committee so constituted to consider the grievances of the revenue site holders like the petitioners. In that light, we deem it appropriate to direct the petitioners to submit their application/representation with all the grievances that they have projected before this court to be put forth before the committee. And if the representation/application is filed before the committee, as observed herein above, within 1 week from today, 1 week from the date of receipt of the copy of the order, the committee shall consider the grievances of the petitioners like it considers the others and pass necessary orders drop appropriate reports as necessary in law.
But insofar as constructions is concerned, this honorable court has already not granted interim order.
ಇಲ್ಲ that decision ಅಷ್ಟೇ.
Till the decision is taken by the committee and communicated to the petitioners, structures, if any, in the subject property, there shall be status quo maintained by the parties with regard to the structures, if any, in the property, ordered accordingly. JK, the 27.12, 4 petitions.
Yes.
Twenty-eight, Rohan Osmat.
Yes.
Learned counsel Shiva Prasad Shantangowda seeks 2 weeks time to file statement of objections. Less the matter on 20th. Both. 29, 28, 29, 30. All 3, yes. Yes. Spring Valley Culture Associations, there is one more. What is your grievance?
29.
29, 20th.
Order maybe.
That will be.
Thirty-one, Deepak Shetty.
Take some time to find my objections.
Learned counsel Shiva Prasad Shantangowda seeks 2 weeks time to file statement. Interim order will continue. Shobha. Representation, huh?
32, Shobha.
Same.
representation, same.
ಮುಂಚಿಂದ ಯಾವ್ದು?
Similar level.
Serial number?
Serial number 18.
18.
18.
18. ನೀವೇ ತಗೊಂಡಿದ್ದು. 18 ಅವ್ರು previous same order. Consider representation after same order.
Yes.
ಇಲ್ಲೇ ಮಾಡ್ಬಿಡ್ರಿ.
Will you make one submission? I'm very sorry, friends. Serial number 4. It's Lordships had indicated it's a road matter. I just sought instructions, minutes. The instruction is that the road passes through, but only about 6 feet of the constructed portion the house goes, minutes. It doesn't go through the entire property.
So ಅದು dispose ಮಾಡಬಾರ್ದಾ?
I'll file my objections to the status report if anything.
ಆಯ್ತು ಎಜೆಕ್ಟ್.
Serial number 4.
ಅವ್ರು ಬಂದಿದ್ದಾರಲ್ಲ. Serial number 4 dispose ಅಂತ ತೋರಿಸಿದೆ. Dispose ಅಂತ ಬೇಡ, list on 20th ಅಂತ ಮಾಡಿ.
Please. Grateful. ಇಲ್ಲ ನೋಡಿ. 1.55.
1.55 ಚದರ ಮೀಟರ್.
ಇಲ್ಲ ಇದು
Please,